Well, good morning and thank you for joining us on the third day of the trial of former officer Christopher Schurr. And he was charged with second-degree murder for killing Patrick Lyoya. We have crews live across downtown Grand Rapids, both inside and outside the courtroom, ready to bring you updates as they happen. 13 on your side's Kylie Lichter and Riley Mack are inside the courthouse viewing the trial live and updating our live blog on 13onyourside.com. We also want to bring your attention to something we've been talking about every single day. We are delivering you the live stream of the trial on a court-mandated 30-minute delay. So 13 on Your Side was instructed by the judge to stream the trial on this delay so that any sensitive information that is not supposed to be broadcasted, like personal details, can be redacted before it is put on air. There are no other modifications that we are doing to deliver you this trial, and we will remind you of this delay throughout the day. And I want to bring in Tanner. Emily, we are on the third day of this trial. Things got a little heated yesterday.
Yeah, definitely seeing some contention, some back and forth between the prosecution and defense in terms of exactly what can be presented in this trial.
Yeah, a couple of the notable objections that we heard, right, were from, of course, the officer-created jeopardy theory that we heard a bunch about from Seth Stoughton. We also heard a lot about the deadly force warning requirement and, of course, the scope of expert testimony. Of course, two of those three witnesses, those expert witnesses that were brought on to the witness stand yesterday, not the taser expert, but the two at the very end of the day, those that testimony was actually very contentious and did get very heated, like you said, between the prosecution and defense.
Yeah, we're gonna get to those testimonies in a second, but I want to start with the taser expert. That is kind of the crux of this whole entire trial. We're gonna be hearing a lot about the taser. At times, the other two experts were actually questioning whether or not they can even speak on taser use. But starting with that first person, I think what we really saw is the fine details that both the prosecution and the defense are really going to try to hit on when it comes to the use of taser.
Yeah, it has been so interesting because, of course, this is a case surrounding someone who was shot in the head, with a gun, not surrounding that taser, but yet such a huge part or a huge focus being on this taser, again, in terms of the prosecution saying, did Christopher Schurr have a reason to truly fear for his life in that situation? And the defense saying because of that taser and because the video potentially showing that Patrick Lyoya was going for that taser, did that change the way Christopher Schurr felt in terms of being in danger or feeling that there was a threat to his life? So a lot of focus, hours of time being spent on talking about this taser.
Yeah, a lot of the questioning we heard was from Chris Becker to Brian Childs, which is the expert from Axon, which is the weapons manufacturer that made the taser. Brian also being the same person that analyzed the taser after the shooting. And I have a couple of notes here that I just want to rattle off here. Of course, the prosecution arguing that after Schurr, the officer in question here, discharged his taser twice during the struggle with Patrick Lyoya, that device could only be used in what's called the drive stun mode, which does cause pain, but not something called neuromuscular incapacitation, or that NMI that we heard a lot about in the trial. Basically, the questions that Becker was asking was to kind of paint this picture that this taser was not going to be a threat to Schurr at the time of that fatal shot. And so that's really what the prosecution's argument on the taser here hinges on, is that this taser specifically would not have been a threat to the officer at the time.
And I think what's something interesting about the questioning from both the prosecution and the defense is how they were asking questions. When the prosecution was asking about the use of the taser, a lot of the things that they were trying to get across, like you said, Tanner, was how this taser wouldn't have made great bodily harm. So asking what was the most fatal way someone could die from a taser, and they said it's if someone was tased at a high elevation and fell, that was actually the most dangerous way someone could die. He also said that the taser does not leave long-lasting impacts, and that being hit, you had to be hit by certain areas on your body to create great bodily harm. But then on the opposite side, when you heard the defense talk, they got very specific about ways you could be severely harmed and even incapacitated from a taser. So it was interesting to see how they both were trying to basically place their case with their questioning.
Yeah, even in opening statements, you could see just how much both sides were going to be relying on this, because again, it comes down to the prosecution saying, did Christopher Schurr truly have a right to fear for his life in this way? The prosecution arguing, you know, if we're pulling the taser into this argument, that's not enough. But the defense saying, okay, well, even if the manufacturers are saying this is not something that can cause fatal injuries, does that change if the person handling this taser hasn't had the proper training to use it correctly? And that even came back up when the prosecution, Chris Becker, again wanted to question this expert about, well, how do we know that Patrick Lyoya would then know how to properly use this taser at all in terms of taking the safety off? Do you pull the trigger? Which button do you use in order to activate the taser? So that was part of the hours-long conversation here.
Yeah, the defense also trying to create that doubt that the taser could still be a lethal weapon and still could have posed a threat to Officer Schurr there. Again, you kind of see how both sides, I don't want to use the word spin, but you can see how both sides are using the questions to their advantage here when they're trying to argue just about this taser, which again has become a really central argument.
Yeah, but that too has just been part of this slow crawl,
Yep.
as I've been describing it, to get this information out, because again, day one, we saw what, I think 8 witnesses
Yeah.
Yeah.
called, and so we were expecting to really kind of get into the meat of how would the prosecution piece together this puzzle. And then day 2 going a lot slower, only seeing 3 witnesses, some of them for hours at a time. And again, just feeling like, all right, what were we supposed to get out of that line of questioning?
Yeah, definitely. To give everyone a better idea of what we're talking about, take a listen to what we saw yesterday.
Yeah, tell the jury what this is.
This is a Taser 7 energy weapon.
And tell it what, Taser 7, why is it Taser 7? Is there different versions of Taser then?
Yeah, there's several models over time, and Taser 7 was our 7th iteration of the design.
So what Taser are you on now?
Right now we're on Taser 10.
Okay, so this is an older version. When did this version kind of go into use, if you will?
This one was released in 2018.
Can you, maybe if you can show the jury in terms of what, describe some of the things on, you know, it kind of looks like a gun. Is it a gun?
It is not a gun. It is not a firearm. It is a handheld device, the shape of a gun for the look and feel of it. It has a grip. This part is where the battery pack will go in. It has rechargeable batteries. Has a safety switch, which is ambidextrous, so it can be used left-handed or right-handed. And then a trigger switch here. And then also on each side, there's a button on the side that is called the arc switch. I'll get into more technical what each one does. We also have cartridges that install in here. There's 2 cartridges. Each cartridge has 2 probes. So there's 4 probes total. What else? We have cartridge release. That's essentially it. There's a high voltage section, and then pretty much the microprocessor and the smart section of it.
Maybe talk a little bit more. You talk about a safety switch. The safety switch, it's on there. What is that designed to do?
So the safety switch arms the weapon. So it turns it on, powers it up, but it does not activate the high voltage yet. So it just puts it at a ready. If the trigger is pulled or the arc switch is pressed, then it will activate. Also with the safety switch, laser aiming will turn on, and a flashlight if it's configured.
Now, what is a taser designed for? What was the purpose of a taser?
The overall purpose of a taser weapon is to inject electrical signal into the human body or animal and override the central nervous system and tell the muscles to contract. So when activated, it produces high voltage pulsing, and that pulsing, if delivered to the body, will be received by the muscles, and all of your muscles, all movement that you make is done by electrical signals from your brain. And so what this does is it puts an electrical signal on the muscles, and the muscles say, oh, I need to contract. So they contract and then release. But the weapon does it 22 times per second, so it causes a rigid muscle lockup if you have enough muscle receiving that signal.
I'm going to go and maybe help a little visual in terms of how this works. I'm going to play what's been stipulated to as Exhibit 22 of the people, Your Honor. Dim lights. And you've seen this your promotional video for the Taser 7?
Yes.
And you recognize it?
Yes.
I'll go through it and ask some questions. That was a promotional video, that's why you got that kind of cool music and everything, right?
Yes.
Now going back a little bit, I think there's some things that the jury may be interested in. Can you describe, when you talk about these cartridges, you got the probes, if you will, can you tell the jury what they're looking at here?
So what we're looking at here is the probes coming out of the cartridge. How that works is inside the cartridge there's a nitrogen gas capsule, excuse me, about 2,500 psi of nitrogen gas. When triggered, there is an electrical signal sent to a primer, which that explodes internally, and that creates pressure and pushes the gas capsule into a puncture pin. That ejects the air, the nitrogen gas, out of the capsule, going down these channels, and pushes those probes out. So it's not gunpowder as a typical firearm. The probes are launched via compressed air. The wire in the probe, the wire is actually wound inside the probes. So the metal pieces there, the wire's coming out of them spooled inside them. And it's tethered to the cartridge, which is electrically connected to the weapon. And then the wire is attached to the probe tip.
So in terms of these probe tips, that's what's got to go into the person, if you will. Is that a fair statement?
The design is for it to go in, but the whole point of the high voltage of a taser weapon is to be able to arc to the skin, to jump through the air to the skin if the probe is close enough. So even if it doesn't penetrate the skin, it can still make a connection.
Right around here, they talk about cross connect. Can you describe what this cross connect is? It looks like a probe is missed, but another one is hit. Can you describe what cross connect is and what this video part of the video shows?
Yes, so adaptive cross-connect is a technology. Previous versions of the weapon, the X2 mainly, had 2 cartridges, but it had a chance to cross-connect, but it was pretty much due to the laws of physics. It could happen or couldn't happen depending on what's going on, where the wires are, how far the probes are from the skin, stuff like that. With the Taser 7, we designed adaptive cross-connect that forced that cross-connect to happen. So if a probe misses, like in the image here at 34 seconds, one of those probes missed, but we're able to cross-connect from one cartridge. Well, let me back up. Each cartridge, say you deploy one cartridge, the top probe is the plus of the circuit, and the bottom probe is the minus of the circuit. You always have to have a connection between plus and minus in order for electric current to flow. With this, we allowed, say for instance, if you missed with the bottom probe of the second cartridge, the top probe of the second cartridge would connect to the bottom probe of the first cartridge. So that's cross connect.
Now here, the Taser 7, and once again, correct me if I'm wrong, the Taser 7 had something about a close range cartridge versus a longer range cartridge. Could you tell the jury what you mean by that?
Yeah.
We're at .53 now, and you're talking about the close range cartridge.
So with Taser 7, one thing new that we added was 2 different types of cartridge. On each Taser cartridge, the top probe comes out straight. The bottom probe comes out at a downward angle. The reason for that is, I mentioned before with the Taser technology, in order to cause a reaction from the muscles, you need enough muscle to receive that signal. So you need enough muscle mass between those 2 probes. So you need distance on the body. And so with the bottom probe coming out, or top probe coming out straight, and the bottom probe coming out at a downward angle, the further back you are, the more spread you have between those probes. That can cause a problem because if you are too far away, then the bottom probe might hit the ground before it reaches the target. So we designed 2 different cartridges, one with a 3.5 degree angle, and that is for long range. And then we have a close quarter cartridge that has a 12 degree angle on the bottom probe, and that is pretty much at 4 feet. In general, your general rule is you need about 12 inches of spread between the probes. There are caveats there on location on the body because it's really about muscle mass, how much. But in general, you want 12 inches. So effective at 4 feet means at 4 feet, you'll get about the 12 inches of spread between those probes.
So that's kind of minimum distance for the close range cartridge that's ideal for appropriate NMI.
Yeah, to create that ideal situation for NMI, you'd need to be at 4 feet.
And then so it can go this side. I think there's one. We're talking about 111 now. It can go up to 12 feet. Is that the maximum distance, if you will, for the Taser 7?
For Taser 7, actually, the maximum range is 25 feet.
Okay, so this is even a little bit closer than 25 feet. It can go further back.
Correct.
The weapon, is it weapon designed to be with this distance then? In terms of that's the ideal way you should use it?
Ideally, we create it so that an officer can create distance between him and the subject. But we made the close quarter, so if you can't make distance, then...
You know, like you kind of just said, Tanner, he did a really good job of really explaining how a taser is used, the distance you have to be from someone, you know, reloading and how you can use it just for police, at least on a daily basis. So it was interesting to hear.
Well, not only that, you know, he did also a really nice job of explaining why a taser wouldn't use or wouldn't work rather in the case of, you know, the taser being shot into the ground. We heard a lot about that. There were a lot of questions about that second shot there that he says went into the ground and with the wet grass, it probably short-circuited the taser. But again, later clarifying it would not have impacted the effectiveness of the weapon when he was examined on the cross-examination there. So very interesting testimony on the taser. Of course, that man that we heard from, Brian Childs from Axon, is the guy who investigated the taser after the shooting happened in the days and weeks that happened after that. So this is the main guy that basically wrote the report on what happened with that taser.
It was also interesting because it was surrounding the taser that I do believe we heard a question from one of the jurors. We also heard a question from the judge first. I think it was her question wanting to know, does the taser, the safety, have to be taken off each time you're activating the taser? And I believe the expert answered that no, once the safety is off, then you can continue to use it until the safety is placed back on. So that was a question, I believe, from the judge. She then shared a question from one of the jurors, which I think was, they showed a picture of the taser in use from that day, and there was a lot of dirt and debris on the taser. I think one of the jurors wanted to know, would that have any impact on the taser's function? And I believe the expert witness answered that no, that would not. Electricity can travel through dirt even if it's wet.
Yep, you're right. But that is exactly when that point of clarification came up, which is a good point of clarification too, just so we kind of get an ideal picture of how the taser can work and the effectiveness of it and how that all works. Something else that I want to point out is when the jury members asked that question, we heard the mic go mute during that time. We also saw the attorneys come up for a sidebar. I would assume that they were trying to figure out, if there were any objections to that question. But again, it was a very interesting process to see that happen in real time in the first time a jury member has asked a question in this trial.
I think also what's interesting is that he did confirm that no one was hit by the taser on both deployments. I think that a lot of people were questioning when, you hear a taser, you hear a pop, there's a lot of sounds of no, stop. I think people were wondering, was anyone hit? Was Leoya hit at the time? And he was able to confirm to us that no one was hit by the taser.
Yeah, and even though, the taser was registering that data of like sending out those shocks, and he described how the taser does keep track of that data and how it's so many shocks per second that it emits from that first and second deployment. And when that taser was emitting that shock, how it was going into the ground, and it was registering as something, but he was able to tell by the data it was the ground. I thought that was very interesting in how they were able to tell that data.
I did as well. It's almost like these tasers have a little black box inside that they're then able to analyze after the fact and say, well, exactly how was this taser used? Was there any impact? I know you mentioned they talked about the prongs, at least on one end of the taser. Some of them were bent, and the expert then said that's how he knew that it probably hit the ground, because if it hits flesh, that wouldn't be strong enough to bend them. So it is interesting that they're able to go back and analyze these tasers and tell us this is exactly how it was used and what happened when it was used.
Something else I want to bring up is that during his testimony, again, he was on the stand for about an hour and 40 minutes yesterday morning. There was only one objection in that entire hour, 40 minutes. It was an objection from the defense asking Childs to interpret it was the prosecution objecting here. Defense had asked Childs to interpret a video and kind of walk them through, and then the prosecution objected to that question. The judge allowed the question only as a rephrased question. But again, that was the first objection and a wide swath of objections that came in the second and third people to take the stand there.
Yeah, I mean, right off the bat, when his name is Seth Stoughton, he was the use of force, one of two use of force experts for the prosecution. Even before he took the stand and was able to start being asked questions, the defense said that they objected to him, saying that they didn't believe that his answering would be relevant to the case, and that there were some issues of double jeopardy with him speaking as well. And I thought that was interesting because you hear the judge and the prosecution both say, this person has been approved. This witness, we've already gone through this motion. He has been approved, and you can see the defense. And that's not the first time that they try to get him off the stand. They did it 2 or 3 times, actually, saying that they just feel like at one point they said that his answers could be dangerous to the jurors of what he could possibly say.
Yeah, again, he was testifying on this idea of officer-created jeopardy, right? It's arguing, basically, the defense objected because they were arguing whether that was relevant or not to Michigan's self-defense laws, and it could confuse the jurors. Again, the jurors are hearing all of this, and they need to hear it in a way that they understand and comprehend. So the defense making that objection because, obviously, in their words, that could confuse the court and the jury.
And that goes back to sort of this slow crawl process, because as prosecutors first started questioning this expert witness, you could tell that their first, goal really was to show that this witness in their eyes is credible. I believe they pointed out the many various other trials that this witness has testified in before, just to, again, from the prosecution's perspective, show this is a credible witness and you can trust the theory that this witness is using to make this testimony.
And this is in And what we're talking about, that was what, an hour, hour and a half? I mean, they hadn't even
Yeah.
gotten to the questioning before they were going back and forth and doing examination with this witness. It was very interesting to see. That was the person we saw most today.
Yep.
And even in his responses, he brought up the use of force law here in Michigan. He commented on that, saying, I don't know the use of force law well. I'm not going to give my legal expertise on that. I'm just going to answer
Stick
the
to what I
question
know.
as a use of force expert. And I thought that was very interesting to hear his response. That it wasn't a pushback to many questions, but definitely a response of clarity that I think actually helped the jurors understand how he was going to answer questions.
Yeah, how he's going to answer questions, but also how he can comment on the grand scheme of things across the country, not just in Michigan. Another thing that I think kind of goes down the same line is where the defense argued with the GRPD policy only required a directive. So, for example, like drop the taser, not a specific warning like I'll shoot. The prosecution countering that with general police standards requiring clear warnings. The judge allowed Stoughton to actually testify on the GRPD policy because despite GRPD's policy at the time, it was a testimony about industry standards at the time. So I thought that was very interesting the judge allowed that. And again, something that the jury will now have to sit with as they weigh what happens here in the future.
And that exchange got very heated because the defense was saying, hey, that's not the most up-to-date compliance for police. Prosecution coming back and saying, but that at that time, that's what they were following.
Yeah.
So you can just see how heated things got in court because they were trying to get as specific as possible with each question.
Yeah, making you not envy the jury at all,
Right.
because I myself am already just trying to process all of the information they've been given. They will not have an easy job.
Well, it's
Yeah.
10 witnesses now, right? So we're on our 10th witness. They've heard from many character witnesses. We've now heard from 3 expert witnesses. A lot of that has got to get confusing when we get into the grand scheme of things and the jury's trying to weigh all of that before we even get into the 50-some people that could be called on the defense side. And think about that. You're going to hear from 50 people over the course of a trial that the judge expects to last maybe 2 to 3 weeks. I agree with your point. I think that the jury has a lot to wrestle with and will continue to have a lot to wrestle with here in the coming weeks.
Most definitely. We have that sound booted up from this second witness. Let's take a listen.
The prosecutor, Your Honor, is asking you to create use of force law unknown to Officer Schurr. There's not a single Michigan court that has accepted this theory in a murder case. Your Honor, the U.S. Supreme Court in Barnes v. Felix declined to consider that it's not a theory. It's still yet to be litigated. Professor Stoughton acknowledged that it's an unsettled area of law. This court should not be the first in Michigan to accept Professor Stoughton's theory. There are citations to law review articles and civil cases. This is not the context in which this applies. It's not reliable because it has no application, especially in the case alleging self-defense. It doesn't account for intermediate cause. It doesn't account for the standard negligence versus recklessness. And the opinions here are based on negligence. He acted unreasonable with a foot pursuit. He acted unreasonable because he stood too close to him with a taser. Therefore, he can't argue self-defense. That's the suggestion by putting that information in front of the jury, that he's created this unjustified risk that he is foreclosed from defending himself, no matter what happens. That's the problem, and you're going to confuse the jury completely by letting Professor Stoughton give opinions about things that based on this theory. Your Honor, it's absolutely dangerous if we're going to ask Officer Schurr that once you do a foot pursuit and you're negligent, that you can no longer defend yourself or others. That is what this theory says. That is what we're going to be asking the jury to consider, whether or not this has any relevance whatsoever. This is a murder case. The issue is whether or not he intended to kill somebody, and the issue is also whether he was justified in doing so. We ask this court not to accept this theory. It has no bearing whatsoever on this matter. There are other areas, as in the expert's report, that they can opine upon that actually might matter. But the theories of the foot pursuit and standing too close are not reliable in the context of this case. Thank you, Your Honor.
Well, as I previously stated, I wanted to hear from the witness regarding his opinion because under 702, MRE 702, a witness qualified, who's qualified as an expert by knowledge, skill, experience, training, etc., may testify in the form of an opinion if the proponent, which would be the people, demonstrates to the court that it's more likely than not that his opinion would help the trier of fact to understand the evidence or determine the fact of the issue, that testimony is based on sufficient facts or data, and it is a product of reliable principles and methods, and that the opinion reflects a reliable application of the principles and methods to the facts of the case. Here, there's no dispute that the witness, Mr. Stoughton, is qualified to be an expert as he has the requisite knowledge, skill, experience, and education. Again, the issue is whether or not his testimony would be the product of reliable principles and whether his opinion reflects a reliable application of the principles to the facts of this case. As he testified to, well, first I'll say here, part of what the jury has to determine, they have to take into account all of the circumstances in the case, not simply the moment of the shooting, but all of the circumstances. And there's been a lot of evidence and testimony surrounding what the circumstances were at the time that this incident occurred. In considering that, after hearing from Mr. Stoughton, he clearly testified that officer created jeopardy, that particular theory is a term of art, and that term of art, which was coined in the 90s, not by him, but by someone else, that particular term of art, officer created jeopardy, is regarding tactical decisions made by an officer, which is subsumed within generally accepted police practices. So because I believe that he has testified sufficiently that he has applied the facts in this case to the generally accepted principles and practices, which apparently are nationally recognized and nationally accepted, I believe that because officer created jeopardy in and of itself is not a particular method, rather a theory, again, subsumed within those accepted police practices. For those reasons, I am going to allow him to testify as an expert in use of force and generally accepted police principles and practices, because I believe that he's testified that he does, again, possess the requisite knowledge and training and education, and that his testimony would be relevant and could help the jurors understand the evidence in the case.
Very interesting.
Yeah.
I think what it comes down to is what she said there at the very end, the judge, Judge Mims, saying use of force expert. You know, she's talking about the practices that he is going to testify to. She says, in her own words, that these are widely accepted practices across the nation, and for that reason, he is an expert in use of force. So I think that's where she rules in favor of him taking the stand ultimately, just based off of that soundbite, what I'm hearing.
And as we go through his testimony, you can actually hear him kind of confirm that. You know, when he's asked a question by the defense or prosecution, he says, how do you want me to answer this? Do you want me to answer this in a legal way or as a use of force expert way? And he says, and if you want me to answer in a legal way, I can't do that on this stand. So it's interesting to see how he even reiterates that point.
Yeah, and he knows what he's doing, right? Because he is a lawyer, too. He said that he was a police officer down in Florida for many, many years, and now is a non-practicing attorney. I forget what state that he's associated with the bar there, but he is an attorney. He knows what he's talking about, and also has been practicing all of these things that he has knowledge on. Not only that, but gathering the facts on that and also practicing it in an academic sense since then. So, I mean, it looks like that is what the judge has ruled on that, is being a use of force expert.
And I know that we've got the other side of the argument as to whether or not this expert should have been able to testify, but I want to quickly go back to the point that we made on day one, that we heard from Andrew Rodenhouse, the attorney and expert that we've been talking to about this case, who hasn't been working with the case but has been helping to guide us through this process, who said, again, it will come down to the law and the instructions given to the jury by the judge. So it's important to keep in mind that these expert witnesses that are offering testimony, that will be something that they'll be able to use in conjunction with making their decision, but it should not be the basis of their decision. It is going to go back to the law and those jury instructions.
And speaking of the judge, we are on that 3-minute delay, but I'm looking at our live stream out here, and it looks like the judge has seated finally in the courtroom. Again, you won't see that for the next 30 minutes, but you know, day 3 is about to get underway. Something I think also that we haven't talked about is he really starts to get into the meat and potatoes of why he thinks Schurr did not do what he was supposed to do. He talks about the actions that he specifically talks about, the police tactics that Schurr did that day that were not in protocol, or as he says, poor tactics. One of the biggest things is that he said, when on the video, when you see Schurr come toward Leoya and Leoya starts to run away from the car, he says the moment that he curves around the car and starts to run away, that in that moment, Schurr, in his opinion, Schurr should have stopped and let him run away, because if you remember, there was a passenger still in the car.
Yeah.
And he says that good police tactic is that if there's 2 people at a situation and someone is in the car, someone is running away, in his mind, you let that person run away, you talk to the other person, get their information, and you arrest that person that's ran away later on in the day.
Yeah, and again, this goes back to what he was specifically testifying on. The expert here, Seth Stoughton, that when he started that foot chase, that is what he calls, and I'm talking about Seth Stoughton, officer-created jeopardy. And I've wrote a couple of notes down here. It refers to a situation, officer-created jeopardy does, of a situation where law enforcement officers unnecessarily or unjustifiably escalate encounters, creating or increasing risks that lead to the use of force, particularly deadly force, in which we saw in deadly force, of course, being the end result of the situation here. Now, again, his testimony just offering some light as to what the officer-created jeopardy could be in this situation, and ultimately his testimony, that was what the defense was objecting to, was allowing him to be an expert in that officer-created jeopardy.
Yeah, and this is what it all comes down to. What were the steps that Christopher Schurr took in that moment on that day during that stop, that traffic stop, and did he make the right decisions regardless of what the outcome was that day, which we now know is the shooting death of Patrick Leoya. So that's what these expert witnesses are testifying to. We heard from them that they're not saying everything Schurr did that day was incorrect, but according to these witnesses, there were steps that he took, they say, went in the wrong direction.
And obviously, we're not legal experts, but we do have a legal expert joining us now, Andrew Rodenhouse. You heard him yesterday. He joins us again today. Andrew, thank you so much for joining us.
Well, good morning. Thanks for having me.
We want to first just start right off the bat. What is your reaction? We talked to you around the lunch break. What is your reaction for the rest of the day in terms of day 2?
Well, to put it bluntly, I was more than flabbergasted that what this person was testifying to, Professor Stoughton. I was deeply troubled by the fact that this was allowed. I spoke with a number of my fellow colleagues last night about their take on it, and their take was the same as mine, that this is a criminal case in the state of Michigan. There's nothing in the jury instructions that's going to talk anything about officer-created jeopardy, or that you got to follow the standards, or you got to issue a warning. I mean, imagine having to issue a warning if somebody's stabbing you. You say, "Stop stabbing me, or I'm going to shoot." That it just, to me, is I'm just stunned that this was allowed. I thought the defense did a very good job trying to counter it, even though it was allowed. I presume they've got experts that are going to testify that just how ridiculous that requirement is, because it would be more appropriate in a civil case when it's about money damages, but not in a criminal case when it's about whether or not Officer Schurr acted with justification or not. And that brings me to why. So there's a specific rule of evidence that applies to this, and the rule says that experts are not allowed to testify to the ultimate issue. The ultimate issue being, is this with or without with justification? And what was allowed to happen was that the expert was allowed to testify that in his expert opinion, because he didn't think that Officer Schurr followed through the police requirements or the police standards, that was what made it without justification, and it was narrowed to that. But that's, again, that's confusing for a jury. That's two different things. And so I was just kind of stunned by it. You know, this whole thing is like, if a taser isn't deadly, then why are these guys fighting so hard over it? Why are they so hard to control it? That doesn't even make sense. I mean, the Childs testified. He's the guy. He's literally the guy from Axon, and he testified that that specific taser, like how deadly it still was. And we've got this guy who's never inspected the taser coming in and saying, "Well, tasers aren't deadly." So, well, then why is it still a felony in Michigan to possess one? You know, so I was kind of stunned by the whole thing. That's my my gut reaction.
And I have to ask, you know, you said something about the law in regards to this case, but the jurors don't know that. The jurors don't know the difference of use of force law in Michigan compared to someone else. So does it hurt or help to have someone like this come on the stand and the jurors having to make their decision?
Well, I think it's helpful to have an expert in use of force, but I think that their testimony needs to be narrow to what they're qualified to testify about. And so in this particular case, because it's simply a question of whether or not somebody is justified, to have them come in and testify to all the police stuff, the officer created jeopardy, I think is what they said it was, or what he said it was. There's no law in Michigan about that. This is a straight up question of whether or not an individual is justified or not justified, and it doesn't really matter whether or not you're a police officer or you're not a police officer, because there's no distinction in Michigan law about whether or not you're a police officer or not a police officer. The same standard applies.
Well, Andrew, I'm curious, you know, when we see these different trials, not just this one, but sometimes you hear people say you can find an expert to testify to anything. And so I'm wondering, can you shed some light on what is that process and what are the qualifications in order for the prosecution or defense to get someone approved to testify as an expert?
Well, so to be qualified as an expert, it has to be your relevant training experience. You don't necessarily have to have like a degree in something. It's like Mr. Childs. He said that, I recall from his testimony, that his background wasn't so much in education, it was hands-on. I mean, this guy just worked with these things for so long that he is qualified as an expert to testify in those. And so it's based on your training and experience. I mean, a high school physics teacher could testify to a lot of stuff in court as an expert, just like on accidents, like how fast a car's going. Like you can calculate something. And so you don't have to be necessarily hold yourself out as a quote unquote paid expert in order to be an expert. And generally speaking, you can find experts for a lot of different things. And it's the court that's supposed to be the gatekeeper. And that goes back to why the defense team was fighting so hard to have this expert come in and testify to some of his conclusions. And it's simply because from their perspective, it's not appropriate in this trial. And the judge allowed it. So that's the world we're living in.
I have a question just about the industry standards that Stoughton was able to testify on yesterday. And I'm assuming you just talked about it right there. I'm going to assume that you're going to kind of go along the same lines as you did your previous answer there. But when he was testifying about the GRPD policy requiring a directive or not a specific warning here, you know, would that be your same opinion, that he should never have been allowed to testify about the national practices versus the GRPD policy at the time?
Yeah, because this case isn't the trial's not about what policies are to be followed. I mean, that's where it would go in a civil case, and quite frankly, in a civil case, my opinion is that it would be more appropriate. to have him testify. But in a criminal case, that's not the issue. The issue is whether or not Officer Schurr feared for his life or for the life of others. I think it's just his life, or having great bodily harm. And so to have this person come in and talk about, well, he should have stopped the chase when he's running around the car. Well, the chase didn't stop when he's running around the car. It seems to me that that would be an officer discretion type issue. And the officer decided that he was going to keep going. He did issue commands. I mean, he issued a lot of commands. I think it was 27 commands to stop. One presumes that if you're fighting for a dangerous weapon like a taser is, and that's been made pretty clear that it's a dangerous weapon, that if you're fighting for that, I would presume if somebody's saying put it down or let go, that it's kind of implied that I'm going to have to take a next step. And whether or not you have to issue a warning, I think that just kind of confuses the jury, because the issue is whether or not you're justified. Would a lay person have to issue that same warning? Because the instructions are the same for police officers as lay people. Would I have to issue that warning? Stop stabbing me or I'm going to shoot? I mean, it's ridiculous.
I think so many people have, this one major question on their minds, Andrew, and that's, will we hear from Christopher Schurr? Will he testify? So I'm just curious, from your opinion, a lot of times we hear that defense attorneys will discourage their clients from testifying. What's your opinion in this case? Do you think he should take the stand?
I'm not going to speculate as to what their conversations are. I can tell you that in self-defense cases, particularly in light of what this professor testified to yesterday, I think it would be hard not to put him on the witness stand. I think he needs to. Whether or not he does is up to them. I don't know what their strategy is, but I think that he needs to. I think the jury needs to hear from him, like, what was going through your mind.
Andrew, Nicholas Bloomfield, I know that he is testifying right now. We're watching a feed off camera that we can't show on until a 30-minute delay, but we know he's testifying back on the witness stand right now. Again, they are asking him questions about that taser. From what you heard yesterday in his initial testimony, what do you expect to come out from today? And also, what's your reaction from yesterday's testimony from Nicholas?
Well, I wasn't able to catch every piece of it, and so I was really hoping to catch more of it this morning. My suspicion is that he's going to follow along with what Professor Stoughton talked about with the taser. I find it interesting that they have to bring him in to try to gloss over what the actual guy from Axon testified to about that actual taser. When this person is not a mechanical engineer, as far as I can tell, or an electronic engineer, and he's a use of force expert. And so he's just testifying about kind of the same thing that Professor Stoughton did. And so I find it interesting that they have to bring him in to kind of their own witness. Their own witness was Brian Childs. And so what, are you impeaching your own witness with another witness? That doesn't make any sense.
And I have to ask, just bouncing off of Emily's question, the root of this case is, did Schurr fear for his life? If he does take the stand and say, I did fear for my life, this is the reasons why I did all these things, does that just kind of drop the rest of the trial for these experts saying that he should have done this, he should have done that? And also, how does that affect the appeal case after this if his team decide to appeal the decision?
Well, first of all, the appeal would only take place if he was convicted. If he's not convicted, there's no appeal. The prosecutor doesn't get an opportunity to appeal if there's a conviction, or not a conviction if he's acquitted. But it's a substantial appeal if he is convicted. That's a big reversible error that the courts of appeals routinely grant new trials when the experts allowing an expert or not allowing an expert. The courts of appeals routinely grant relief from that. And so it's a pretty big appellate parachute for him if he is convicted. But then again, you got to sit and wait. And I don't know if he would get a bond to stay out on bond during appeal. He might have to start serving a sentence if he's convicted, waiting for an appeal.
You know, we keep going back to an earlier conversation with you, Andrew, where you were explaining that the end process is all going to lead up to the jurors being given very strict instruction and being told to follow the law. So can you talk more about that and how they're really going to have to be able to separate a lot of the noise they're hearing over these last few days and what they're really supposed to base their decision off of?
Yeah, and you know, the thing of it is when you're in trial, the very end is when the judge instructs the jury on what, you know, the elements of the crime are, how they're supposed to do their deliberations, how they're supposed to think about the law. And that happens at the very end. And there's a lot between now and then. And oftentimes witnesses just get lost in the haze of trial. Like they might not even remember the professor's testimony, or they might not remember Brian Childs' testimony, or just vaguely recall bits or pieces of it. They might not recall everything about it. And so, you know, from a jury deliberation standpoint, that's why they have to rely on their collective memory between all 12 of them. And that's why we have that many jurors, is because there's just so much to try to remember in a criminal case. And so that's kind of the way my take on it is that I don't see the prosecution's case going much longer. And if the defense has all these witnesses, they could basically have reached the point where the jury doesn't even remember the prosecution's case in chief. And that's why the prosecution's allowed a rebuttal case if they choose to put one on.
You kind of led right into my next question. You know, we could see our first defense witnesses called today. Again, you mentioned 40-some. Not all of them have to take the stand here. But what does the strategy become for the defense team now as they get to call their first witness, potentially as soon as this afternoon or maybe even the later half of this morning?
Well, one of the things I noticed in cross-examination is that they were making a big point about how these experts are not experts in Grand Rapids police policy. I think a good strategy would be to have somebody to testify in what Grand Rapids policy is and what Mr. Schurr specifically was trained on, and what his training was. I would imagine that he remembers who his training instructors were, and if they were to take the stand and testify, this is what we trained them to do. And so hopefully we hear something like that.
And you just mentioned that it could be the people that trained him or were in charge of him at that time. Does that include Chief Winstrom?
Possibly. I don't know who his training instructors were. I usually police chiefs don't do the actual training in a large city like Grand Rapids. There's dedicated people that they oftentimes from the outside that they bring in to do the training, but they would know who these people were. And in fact, if he was so far out of bounds with his training, I would have expected the prosecutors to call in whoever his training instructors were to say that, yeah, we didn't train him to do it like this. And we didn't hear that. And so that's why I'm speculating that we're probably going to hear it on the side if we hear it at all.
Talk about the objections that we saw yesterday. We saw a lot happen, especially with Stoughton. Is that typical? What are your takes on what they were trying to argue every time they objected to someone?
That was actually very typical. That was a classic homicide trial. I mean, this is going in a very classic homicide trial type of way, where really there's not a lot of objections to the lay witnesses. They saw what they saw, and as long as they're not going, way off the beaten path as far as like hearsay goes, there's not a lot of point in objecting to it, and so it is what it is. But when you get into the expert, and this really is, and I think we all knew this all along was going to be a battle of the experts, and that's when all the daggers come out. And when you're in the courtroom and you're actually doing it, you feel like you're in a knife fight, because it's fast, it's quick, there's a lot going on, and so that didn't surprise me at all. And that's usually the more entertaining part of trials like this.
Now, was it, not surprising, even with them objecting to a witness who had previously been approved to speak in the trial? I think that's what caught some of us off guard. Is that unusual?
You know what? I was thinking on that a little bit more in reflection yesterday evening, and I had made the comment that you normally you file these motions well in advance of trial, and it's argued. But again, if the trial strategy, like the motion for the exclusion of the evidence of Mr. Loyola's criminal history, if the idea is to get it out in the court of public opinion, well, then it was well played. And so even though it was outside the presence of the jury, we have all been able to see and hear it, and it's no longer secret stuff because the courtrooms are open to the public. We all get to see it and comment on it and talk about it. And so in the court of public opinion, even though the jury doesn't see it or hear it, and that's why I think they objected to it again in the presence of the jury. They did a quick objection saying real briefly what their objection was. The jury got to hear that. They got to hear the voir dire on the experts, the brief voir dire on the experts' credentials. And so the jury actually got to hear a little bit that, hey, the defense isn't cool with this. And so they're at least on notice now that this is like not all agreed upon like it was with else.
And one final question, like Tanner mentioned, we could see the prosecution rest their case today. What are your final thoughts? What do you think that they have sealed their case in this trial, or do they have a lot of work to do now that the defense can take their case?
I don't know. Possibly. I think that it's possible. I think that if the defense doesn't put on their own at least one expert to counter the professor, I think it's possible that the jury could convict on this evidence. I would expect that at the close of the prosecution's case in chief, the defense will make what's known as a motion for directed verdict. I think it will probably be a substantial motion and may actually take up some time. Oftentimes, attorneys will make a motion for a directed verdict, and it's just a real quick, Your Honor, we moved to have the case dismissed. The people didn't put on a sufficient amount of evidence. And the judge, and it's you do it for appellate review purposes, and the courts allow it all the time because everyone knows it's for the purposes of appeal. But I think in this case they have a substantial issue, and the issue is that they didn't prove that, because the people have to prove beyond a reasonable doubt that it was not justified, and that was the issue all along from the time that they had the preliminary exam all the way up to the Michigan Supreme Court denying leave to hear the case. And so that has been the issue all along. And so I would expect to hear at the close of the prosecution's proofs a motion for a directed verdict. And I can briefly tell you what that entails is first of all, the judge has to take all the evidence in the favor in a light most favorable to the prosecution. So if something could be inferred one way or the other, they have to infer in favor of the prosecution to see if a reasonable juror could then conclude guilt beyond a reasonable doubt. And those motions are routinely denied, but they preserve an important issue for appellate review. I hope that makes sense.
I know that we said one last question, but I just had to clarify because I think everyone's wondering. Yeah. So when you say that this directive appeal, or sorry if I'm missaying that, does that mean the case could end today? What does that mean? Because that's a bombshell for us.
I doubt it, but it's possible. So if the judge says that, yeah, I agree, the prosecution did not present proof sufficient to prove in a light most favorable to the prosecution. So that's the important aspect of this, is that the judge has to take all of the information in a light most favorable to the prosecution. And so that's why it would likely be denied. But at the end of the day, it is a possibility. If the judge does grant the directed verdict, then the case is over.
Wow.
Very interesting.
That is very interesting. So today is a big day for us then.
Yeah, I wouldn't get anyone's hopes up that that's going to happen. I would just say that is one of the possible outcomes.
Okay. Well, thank you, Andrew. We appreciate you coming and giving us your knowledge on this case. Of course, we will continue to talk to you as the case goes on, if it continues after today.
All right. Thanks again.
Something that interesting, that is happening right now, of course, is the cross-examination of the last witness from yesterday, right? So I'm reading our blog on 13onyourside.com. Matt Borloga, the attorney for Christopher Schurr here, he's now playing footage for the court of that taser incident. And so that is partially what the testimony you're about to hear in about 5 minutes will begin. But again, that is the end of the prosecution's case here, in which we could start to see the defense start to call their first witnesses.
And what he just said right there, I think that might have a lot of people holding their breath, because I didn't know that. I didn't know that it could possibly end today. Now, like he said, it probably won't.
But there's a possibility.
There's a possibility, and now that'll be interesting to see how that plays out if that does happen.
Yeah, I mean, it's so tough, right? Because he says this all really comes down to how Christopher Schurr felt, in terms of if he truly felt that his life was in danger. So that really just sort of changes the perspective for me and the tough job that this jury has to work their way through all of this information that they've been given. And what stood out to me about that directed verdict that he mentioned is, he's saying that the judge has to take into account all of the information in favor of the prosecution. I'm just even more confused now.
It almost makes you think that, if they do move for that and then it's denied, the prosecution, after they've rested their case, how much work does the defense have to do here to make their side of the story heard, to kind of, ensure that they can get a win on their side. But again, it is interesting, right? Because it's just one of those things that we did not expect to hear, but it could be a possibility today.
And you're really gambling on a lot. I mean, Schurr has not said anything. He hasn't been able to take the stand. And, I think a lot of people would probably want to hear from him. And if the jury decides to go in a way that's not in favor of that, I think it would leave a lot of people confused.
But that was interesting to hear from Rodenhouse,
Absolutely.
too, that he essentially feels like he
could
has
get
to
a
take the stand.
Yeah.
He needs to take the stand, which, as I said, most times you hear from defense attorneys anyway, they are totally discouraging their client from talking. So to hear him say, we really kind of need to hear from him, I'm so curious if Christopher Schurr will end up taking the stand.
In that same vein, he's saying, with this professor's testimony that was allowed, he was vehemently against that professor being allowed to testify here. And again, one of the reasons being that they're just not experts in Grand Rapids policing.
Right.
But of course, he was allowed to testify. It was interesting to see his take on that, as maybe that could be a reason why we see Schurr take the stand, to get his own thoughts and opinions about what happened that day and see the story through his eyes. But again, I was also very, very intrigued by his reaction on that one major objection that we heard as the Professor Stoughton, take the stand, as we heard that. And again, that goes back to that contentious battle. And now we see a better picture of why the defense really did not want Professor Stoughton to take the stand there.
And I think also too, something that he brings up is that these people were not from Grand Rapids. If we do hear from people who train people with our police, even Chief Winstrom, is that a connection that the jurors have? These are people that work in my community, that know the policy that's for my city. Does that change how the jurors connect to the experts? Now, do they look at Stoughton and say, well, he's an expert from South Carolina, here's someone who works in my community, I might lean on them a little bit more to say yes or no in this case.
Well, I also thought it was interesting, Andrew's reaction to the back and forth and the objections versus ours. We're like, oh, whoa, things are really kind of heating up here. And he's like, no, this is standard for a homicide trial. But also really important to note that he was saying sometimes these objections are sometimes sort of just part of the show, right?
Yeah.
Part of the defense or prosecution just wanting to make their argument clear. We talked about the defense objecting to these witnesses that had already been approved to testify, and Andrew saying that, well, that could be part of either side just wanting the jury to have a clear understanding of how they felt about that. Hey, this has been approved, but we want you to be sure or clear that this was not something we supported and we do object to this.
Maybe something we should have asked Andrew, and if Andrew's listening, maybe we can talk about this the next time that we speak with him, is that, we've had these 3 expert witnesses after, at the very end of the prosecution's case here. We're talking about Brian Childs, Seth Stoughton, and Nicholas Bloomfield were the 2 that created the most controversy between the 2 sides here. I'm curious if, we hear from these these witnesses on the second and third witness that we heard from, and we're hearing from Bloomfield right now, but I'm curious is if the defense will have to quickly feel like they have to make their case, you know, with their most bombshell witnesses and things like that. So I think that is something interesting that we'll see as the prosecution rests and the defense picks things up.
Most definitely. We just got word that on our stream, the judge has just walked in. Let's drop into those proceedings now.
We were, I don't know about in the middle, but taking testimony of Mr. Bloomfield. But before I have him retake the stand, is there anything we need to address before the jurors come out for the people
Nothing, Your Honor.
and defense?
Yes, Your Honor. We're wondering if the court is going to give a written version of the jury instructions soon so we can look at that. I know we've talked about it in chambers, but we're hoping to get sort of the final set. Just with the special instructions, not all the instructions, obviously, just the ones we've been discussing.
Really, it's just one, right?
It really is just one.
Okay. Okay. So, I will have my law clerk work on that while we're in here this morning. But I have it, I wrote on it, but probably can't read my writing. So what I'll do is have them amend it and then we'll distribute it.
Okay.
Anything else before we come in?
No, thank you, Your Honor.
All right, and so I'm gonna ask the witness to retake the stand, please, that you see him in the courtroom. And if anyone like him re-sworn for the day, or I can just remind you.
I have no need for re-swearing, Your Honor. Whatever the court wants to do, Your Honor.
Okay. Sir, I'll remind you that you are still under oath from yesterday.
Yes, Your Honor.
And you may have a seat.
Thank you.
For now, until the jury comes back in, and we'll have them run their name. Welcome back. See, everyone made it back to court safely. You may be seated. Mr. Becker, you may continue with your report.
Thank you, Your Honor. I'm gonna start the morning off. You dim the lights of any that are radio, please. Okay, Mr. Bloomfield, you had an opportunity to look at the video and the still frames of the video, correct?
That is correct.
For the record, this is the People's Exhibit 7, starting at frame 5592. Now, I think we left off, I just wanted to make sure we're on the same page. Your issue is with the taser. You didn't have a problem with the taser being used, but it was how it was, at the time it was deployed. Is that a fair assessment?
And that's a fair assessment, yes.
I'm going to show you here, kind of walking through this. Now, can you go over like, a little bit again, why is this why was this bad tactics, if you will?
So 2 reasons. Number 1 is the effectiveness of the taser. In order for the taser to, in these situations, when there's a probe deployment that is being attempted by an officer, the greatest likelihood that neuromuscular incapacitation is going to occur is when the probes have a far enough spread apart in large muscle mass areas of the body. And what TASER has also recommended through their training to officers is what they term splitting the hemispheres, where if again you use the waistline or the belt line, separating the upper from the lower hemisphere, getting a probe in the upper half and a probe in the lower half of the body, again give officers the greatest likelihood that neuromuscular incapacitation is going to be achieved. In order for that to happen, you need to have some standoff distance so that as the probes leave the cartridge, they can have time to essentially spread apart in order to achieve that.
I'm going to show you right now, we've gone to now 5631. I think there's a laser pointer there too. Can you give them the drill, what they're looking at here in terms of where you talk about the spread and where the taser's aimed at, if you will?
So right here you can see two laser pointers which are affixed to the TASER device. This is to assist officers in being able to visually see where the probes are likely to impact. The green laser dot is the upper probe or the top probe, and then the red dot is the lower probe. Again, and they're different colors so that officers are best able to distinguish between the two. And again, so that's a visual indicator. So right here you can see that both of the probes, based upon the laser sighting, are above Mr. Luoya's belt line. And so that would indicate to an officer that both of those darts are likely to go just in the upper hemisphere.
What was the other issue then that you had in terms of with this opponent? It's not just the taser distance, but it was something else related to weapon retention?
Correct. So it's generally accepted in policing all across the country. The principle of what we refer to as weapon retention, where officers are taught tactics to retain their weapons, essentially to keep other persons from grabbing and getting a hold of their weapons and potentially using those weapons against either the officer or other bystanders. So this is a heavy part primarily of defensive tactics training that officers go through. Both the basic training as well as they go through refresher trainings throughout their career. And so extending a tool in close proximity to an individual, especially one that is facing you in this manner, creates a high likelihood that your weapon is likely to be grabbed, or your tool is likely to be grabbed in this particular instance. What we see a lot of times, and again, this is not just related to tasers, this could be firearms, batons, OC spray, is that when it's in close proximity, you will have subjects who will reach out and attempt to either deflect or disarm officers just because the opportunity is there, even if prior to that there was no indication that an individual was attempting to close distance and disarm an officer. It's more opportunistic in a lot of these cases.
And so that's what essentially happened here, because you continue on. The weapon is grabbed right around 56, 58. And then 56, 70, you clearly see the taser in the hand of Patrick, correct?
That is correct.
Now, you didn't just look at this frame by frame, you looked at all the videos, correct?
All the videos were provided to me, yes.
Take it, this is going to exhibit 1, the cell phone video.
Okay, why you got?
For the record, it's about 50 seconds into exhibit 1, Your Honor. What did you hear there?
So what I heard there was what I would recognize as being consistent with the sound that a taser makes during a probe deployment. So you initially hear a pop, which is essentially when the cartridge, or excuse me, when the probes are leaving the cartridge of the taser, you'll get that distinct popping sound that you hear, followed by the cycling of the taser, which is consistent with kind of what I consider kind of an electrical sound or an electrical cycle.
Continue on with the
Okay, why you gotta do her that, bro? He good, man. No, like he good at.
So did you hear anything there?
Again, at this point, I heard another popping sound that I recognize as being consistent with a probe deployment.
And just for the record, that's about 113 and Exhibit 1, Your Honor.
You can talk to him, bro. Like he good, bro. Like, can you talk to him like good? Like, can you, yeah. Stop grabbing him like that. Now he good at for real. Yo, you hear him too. He's that shit. Now he ain't brought no taser. I see that. Let go of the taser. Drop taser.
I'm going to stop right there. Now, in terms of, did you ever hear any additional taser deployments other than the two you just mentioned?
No, I only heard the two. The other thing that I wanted to mention, just because you asked me about sounds, is with each taser deployment, you'll also hear kind of a chirping or a beeping coming from the taser. These tasers, specifically this model, has built into its software to where it will cycle for 5 seconds automatically, then it has an automatic shut off. And so that chirping is notifying the officer that, hey, this cycle is coming to an end. And in both probe deployments, or what I recognize to be the sound of probe deployments, as was asked, you also hear the follow-up chirping notifying the officer that, hey, this 5 second cycle that is active is about to come to an end.
And that was kind of my next question. Did you ever hear that chirping at any point in time after that? Other than the two deployments, did you ever hear it at this point in time or just before the shooting?
No.
So obviously you took a look, you saw the shooting now, you've seen this whole incident in your analysis of this case, correct?
Yes.
Could you tell the jury what your opinion is when a reasonable officer in the same circumstances made the decision to fire, as we just saw?
So with the taser, there's a theory that's commonly held within the policing industry with regard to an officer being disarmed of a taser. The theory essentially posits that an officer may be justified in using deadly force if they were disarmed of their taser because of a threat that they may have the taser used against them, specifically being incapacitated by the taser. In order for that to be a valid claim, the taser would have to be in a condition to where it could cause neuromuscular incapacitation. The greatest likelihood of neuromuscular incapacitation being achieved, as I've mentioned here on the stand multiple times, is through a probe deployment. The Taser 7 is equipped with two cartridges, and those cartridges are there because, again, over the years, the original tasers only had one cartridge. Then Taser started coming out, Axon started coming out with multi-cartridge models because, again, a lot of things have to go right in order for to have a good probe deployment and have neuromuscular incapacitation achieved. And so Taser started again coming out with multi-cartridge models to give officers follow-up opportunities in the event that they were unable or unsuccessful. And so there's only two cartridges available. Beyond that, when it comes to drive stun mode, even with the expanded cartridges, we're now in a situation where the taser can still be used in follow-up or drive stun mode, but that operates off the principle of pain compliance, so it does not achieve incapacitation. And so in this particular circumstance, you have a situation where a taser is no longer in a condition to where neuromuscular incapacitation is likely to be achieved, either against the suspect or against the officer in this particular case. And so based upon that, a reasonable officer in this position to elect to use deadly force, knowing that is the condition of the taser, that would be unreasonable, excessive, and contrary to generally accepted police practices.
I have no further questions, Your Honor. Thank you.
Morning, Mr. Bloomfield.
Good morning.
Okay. I'd like to ask you a couple of questions about your background.
Yes,
I think you said you work for a hospital system or a hospital
I
chain?
do now, yes.
And what do you do there?
I'm the regulatory manager.
Okay. What do you do as the regulatory manager?
So I'm responsible for making sure that the organization which I'm employed with is in compliance with federal and state regulations. Primarily, the regulatory body in healthcare is CMS, Center for Medicare and Medicaid Services, and so they set standards the hospitals must comply with in order to qualify for those monies.
Do you ever review situations to determine whether or not a particular situation, individuals comply with regulations or rules?
Yes, I do.
Okay. All right. And I'd like to talk about, really, you gave focus really on two opinions. One was yesterday, and you had a little bit of that today. And then you had another opinion, the one you just ended with, and I'm going to talk about those in order.
Okay.
Okay, so now you did team up with Professor Stoughton in this case, correct?
Yes, I did.
And so you guys have a joint report.
Yes, we do.
All right. How do you know Professor Stoughton?
So Professor Stoughton now is a colleague of mine. When I was conducting research for our organization, when I was employed with the Farmington Police Department in reference to contagious fire phenomenon, he was one of the academics that I reached out to, and we began a rapport from there, and then that turned into some professional teaming up and working in this field.
Okay. All right. Thank you. So yesterday you talked about OC spray.
I did.
Can you tell us if OC stands for something?
It does. It stands for oleoresin capsicum.
Now we know why they call it OC spray.
That's correct.
Okay. What is the purpose? Is it something that a police officer might have on his or her belt?
Generally speaking, yes, and so OC spray is a common force option that officers are provided that is very common throughout the industry.
You wouldn't classify it as a deadly force?
No, I would not.
Okay. Now, you were talking about it, but is anything in your opinions, or is it your opinion that because Officer Schurr didn't use OC spray, he acted unreasonably?
No, not in this particular case. Part of the use of force calculus is what reasonable options did an officer have. That clearly could have been an option that would have been reasonable based upon the level of resistance that a reasonable officer in this situation would have observed, but it wasn't selected as an option in this case.
Okay. All right, and if we could switch over to the defense. And 5400. RFN 5400 from Defense Exhibit A. So I'm going to play you the part about the taser
Okay.
before the final use of deadly force. And it's not very long. No, we have this, I'm sorry, we have this problem every day. The plug's got to be connected.
There, it goes green now.
And so this is with regard to the opinion that you finished up today, the taser deployment, the first one. If we could just play that in normal speed. And this is RFN 5400. Yeah, that's good. Okay. And so when you're talking about Officer Schur's use of the taser, you're talking about those seconds in that video.
Yes,
And so you would agree that this happened over the course of reaching for the taser was a matter of seconds?
I would agree with that.
Okay. And it's your opinion that using the taser in that situation is fine, but it's the manner in which you used it was not fine?
That is correct. The taser as a force option was reasonable. However, the manner in which it was deployed was tactically unsound.
And part of that is because of the distance, and because you didn't believe that there was the ability for NMI at that distance, correct?
Not the ability, but the likelihood, based off manufacturer recommendations, that NMI could be achieved was significantly diminished.
Okay, and I think you said yesterday that the preferred range is 7 yards. Did you mean feet?
No, feet.
Okay.
Yeah, sorry if I
I didn't
misspoke.
think you meant
So-
21 feet, but.
No.
You know, we did make you testify right after getting on
Yes.
off the plane. So, all right, so 7 yards, you believe is the preferred range, so you get 12 inches? Or 7 feet? Did I just
Yeah,
say
7
yards?
feet, you
I'm
did.
sorry.
I was gonna correct you, but you're fine. So, yeah, no,
Please
you're
correct
good.
me if I do something
No,
wrong.
you're good.
Okay. So 7 feet would allow you to get 12 inches of NMI.
Generally, of spread, generally speaking, but in addition to that, TASER recommends that those probes split the hemisphere, so you have, yes, one probe, just as you're demonstrating, one above the waistline, one below the waistline.
And it's your opinion that this isn't close enough to split the waistline? I mean, it seems like he's pretty close. He's just above the belt buckle, right?
Again, I'm speaking, it's close, but however, I'm speaking to TASER's recommendations, so.
Okay, and with regard to those recommendations, with the TASER 7, the actual recommendation to get the 12-inch spread is 4 feet, right?
Is what?
4 feet?
4 feet?
Yes.
Could be.
Okay, so it's
Yeah,
not
yeah,
7.
I don't recall specific, 4 to 7, somewhere in that range. There's not, yes, I'd leave it at that. So I don't have the materials directly in front of me.
Well, and in your report, you say 7 feet as well.
Yes.
And you're basing that on the trainings that you reference in your report, right?
Yes, so TASER does provide trainings to departments. Anytime officers undergo TASER training, they actually do not, they may have their additional curriculum, but TASER actually provides a curriculum for officers that they recognize as the curriculum that officers essentially would need to go through for the manufacturer to recognize them as a valid operator with their device. And again, they put that out, and so certified TASER instructors have that. All the information that I referenced in the report, so if it was 7 feet in the report, that would come directly from TASER.
Okay, and you're referring to particular trainings on the TASER 2, right? In your report?
I don't recall specifically, does it state in the report?
Have you ever worked at Axon?
No, I have not.
Okay. Okay, now, in a close proximity situation, let's say you don't get the full 12 inches. Are there any departments that train that you can use the drive stun to complete a circuit of more than 12 inches?
Yes,
So if one probe goes in and another one misses, right, and sometimes that happens, right?
yes,
You can just make a
more
third
often than
point.
not.
What's that?
Said more often than not,
Because you have two darts basically going on, and they're designed to actually spread distance, right?
correct.
So you can make the third point and cause NMI.
Yes, you could.
Okay. Okay, and then I think you testified that in this situation, he should have created more distance, preferably 7 feet, according to you, right?
At least enough distance in order to get a reasonable spread that would split the hemispheres.
Okay. But there are some situations where officers really can't create distance, right?
That is correct.
And one is if you're in a confined space,
Correct,
there's nothing you can do. You can't go through a wall.
correct.
but that's not the case here.
No.
They're outside. And also when a suspect is closing in on the officer, right?
Yes.
Okay. And is it your opinion that Mr. Leoya wasn't closing in on Officer Schurr at all?
Correct. In the video that we reviewed, the one that's been shown here today, you can see that Mr. Leoya's posture is always trying to create distance from the officer, and the officer in this case is the one who is closing the distance.
How about when Mr. Leoya grabs the taser? That's not closing the distance?
At that moment, Mr. Leoya, at that moment in time when the taser was presented, reaching forward, I wouldn't necessarily constitute is closing the distance. He's reaching forward to grab the taser. I would agree with that. But the whole reason why that opportunity even occurred was because the officer in this case is the one who closed the distance on Leoya, who was trying to create distance from the officer.
He didn't give him the taser though, right, the officer?
No.
Okay. Mr. Leoya grabs the taser.
Correct.
Is reaching out to grab something off an officer an act of aggression?
It could be. It's also consistent again where individuals are simply trying to defend themselves from being, in this case, having a taser used against them, being shot. There's a number of reasons, and I don't know the mind of Mr. Leoya.
Well, just based on the video,
Mm-hmm.
you agree that it could be an act of aggression for someone to grab a taser from a police
Correct. It
officer.
could also be an act of defense, yes.
Okay, and an act of defense like deflecting something, right?
Yes.
Okay, how about disarming a police officer? Is that an act of aggression, in your opinion?
Yes.
Okay. Now, you and Professor Stoughton had some opinions about things that happened more than a minute and a half before deadly force was used, like chasing Mr. Leoya around the car.
Yes.
And you talked a little bit about it yesterday, and Professor Stoughton talked a lot about it. Is the fact that, in your opinion, Officer Schurr shouldn't have, it was unreasonable for him to chase Mr. Leoya? Does that mean that he no longer can use deadly force at a later time?
No.
Okay, so he's still, if he's reasonably in fear of great bodily harm or death, he can, or if someone's going to attack him, if he's reasonably fear, he can still use deadly force, right?
So I'm going to clarify just a little bit. In order for an officer to be justified in the application of deadly force, they must be able to articulate why they have a reasonable belief that they themselves or another individual is under immediate threat of receiving great bodily harm, great bodily injury, and or death. by
That's
the
generally
actions of
accepted
another.
police practices, right?
And that is the language the Supreme Court uses, which is what was adopted by the policing industry and has now become generally accepted police practice.
And to be clear, you're talking about the U.S. Supreme Court,
And that is correct.
not the Michigan Supreme Court.
And that is correct.
Okay, because you're not familiar with Michigan law.
I'm not.
Okay. All right, and then you talked about Officer Schurr's use of deadly force. You say it's unreasonable and contrary to generally accepted police practices.
Yes.
And I understand that the basis for your opinion is that the taser wasn't in a condition to incapacitate him.
That is part of the reasoning, yes.
All right. And I think you testified about it. You can hear the pop, right?
Yes.
Okay, and you know that there's two probes, right?
Yes.
Okay. Now I believe you testified about, it's generally accepted that in the absence of physical ability to incapacitate the officer, or otherwise render him unable to protect himself,
Mm-hmm.
no reasonable officer, not one, could have concluded that Mr. Lillia presented a threat of death or great bodily harm. That's what your opinion is?
Under this specific case, this specific fact pattern, yes.
Okay. And the reason you're forming this opinion is because you know that if an officer is incapacitated, he's lost the ability to protect himself, right?
That is the theory, yes.
Okay. And we're talking about what he reasonably believed in that situation, right?
Not what he reasonably believed, what a reasonable officer would have concluded.
Okay, so you're just talking about objectively reasonable officer standard.
That is the standard, the only standard in the review of all cases that's accepted in the industry.
Okay, generally accepted.
Yes.
Not talking about Michigan law now, right?
Not talking about Michigan law.
Okay. So you don't consider whether or not the arresting officer, in this case Officer Schurr, knew that the second probe?
So when we review cases, we do take into account the subjective statements, opinions of officers, as far as to fill in what a reasonable officer in that officer's situation would have known at the time.
Did you review Officer Schurr's statement in this case?
We did.
Okay. And in there it said that he,
Object. This is hearsay. You can't get it in. I can get it in if I want to. It's the same against party opponent. He can't get it in.
I believe the expert relied on it in his opinion, so I'd like to ask him about that.
Well, you can't, doesn't make hearsay admissible, so.
Well, there's a lot of hearsay that he's
You can
talking
ask him
about.
what he based it on, but you can't say, my client said, whatever he said, that it would be hearsay. So I'll sustain the objection on that basis.
Mr. Bloomfield, you relied on a lot of materials, including trading materials, right?
We did rely on some of the training materials that were provided, yes.
And you said you considered the statement as well when forming your opinion?
Yes, we did.
Okay. So I believe you testified yesterday about incidents where if an officer is incapacitated and loses his firearm, he can be shot or killed, right?
I don't recall getting into that yesterday. I did touch on that briefly today.
Okay. Are you aware of situations where an officer is incapacitated and then loses his firearm and is shot and or killed?
So I need a little clarification there. When you say incapacitated, are you talking incapacitated with a taser specifically or incapacitated by other means?
Well, let's talk about both.
Okay.
Okay. Incapacitated by any means. Are you aware of any situation where an officer's been killed after being incapacitated?
Yes, there are situations where I would personally classify that an officer's been incapacitated. Maybe that would mean being knocked out, being injured to a point where they're no longer able to successfully defend against somebody disarming them. I am aware of incidents like that.
Okay. And here the concern is with a taser, you can be incapacitated if NMI occurs, right?
Yes.
Okay. Are you aware of incidents where an officer has been tased and has been shot?
Where an officer has been tased and then shot. It's a very specific circumstance. Right now, I'm not aware of anything. Myself and my colleague, Professor Stoughton, him specifically, conducted extensive research on officers killed in the line of duty. And we are not aware of any case or instance where an officer had a taser that was used against them where they were incapacitated, and also within that same set of circumstances, it resulted in an officer's death where they were disarmed. In addition to that, I do not know of any case, not including deadly force, where officers have been disarmed of their tasers, where an officer has been successfully incapacitated by a suspect.
You're not aware of that, right?
I'm not aware of that, and nor in any of the research that we conducted in preparation for this did we ever find anything that would essentially change my opinion. If I was aware of at least an instance, I would let you know.
Okay. I'm just asking you about what you're aware of and what you relied upon. Now, your opinion states that it's unreasonable for Officer Schurr to believe he could be incapacitated, right?
For an officer, yes, in his circumstances.
Because the available evidence establishes that any reasonable officer in Officer Schurr's position would have been aware that Mr. Leolia did not have the ability to incapacitate Officer Schurr because both of the cartridges in Officer's taser had been discharged. Is that right?
Yes.
Okay. So it's unreasonable for Officer Schurr not to have known that the second cartridge had been discharged?
I believe what we state in our opinion is that an officer in these circumstances would have known that both cartridges had been discharged from the taser.
Okay. And because you assume he would have known, he is therefore unreasonably believing he could be incapacitated by the taser.
Correct.
You also have stated that in stressful environments, human decision-making suffers. Officers may experience distorted sensory perceptions, including visual distortions, like tunnel vision, auditory distortions, which is auditory blunting, and temporal distortions, perceiving events as occurring more quickly or more slowly than they actually are. Is that a
Yes.
fair statement?
Yes, it is.
In fact, you said it, right?
Mhm.
Yes?
Yes.
Okay, so what, you talked about auditory distortions there, for example, auditory blunting. What's auditory blunting?
So, again, it is a term that is known in the industry. Auditory blunting or auditory exclusion is what they're most commonly referred to. So essentially, that is a phenomenon, physiological, psychological phenomenon, where under stress, when officers have discharged their weapons, they report that essentially the signature of the weapon being fired, the sound, is reduced. And that has led officers to believe that in some cases that something is wrong with their weapon as a result of that. And so, again, this is a pretty well-known phenomenon. Most officers receive education that if they are involved in a deadly force encounter and they discharge their weapon, that a lot of these physiological and psychological phenomenon may be experienced. Auditory exclusion happens to be one of the most commonly reported phenomenon that is experienced along with tunnel vision.
And what's tunnel vision?
Tunnel vision is essentially where officers, and again, this doesn't just have to be officers, it could be soldiers, but in deadly force encounters, they become hyper-focused. Essentially, their vision, they report what could be termed as superhuman vision, where they're able to hyper-focus, mostly on weapons. At far distances, officers have reported being able to see amazing things. Also time distortion, where generally speaking, among most officers in deadly force encounters, they report time as if it's slowed down for them. Rarely do we hear any reports of time speeding up, some, but mostly time is slowed down.
Okay, and these phenomena occur in stressful environments.
They can. Their most common reference is in when officers are actually under the threat of receiving great bodily harm, great bodily injury, and/or death, and responding to that threat, primarily with deadly force. And so it's just not all stressful situations. In general, officers encounter stressful situations all the time. The majority of the literature and the research is specifically around deadly force encounters, specifically when officers are under the threat, again, of great bodily harm, great bodily injury, and/or death, and are responding to that threat to defend themselves.
Is the video that you just saw one of those types of stressful situations where auditory blunting could occur?
Generally, The situation is pretty common in policing in terms of the events that transpired. As far as now, when you said that statement, and correct me if I'm wrong, is it possible? If you're saying is it possible, well, I'd have to concede that anything is possible. Is it plausible? No, and the reason why I say that is because there's nothing in this situation that I would term that an officer in these circumstances would have a reasonable belief that they were under immediate threat of receiving great bodily harm, great bodily injury, and or death.
Well, we just talked about the fact that you had formed an opinion
Yes,
that if Officer Schurr had been incapacitated, he could be harmed or die.
yes,
And then you gave us your opinion that he wasn't in the situation because he didn't hear the second probe, right?
state that one more time.
Well, let me ask this a different way. Are you an expert in auditory exclusion?
I am not.
Okay. All right, so we talked about incapacitation. What you don't talk about is whether or not do you have an opinion on whether or not the drive stun can cause bodily harm in a situation where a person has taken an officer's taser, as in within a foot or two of the officer?
So when you say bodily harm, can you give me a reference by what you mean with bodily harm?
Like being blinded or getting hit in the throat and the trachea collapses.
I would assume that those things could be possible with that
Okay.
taser and drive stun.
Okay, so in a situation such as this, where the taser is close to the officer, is it reasonable for him to fear that he could be harmed in those ways, given the situation?
Again, it's possible, but anything is possible. I didn't see anything in the facts of this particular case that would lead me to believe that a reasonable officer would have felt that that was an immediate threat at the time deadly force was applied.
Well, Mr. Leolia in this case had switched the taser from his left to his right hand. You're aware of that, right?
Yes,
Okay. And he had it in exclusive control over it in his right hand, right?
when you say, again, exclusive control, I don't know what you mean by that. His hand was on the taser. He never had his hand in what I would term as fire control, or in the way that an individual would commonly hold it to activate it to cause either drive stun in this case with the condition the taser was in.
Would that make a difference to you if Mr. Leolia was holding it like a gun? Would that change your opinion?
It would influence my opinion. I've had cases where that has been the circumstances.
A moment, Your Honor.
I have nothing further, thank you, Your Honor.
Julie, you kind of made right to the one opinion. You said, one of his questions was that, well, your opinion is based on the taser's not in a condition to incapacitate him. And you said, well, that's part of my opinion why the use of force is not appropriate here. What's the other part, I guess? What is missing out of that opinion? It's not just the taser, what else is there?
So when we talk about any application of force within policing, it's based upon a number of factors. One is proportionality to the resistance or threat that an officer perceives. During this entire instance, while I talked about the other applications of force that a reasonable officer would have used throughout this situation as it unfolded, the primary form of resistance that was demonstrated by Patrick Leoia would be classified as resistance. And so resistance in the form of physical resistance, attempting to get away, being taken into custody, creating distance. Not at any time in any of the evidence that we reviewed did we ever see Patrick Lioya attempt to harm the officer in this particular instance. As noted, Patrick Lioya did grab a hold of the officer's taser, and there was a struggle over the taser in this instance. But again, in this circumstance, it is that there was nothing that we term to be aggressiveness or combativeness on the part of Mr. Lioya towards the officer in this case, coupled with the fact that the taser is not in a condition where neuromuscular incapacitation could be achieved, in addition to the fact that a reasonable officer would have known that that was the condition of the taser. And so all of those things together would lead a reasonable officer to conclude that they do not have grounds to reasonably articulate that they were under an immediate threat of receiving great bodily harm, great bodily injury, and or death. Therefore, that classifies the application of deadly force in this instance as unreasonable and excessive.
Thank you. Anything further? You have a couple more questions, right? On that? Mr. Bluefield, does an officer have to wait to be harmed before he
Acts.
They do not.
Okay. And it's your opinion that you never saw any act of aggression by Mr. Lioya on those videos?
No.
That's not your opinion, or you didn't see any?
My opinion is that we did not see any actions by Mr. Lioya that we would constitute as act of aggression attempting to harm the officer.
Okay.
Yes.
Yes, Your Honor. I have nothing further, Your Honor.
And I do see one hand raised on the jury, so I'll have my clerk come and grab that question from you. Right now, hold it, please. Okay, so I'm gonna pass the question back because there's one word that I'm trying to make it out, I just can't. So I'm gonna ask if you could just rewrite it, and I just noted which word it was. And then, I'll have you approach. If you could approach, please. Do you usually find errors on the other's choices of force or lack thereof?
I don't know if I'm fully or can grasp what the question is that the jury needs assistance with. Can you read it one more time, Your Honor, and I'll.
When investigating cases, do you usually find errors on the other's choices of force or lack thereof?
So when investigating these types of cases, I think if I'm understanding the question correctly, the question is do we often see errors on the part of officers in their decision-making and, the levels of force that they choose to employ? The answer would be yes and no. In a number of cases that myself and my colleague in this case, Professor Stoen, we basically review, hundreds of cases. And in cases, we find where the actions of the officers are completely reasonable and consistent with generally accepted police practice. In other cases, we find the opposite, where none of the actions of the officer were reasonable and consistent, and then we find a mix, where sometimes some of the actions of the officers were reasonable and other actions were not reasonable. In this particular case, we rendered a number of opinions on the actions of a reasonable officer in these circumstances that we found to be reasonable. Most of that was leading up to the deployment of the taser. We said, hey, we recognize that the majority of these decisions by a reasonable officer in this case were reasonable decisions and were consistent with generally accepted practice. And so I hope that answers the question.
I have no follow-up, Your Honor.
No, Your Honor. I don't see any other hands raised. On the jury, may this witness be excused?
Me, Your Honor. Yes, Your Honor.
Objection. Thank you very much.
Thank
sir.
you, Your Honor.
Your Honor, I show we've admitted 35 exhibits. They're all admitted at this point in time.
Check. Exhibits 1 through 35 for the people, yes.
So, all right, with that, we have no additional witnesses and we rest our case.
And Mr. Gordon, are you ready to put on your case at this time? Or would you like a break?
We would like a break, Your Honor. We have a matter for the court outside of New Jersey.
And so, what we'll do is we'll take a break for 15 minutes right now, and so that means we'll come back at 10 after. So meanwhile, just because people are arrested doesn't mean it's time to deliberate, so you're still instructed to not discuss the case with each other or with anyone else, same restrictions with respect to access to any news reports. Also, please leave your notes upside down in your chairs, and they'll be there when you return. Thank you. All rise for the jury, please.
And we're back with breaking news. Christopher Schurr's defense team has just filed a motion for a mistrial that they believe the prosecution has skewed the perception of the jury too far with experts the defense team disagrees with. Now, we want to remind you that we are on a 30-minute delay, so you have not heard this argument yet. We are working to bring you that as soon as we can during this break. Schurr's team has also filed a directed verdict. That's something we heard from our expert Andrew Rodenhouse this morning. It's a motion where the defense is trying to direct the judge to order Schurr's acquittal in the case, as they believe the evidence presented by the prosecution should be discredited and is not accurate. And we are just slowly learning details as to the judge's response to that. My producers tell me in my ear that the judge has not ruled in favor of a mistrial. She's still going through the directed verdict. This is something that Andrew Rodenhouse just talked about with us a couple moments ago, saying that this was a possibility that we could see this happen today. And if this had ruled in favor of the defense, the trial could have ended today. But as we know right now, and I just got word in my ear that she has also ruled against the directed verdict, meaning that this trial is going to continue. Again, this is developing and it's happening in real time. We're on a 30-minute delay, so you have not seen that motion filed yet. You also have not seen the judge talk about that in about 30 minutes. you'll be able to see what we're talking about. But again, for those who are just joining us, the defense has filed a motion for a mistrial and directed verdict. Some of their complaints saying that the defense team, their experts that the prosecution brought on, they disagreed with them, bringing on prejudice to the case for the jurors. Also, with the directed verdict, asking for the acquittal of Schurr, and the judge has denied both of those. This is breaking news. We are still, as you can see, still learning some details as to what this means. You know, we'll be bringing in Andrew Rodenhouse later on to kind of talk about these things. Earlier, when we were talking about the directed verdict, he said that this could help the defense in their appeal case. It shows that they are able to make progress in the case and it could help them. It'll be interesting to see how they are able to use the decision made by the judge as to these motions. Soon, Tanner and Emily are going to be joining me to kind of talk about this further. But again, breaking news, I believe that after the decision has been made that the court has gone back into a break. And so so now we're getting more word that the defense is now taking the stand. We're going to have Emily and Tanner join me right now. Again, that's 30 minutes away from us, but we have learned that the defense has taken the stand with their first witness. Guys, breaking news. Andrew told us this was a possibility that this could happen.
Yeah, certainly a possibility that I think was in the realm of the situation today, especially with how he was characterizing the witnesses, those two expert witnesses at the very end of the prosecution's case here. That was something because if you recall yesterday, the defense actually, that was kind of where this heated argument got into place, especially with Professor Stoughton, the use of force expert, who was talking about just that theory that officer, I forget what the exact term is, but except that police use of force, that one theory that we've been talking about.
That officer created jeopardy.
Officer created jeopardy. That was kind of the theory that was the bone of contention for them. And then, of course, more controversy once Nicholas Bloomfield got on the stand as well.
Yeah, I gotta say, I was really surprised because even with Andrew giving us the heads up that that could happen today, I didn't believe him. I did not think that we were on the path to that happening. Really within minutes of us having that conversation with Andrew. I don't think Andrew believed that was really a true possibility today. So I really just could not believe that as we were listening in and heard those very words that Andrew prepared us.
It was right there back to back, a mistrial motion there, and then of course she moved to have a directed verdict. Even when they came back to ask about why they were asking for that directed verdict motion there, she cited a Supreme Court law, and she said it's actually the judge, paraphrasing here, but the judge was like, it's funny that you're citing something from the Supreme Court and what she called the law of the land here. She says that, well, you know, this directed verdict, we're listening to testimony from people commenting on the theories and practices of the law of the land. So very interesting, and of course the judge ending up denying both motions there, that mistrial and directed verdict, which again, that directed verdict would have been an acquittal for Christopher Schurr in this case.
Most definitely, and we're still learning as to the reason why she decided to go against those motions. I had to chicken scratch a lot of things. I missed a lot.
It happened a lot.
It happened very quickly. One of the things for the directive verdict, she had to list 3 different elements of this case. The one that I was able to catch before I got in here is that she says that while it's clear that Leoya had the taser at the time, the rational effect shows that he was not going to use it at the time. And so she's saying that the evidence that the prosecution has brought on is showing that, yes, he was reaching or grabbing that taser, but it's not clear at that point that he was actually going to use it to create bodily harm. So it'll be interesting to see how the defense takes that information that she just said and uses it for their own case.
Yeah, as things were unfolding, the newsroom was sort of just in an array as we were all trying to capture exactly what was happening. What does this mean for the trial? I caught a little bit of that as well, Lauren. You mentioned those 3 elements that the judge was going through in terms of whether or not that directed verdict would be able to be met. I know the first one she said was easily met. I missed exactly what those details were. The second one, I know she said was also met, and she was saying that was showing that there was an intent to kill. She said, as a police officer, Christopher Schurr likely knew that putting that weapon to the back of Patrick Leoya's head could likely lead to death. So that second element, she said, was met. The third that you mentioned, Lauren, showing that Patrick Lyoya, it seemed, was in possession of the taser, but was he able to actually use the taser in the position that they were in at that time? She said that was the only element that was still in question, and I believe why that motion was denied.
And our producer has just given us those three elements right here. She said the judge says the three elements must be proved in this case. First, that the defendant caused the death of Lyoya, which she says is proved on video. Second, that the officer had to have a state of mind where he intended to kill or cause great bodily harm, which she says is proven because Schurr shot Lyoya in the head. And the final aspect is whether this killing was justified. She says it's clear that Lyoya had possession of the taser, but a rational person could find Lyoya was not in a position to use the taser at the time of this killing. So again, those three elements, she's saying, hey, those are the three things the prosecution had to hit. They hit all of them.
Well, it's also something very interesting to hear what the judge is saying and her rationale for not declaring that directed verdict, because some of the things that she's talking about here are exactly what the defense was arguing during their cross-examination. They were trying to paint the picture that this taser was still harmful in the scuffle between Lyoya and Christopher Schurr. And again, to the judge's point here, it sounds like, as to what she has gathered from the evidence and the facts presented and the testimony here, that she does not believe that to be the case. And again, ultimately, she's basically placing the verdict back in the hands of the jury when she declares that directed verdict as a downvote there. So it's very interesting as to hearing her rationale, especially given all of the testimony that we've heard over the last 3 days.
Yeah, really kind of fascinating that she is, on the spot, obviously legally trained to make these sort of decisions.
Yeah.
But boom, here this motion is filed, and then right there in front of the court, she's laying out these three elements that need to be met in order to either approve or deny that motion. So to see that play out for us here this morning, where things could have taken a drastically different turn here in this case, where potentially was almost over, albeit this motion being denied.
And something that Andrew did say that we have to remember is that the defense could and did do this directive verdict, not only possibly to have Schurr acquitted, but also for their appeal, for after, if their decision's made not in their favor, to set up their appeal. So it's almost like playing chess in this situation to say, okay, if there's a possibility that we don't win this case, we have to set up the next move in case we do want to make an appeal, which I assume that they will.
Now, of course, I think we all know what a mistrial is, right? And just for those joining us on this breaking news, that the motion for a mistrial and directed verdict was shot down here after the defense made that motion. I just want to read off what a directed verdict is. That way we all can kind of understand what's going on. And I printed off some information that says a directed verdict is a judge's ruling that no reasonable jury could reach a verdict in favor of the opposing party due to insufficient evidence. It effectively ends the trial before jury deliberation, either acquitting the defendant in criminal cases or ruling for one side in a civil case. Of course, this being a criminal case that we've got here. And basically, that means that the judge finds that there is still evidence to be heard. At this point, she is saying the defense must try their case at this point. And of course, after we've heard the prosecution rest their case, it all kind of lies in the next 40 or so witnesses, if they call that many, as the trial continues.
And I'm glad you brought that up, because there's so many large legal words that we don't know.
Yeah.
Having that description kind of puts into perspective for people watching to understand what exactly just happened. I mean, if she would have ruled in favor of one of those two things, we could be having a very different conversation right now.
Andrew was explaining that as well, kind of in layman's terms, essentially saying that this directed verdict is the defense saying, hey, the prosecution has not proved their case. Why should we even move forward with calling our witnesses if we're saying they haven't done a sufficient job? But again, the judge shutting that down, we are moving forward. The defense has started calling their witnesses.
Yeah.
I would have to imagine that the judge made this ruling based off of the testimony that we heard. And of course, I'm not trying to be speculative here, but again, we did hear from two witnesses that the defense was saying could have been, they weren't knowledgeable about Michigan law or Grand Rapids policies as a whole. And that's essentially what the defense was talking about with those two expert witnesses at the very tail end of the prosecution's arguments here. So I would have to imagine that she just wants wants to hear more and allow the jury every opportunity to be able to make their decision. Again, not trying to offer speculation, but in the grand scheme of things, that's kind of what it sounds like was happening.
Yeah, I heard
Yeah.
some of the defense and what they were saying as they were making some of these motions, and I took some notes of her saying that those expert witnesses were applying standards that are just not applicable here in this case, and she felt that the jury had maybe heard too much at this point, and that was part of them filing these motions for the mistrial and the directed verdict. She also mentioned not being able to judge with 20/20 hindsight. The defense making that argument that that's what the jury in this case is being asked to do. So those were some of her notes in terms of why they were calling for that mistrial.
And now it's interesting to see who the defense decides to bring on. You know, we've already heard from people who have seen what has happened, both from a friend perspective, neighbor perspective. We've now seen experts. Who do you bring at this point? I mean, obviously, you guys don't know, but I mean, I would be curious to hear from Andrew later on to say, these are the type of people that you'd want to bring on after you file a mistrial and directed verdict, and you don't get that. Where do you go from here?
My next question too is once you make this entire motion, you know, this little, I'll call it a firework in the courtroom on the mistrial and of course the directed verdict, once you file that and it gets shot down, my question is how do you kind of reconcile with the jury? Like, we tried to end the trial, but okay, we have to keep going here. So with Andrew later, and again, we're talking about Andrew Rodenhouse, who's been an expert that we've been talking to. We spoke to him earlier this morning. I'd be curious to get his take on that, just to see kind of what his thoughts and feelings are, and how do you even proceed after something like this? Again, something that we weren't necessarily sure was going to happen today, but knew in the back of our heads it definitely could have.
Yeah, and if you're needing to catch up on what's happened this morning, you're seeing live the blog that we are keeping up to date for you with our Riley Mack inside the courtroom, telling you what's happening minute by minute if you're wanting to catch up on what's happened so far this morning on day 3 of the Christopher Schurr trial. So again, those motions, both the mistrial and the directed verdict, denied by the judge, and therefore that means this trial is moving forward as expected. The prosecution has rested and the defense has started calling their witnesses. We know that they have some 40 that they can call. We don't know if they'll call all of them, but there were some, mentions at the beginning of this that this could be a week-long trial. I think all of us thinking that is not going to be the case at this point.
Yeah. And I think also too, something that we talked to an expert yesterday, another legal expert, about keeping the jury engaged. Okay, so now you drop this bombshell on them. And again, these are people who don't spend time in the courtroom every single day. This is not their profession. How do you, as the defense, a question I have for the defense now is, how do you drop that bomb, don't receive that bomb correctly, and then keep going?
Yeah.
I imagine for myself, I might be a little confused as a juror, like, okay, where do I go from here, And I understand the defense will probably give them a way to follow their process. But I mean, I got to imagine keeping them engaged, it's tough.
Yeah, I mean, hearing that bombshell, fail ultimately, as a juror, how do you move forward with that? Especially given the 10 people that we've already heard of, 4 hours of testimony from just one individual yesterday. I mean, it's got to be hard to follow. And when you throw in words like directed verdict and, obviously I think we all know what a mistrial is, but directed verdict, again, it goes back to your both of your points. This is legal jargon that we're not necessarily familiar with. And I don't want to get us too tied up on that, because I think that's splitting hairs in some cases. But again, how do you get the jury to follow you after that?
And now we're all wondering, who are these 40 people?
Yeah.
Who are they going to be calling to the stand? Will Christopher Schurr be on that list? And what are we going to hear? What are the experts? Who are the experts they're going to use to combat the prosecution's experts that the defense is saying, hey, those do not even apply to, laws that Michigan law enforcement should necessarily be following. So I'm assuming that will be their strategy, to bring people up to contradict all of what we've been hearing from the prosecution, especially these witnesses that the defense has been fighting so hard against.
And I want to jump in real quick. My producer just reminded me, which I think is so important. We don't know if the jury was actually in the courthouse when those motions were made.
Yeah.
So, and like you all watching, we don't get to see the jurors during this process. So we don't know if they have escorted the jurors to make this motion and then to escort back then. So then my question is, do they even know that those motions were filed? Like, will
Yeah.
the judge eventually tell them?
Very true. It does seem that the jurors were out of the room for some moment because I heard the judge mentioning them coming back in, them being given a list of all of these some 40 witnesses that can be called. She also mentioned that their names are there with their titles and even space for notes because we know this is a lot of information they're taking in.
And I'm hearing now that we can look at those proceedings. Let's take a listen.
That the evidence presented will prejudice the defendant to the extent that the fundamental goals of accuracy and fairness are threatened. By allowing Mr. Stoughton and Mr. Bloomfield to opine on standards that are not applicable under Michigan law, as they both admitted, they don't know what Michigan law is, and that are not within the knowledge and in the situation of the arresting officer, based on tactical considerations that are not ultimately at issue in this case, including everything that led up to the ultimate issue here, which is whether Officer Schurr had an honest and reasonable belief to be in fear of death or great serious bodily injury at the moment that he made the decision to use deadly force. We also, based on their testimony, it's clear that they have not relied on proper training. They were relying on outdated policies. They were testifying about a taser model, an old taser model. They were not qualified as taser experts, and they gave several opinions about the taser. And at this point, we believe that we're too far along with the jury to simply strike their testimony because they have heard testimony from two of the people's experts now that do not accurately and are not nowhere near based on what the law is in Michigan and what should be considered in whether or not Officer Schurr was justified in using deadly force. And so at this time, we would move for a mistrial on that issue. And if the court is not inclined to grant the mistrial, then we would be asking that their testimony is struck from the record. Although we don't think that would be enough because they've heard too much now based on the tactical considerations. And under Supreme Court precedent, San Francisco v. Sheehan, the 2015 case, even under the Fourth Amendment, that it says even if the officers misjudge the situation, the court cannot establish a Fourth Amendment violation merely on bad tactics that result in a deadly confrontation that could have been avoided. Courts must not judge officers with the 20/20 vision of hindsight when they're quoting Graham versus Connor for that issue. So we'd be moving for a mistrial on those grounds. And alternatively, we would also be moving for a directed verdict based on the motions that we just filed with the court. Given the complexity of the case, we would ask the court to review the written motion that we filed before making a ruling on that and before we move forward in our case in chief.
Mr. Baker?
We haven't got a copy of the motions, that may be nice if we got one too, but I think there's no reason to grant a mistrial because they talk about objective reasonableness. The court, we've talked about this over and over again in chambers, that objectively reasonable officer, and we made sure to stick with that standard to the testimony of the experts, so there's no basis. And the experts can't talk about Michigan law. The law's up for the judge to instruct on, so to say they weren't talking about the law, that's not their role to talk about the law, in terms of the law. That's the jury's role in terms of determining whether somebody's engaged in self-defense, and that's a question for the jury, so they stay away from that. There's actually no grounds for mistrial.
Anything else, Ms. Edmonton?
The only thing I would add is while they were testifying, they were talking about the laws and policies from other states. They were talking about what applies from the International Association of Chiefs of Police. They talked about all of these other agencies from New Mexico and South Carolina that it's not grounded or not required under Michigan law. And we outlined that in our trial brief with and attached 4 declarations explaining that that is not something that Michigan law requires or that GRPD trains their officers.
Anything else? Mr. Becker? Okay, so, I'm prepared to rule on the motions for both the mistrial and directed verdict, which incidentally, as soon as we left the courtroom, I did receive the motion, I did review the motion, and I'm prepared to move forward on both of those at this point. I mean, I can still give you a break if you need one after, but as far as a mistrial is concerned, I do not believe that the expert's testimony rises to the level of requiring a mistrial. I believe that the fact that they were testifying, they clearly were testifying on generally accepted police practices. They never held themselves out to be experts in Michigan law, and as Mr. Becker stated, it's the judge's role to instruct on what, excuse me, on what the law is, and it was the expert's job to provide opinions based on how they apply the facts in this case as they have been presented thus far to reliable principles and methods. And I believe that they did that. So, and I believe that the fact that they did not testify based on what Michigan law is, that more so would perhaps go to weight to the extent that it does not agree with what I instruct the jurors on. Also, it's ironic that you cited a Supreme Court case because obviously the Supreme Court is the court of the land, and the experts were testifying based on generally accepted police practices nationwide. And so, given that, I don't believe that their opinions or the fact that the juror heard those opinions would rise to the level of prejudicing the defense or the defendant to the extent that a mistrial should be, that I should declare a mistrial in the case. And as far as the directed verdict motion, obviously, as everyone, well, all the attorneys know, that a directed verdict of acquittal is only appropriate if after I consider all of the evidence presented by the prosecution in a light most favorable to the prosecution, I would have to determine that no rational trier of fact could possibly find that the elements of the crime charge were proven beyond a reasonable doubt. In this case, there are essentially three elements. The first is that the defendant caused the death of Mr. Leoya, that Mr. Leoya died as a result of a gunshot wound that was fired from the defendant. I believe that is obviously clear, it's on video. No one is disputing that the defendant caused the death of Mr. Leoya, at least not any of the witnesses that I've heard so far. So it seems clear that that element has been met. Also, that the second element is that the officer had to have one of three states of mind, that he intended to kill, intended to do great bodily harm, or knowingly created a very high risk of death for great bodily harm, knowing that that would be the likely result. As an officer at the time, he was clearly aware that if he put a gun to the back of someone's head and fired a round into their head, that would likely, that at least created a very high risk of death, if not evidences an intent to kill Mr. Leoya. So I believe that element, again, would be difficult to dispute given the background of the defendant as testified to thus far, as well as the video. That brings us to the only element in the court's view that is really in dispute here, and that is whether or not this killing was justified. It's clear that Mr. Leoya appears to have possession of the defendant's taser at the time that this shooting occurs. But it is also clear to the court that a rational trier of fact could find that the alleged victim, in this case Mr. Leoya, was not in a position to use the taser at the time that the shot that killed him was fired. I believe that a rational trier of fact could find that based on the video alone, but if you also incorporate testimony of not just the experts, but also other witnesses, including the witness that talked about the taser, Mr. Childs, I believe a rational trier of fact could find that the killing was not justified. And so, because that is the position of the court, I am denying a directed verdict of acquittal for those reasons, because I do not believe it to be appropriate under the circumstances. And so with that, is the defense ready to put on their case issue?
We are, Your Honor, and I had a question. We were had some stipulations. I can't recall the court's preference on the stipulations in front of the jury, or should we just do those right now and then we can move right into
You
that?
mean stipulation to admission of exhibits?
Yes, and our first witness, so the court's aware, is our video analyst, and he's going to be playing a lot of videos. So the stipulations that we're looking for are defense exhibit C, C1, C2, C3, C4, and then videos J and K. And then an audio defense exhibit HH.
Okay, I think these are all similar videos, so I have no objection here.
Okay, C was already admitted, stipulated to at the beginning of the trial. So because there's no objection to the exhibits that you just listed, I'll state for the record that C1, 2, 3, and 4 are admitted. I'm assuming they're separate exhibits from C. Also, I'm admitting J, K, and HH at this time.
And yeah, Your Honor, just so, it's HH, two H's. I don't know if I made that clear.
It's
Okay,
HH.
I'm sorry, Your Honor. I don't hear that well.
All right, and I also received the defense witness list, so I have that printed out as well, so that we'll hand that out to the jurors. And anything else before?
No, we're ready now.
Right. And anything for the people?
No, Your Honor.
All right, so we'll have them come in. And right after they come in, I'll have my clerk hand out the witness list. While your witness is coming in. May be seated. And my clerk is going to come around and hand out the defendant's witness list, much like the prosecution's witness list. I also have them do a list with names, with space for notes if you'd like to take them. And Mr. Moore, you may call your first witness.
Thank you, Your Honor. The defense calls Bob McFarland.
Good morning.
And sir, raise your right hand, my clerk will swear you in.
Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You may be seated.
If we can, I think he needs to be switched over to the cart. Is that what, this one?
should be.
Thank you, Alan. Good morning, Mr. McFarland.
Good morning.
Now, I've been referring to you for most of the trial, and you've been sitting back there, correct?
Correct.
All right, so you're a video guy?
Yes.
What's the technical term for what you do?
Forensic video analyst.
Okay, can you tell us a little bit about your background?
Yes. I was in the Air Force for about 8 years as a security policeman. From there, I served at the Oakland Police Department in Oakland, California for about 12 years. And after that, I've done litigation support at a law firm, and for almost the last decade, I've been doing forensic video analysis.
Okay. Tell us about your education and training.
I have a bachelor's degree in criminal justice management. I have several, almost 200, possibly more hours, 200 hours of training from an organization called LEVA, that's L-E-V-A. It stands for Law Enforcement and Emergency Services Video Analyst Association International. And this particular association focuses on audio and video forensics for people in that specific field. I've attended their training. There are 4 levels. You attend level 1 and level 2, similar to Sergeant Batchelor, who was here. You get a certification of a video technician. And then, since then, I've attended level 3 and level 4, which is the final level of their particular training. And from there, you go on to get certified by the organization as a forensic video analyst.
To his qualifications as an expert.
Thank you, Mr. Becker.
Did you want to have them listed for the benefit of the jury, or would you like them to simply be recognized as an expert at this point?
I think we would ask that he be recognized as an expert, Your Honor.
Okay, an expert in what field?
Forensic video analysis.
And you have no objection? Correct. Okay, so he shall be considered an expert in that field.
Okay. So, Mr. McFarland, you were asked to do work on this particular case. What was the scope of your work for this matter?
I was provided with the cell phone video that we've watched, the dash cam video, and the body-worn camera of Officer Schurr. Those 3 videos were provided to me. I was asked to put them on a screen as a multiplex, sort of all three at the same time, to synchronize them so that the actions in the videos match, so you can see, and I'll point out those synchronization points. In addition to that, I was asked to create the same sort of matrix, but do a subtitled sort of transcript along the side for the words that were spoken that I could capture on the synchronized video. From there, I was asked to create a couple slow motion, maybe 1 slow motion exhibit, and an enlarged or magnified cell phone video exhibit. And the last thing was dispatch audio file.
Okay. And you mentioned a synchronized exhibit. Tell us how you create a synchronized exhibit.
With that exhibit, there are three videos. I decompile or export each image individually as a bitmap file. Each image is a large raster file. It has a lot of information in it. You take all of the images out of each one of the video files, and then I numbered them. I labeled them so we know what camera the particular videos came from, and then I recompiled them back together. I also exported the audio files from each of the 3, put them into an audio program, and synchronized those 3 audio files and put them back into the matrix, so we have the 3 videos that play at the same time and all 3 audios.
Okay. Let's pull up the synchronized video, which is Defense Exhibit A. And it's one that has already been admitted and the jury has already seen. And before you start anything, I want to ask you some questions about Defense Exhibit A. We've been talking a lot about RFN as sort of a way to bookmark particular parts of the synchronized video. What does RFN mean?
RFN is a relative frame number. with each video, as you see the dash cam videos on screen, there's what's called an AFN, which is an absolute frame number. For instance, the very first frame you see is number 1. The very first relative frame for the overall matrix is number 1. If I scrub forward just a little bit, I'll show you. We have an AFN that's on the dash cam. That's the absolute frame number for the dash cam. And down here on the bottom, we have an AFN for the cell phone video. So the reason we have an RFN is that when you look at this matrix, you refer to this as sort of the index or bookmark for the particular video.
And how many RFN relative frames are there in 1 second?
In 1 second, this
Yeah.
particular video, 30.
30. So 1 to 30 is actually 1 second, but it's broken down 1/30th at a time. Is that
Correct. Each image is 33 1,000ths of a second.
All right. Can you show the jury a couple of the synchronization points to show them how you did this?
Sure. One synchronization point is the time when Mr. Leoya closes the door to
If we
his
get the
car.
lights,
And you can say which point you're talking about at the time you're talking about it.
Yes, Mr. McFarland, if you could continually reference the RFN number.
Yes. So I'm going to first, because the purpose of this type of tool is to use it as sort of an analytical tool. It's tough to watch everything all at once, so you want to watch one video and then the next and then the next, and then you'll want to watch them all together. So right here, if we look at RFN 3103 in the dash cam, you see in the center of the image, the light from Officer Schurr's car glinting off of the door, the driver's side door that Mr. Leoya is closing. I'm going forward a single frame at a time, and there we see it at 3107, it's closed. So if I go down to the, it's still open, let me close it. Shut right there. 3108, it's closed. In the image below, it's closed. And so when we take it out, you can see the doors open and close in both images. There's another synchronization point with the action of Officer Schurr's foot, his right foot. And I'm at 5733, I believe. Let me find it. Just a second, looking at my notes. So it's right here, when we're at 5756, we inch forward, and you look at the cell phone video, and I'm gonna bring that in so you can see what I'm talking about. You see Officer Schurr's right foot. I'm gonna back it up, and then I'm gonna move it forward, and right here we see his right foot is underneath Mr. Leoya's left leg. If I go down, and that is RFN 5760. So I go down to the body-worn camera and back it up. You see his foot disappears just because it's off the image. When I inch forward, we see it's in place at 5761, 5760.
Okay, thank you. And that was very interesting, but what's the point of doing the synchronization as a forensic video analyst?
When you do a multi-view, you want the people who are viewing what you have on the screen to understand that it's synchronized, that you're not just throwing 3 videos up there and playing them and hoping that they can understand what's happening. So you synchronize the dash cam with the body-worn camera, and then the cell phone video was only on for a short time, but I was only able to synchronize that with the body-worn camera. And so that shows that all 3 have synchronization points.
And what's the benefit of having a synchronized video?
it's a multi-view, sort of give you different angles of the incident. Because when you look at a video, you're looking at a two-dimensional image of a three-dimensional incident. When you have multiple angles, you can see what's occurring from different camera angles at the same time, simultaneously.
Can you give us an example of what you're talking about?
Yes. We could go, well, here's an example. So on the RFN 4696, I'll zoom in so we can see what's happening here. We see Officer Schurr on the back of Mr. Loya. We see his right arm over Mr. Loya's right shoulder, and it's tough to tell because it's at a distance and it's a bit pixelated, but we see sort of the same thing. But when you back out and you look at it, we also see in the distance, I believe that's Fred Butler in the white t-shirt. He's got his arm extended and he's pointing. And if I inch forward, you see the movement of Officer Schurr's left elbow come up. That's when he grabbed his radio. So I'm gonna go back to 4697, and I'm gonna go forward to 4703, and I'll continue to go forward. And we see in both of the videos, the left or the right arm of Mr. Loya come up. I can go back and forward. And then if I play it, we're at 4726. You see them both up and standing at 4810.
Okay, and you did that, you watched all the videos in a synchronized format and analyzed it pretty much frame by frame, right?
Correct.
And you also created a synchronized exhibit that includes a transcript.
Yes.
Tell us how you created that.
It is the same video, the synchronized video. I just added a section of pixels on the right side of it, and I had the audio playing in a separate program. And when words were spoken, at the time the words were spoken, they started to be spoken, I would put the sentence or the phrase into the video itself as the subtitles is what they're saying, so that the statement starts, as on the screen, starts at the same time.
Okay. And this has already been admitted as defense exhibit B, Your Honor. If you could go ahead and play that video start to finish
Yes.
at normal speed.
Yes.
Nelson, North of Grace, Everett Hall, 9367, Hamilton. Hey, stay in the car! Stay in the car! Stay in the car! Get in the car! Dude, I'm stopping you. You have a license? You have a license? I'm stopping you. Do you have a license? Do you have a driver's license? Do you speak English?
Yes.
Can I see your license?
What do you want?
The plate doesn't belong in this car. Do you have a license or no? Do you have a driver's license?
Yes.
Where is it at? Get it for me.
What do you want?
The plate does not belong in this car.
Okay.
no. Stop. Stop. Put your hands up. Stop. 1915. Yeah, we're on it. We're on it. Go, stop, stop, stop. 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 Okay. Stop. Stop. Get your hands behind your back, okay? Hands behind your back, okay? Your hands behind your back. 1950. Stop. Stop resisting.
Ain't good now, you're doing nothing, bro. Why you gotta do what up, bro? He's good, man.
Let go of the taser. Let go of the taser.
No, like he's good, like you can talk to him, bro.
1915.
Yeah, man. Like he good, bro. Like, can you talk to him like good, like, can you, yeah. Stop grabbing him like that. Nah, he good like for real. Yo, you hit him too. No, he ain't brought no taser. I see.
Let go of the taser.
How many times you got going?
Stop the taser.
Everyone. Six in total. Is this kind of stuff Nelson agree? It is.
Get back.
1915. Oh, yes. Only shooting. Nelson Green. 1915, 10-4, Nelson agrees. Starting medical. Safety 15. Nelson. Nelson Green, listen to 4. Suspect down. Nelson. North Nelson 3. Nelson, North Greg, suspect down. 1920, I've seen. 1610, Roger, subject, the access to any weapons, what do you think? 1950, Airport Taser. They're staging until we figure it out.
got the car on the driver's side. Back. All right, you two go up and clear that car. All right,
16, we're going to need a car to the northwest.
Jet 4, you're now seen heading to the north off of Oral. 1918, looks like you're coming in.
1918, hold on.
Done.
We're between 1746 and 1752. Can you call those two residents and make sure they're for that, please?
Done.
From 21st clear, we'll be moving up to record 8.
Now, Mr. McFarland, at the beginning of this video, and we've seen it several times by now, you see Officer Schurr in his car as his body cam goes on, but there's no sound. Can
Right.
you explain why that is?
The Axon Body 3 at this particular time had what's called a pre-event record buffer. And what happens with that is your body-worn camera is constantly buffering, it's capturing images. When the officer activates the camera, that only activates the audio, but what it does is save or preserve the last 30 seconds of images. So when this camera right here is on, he actually didn't activate it until 30 seconds later. These are images that were in this buffer, so to speak, for 30 seconds.
And, you know, you created this transcript. Are you the one that created the transcript?
Yes,
And you use headphones to listen?
I did.
Okay, and it's to the best of your ability, but you understand the jury's the one that decides what is actually being said.
Correct.
This isn't a certified court reporter transcript.
It is not.
All right, so you made some smaller videos related to the cell phone. That's Mr. Tuyasheme's cell phone, right?
Right.
And those are C1, C2, C3, and C4.
Yes.
Why did you do that?
When you look at the matrix or the three videos on the screen at the same time, you can see the cell phone videos sort of long and tall and distant. And the reason for the creation of the cell phone video is to crop the top just because that's where all of the action occurred. Nothing happened in the lower half of the cell phone video. So I made that so it could fit on the screen without continually zooming and in and out and such. Also, that the other two exhibits were the motion tracking for the taser wires and or the probes, and then the final one was the part of the incident in slow motion.
Okay, well, so let's start with C1. This is the cropped image. Could you play that for the jury, please?
Yes. Oops. So this is the first frame. Up here on the left, I put the RFN number, just because we've been relating to the RFN number and everything, this is the RFN number where the cell phone video lands in the synchronized exhibit.
And what is that number?
The RFN number 4146, I believe.
And that's where the cell phone video starts?
In RFN 4146, correct. I'll play it.
Hands behind your back! Okay?
You can't just you good like yo.
Put your hands behind your back.
Don't grab him like that though.
I know, but I'm just saying, man. I'm a black man too.
Yeah.
Come on, man. 1915, start with some more cards. Okay?
Now he said he's good for me, but yo, what's up, man?
Stop. Okay? Do not
No, he good, not resisting nothing, bro. Okay, why you gotta do all that, bro? He good, man.
Let go of the taser. Let go of the taser.
No, like he good, like you can talk to him, bro. Yeah, man. Like he good, bro. Like, can you talk to him like good, like, can you, yeah. Stop grabbing him like that.
No.
Nah, he good at it for real. Yo, you hit him too.
Let go of the taser.
Nah, he ain't brought no taser. I see that.
Let go of the taser. Drop the taser. Get back. Get back. 1915. I was just involved in shooting. Nelson Grant. Nelson.
Okay, and then you made additional videos from that video. Exhibit C2, can you tell us what we can see and then play the video?
Yes, this is the last part. This is a segment of the cell phone video. It is,
This is C2, right? Exhibit C2?
C2?
yes,
Yeah, you're using C2, Mr. McFarland?
I am. This is 6 seconds in length. It's the last portion prior to the shot being fired.
Go ahead and play.
Drop the taser.
And now there's a yellow box in the bottom of exhibit C2. Can you describe to the jury what you did there and why it's there?
That particular portion there, I magnified what you could see in the smaller box in the video, and that was to capture the taser in the hand of Mr. Lioya.
And exhibit C3?
This is, it looks like the same thing, same exhibit.
Is it in the same speed or is it slow?
Let's
slow
see.
motion?
Slow motion,
Okay. So that
5 frames per second,
All right, so the difference is the speed of the play.
yes. And again, this stops prior to the shot being fired, about 15 frames or half a second.
Okay. And, you know, we neglected to say the RFN numbers
Okay.
for C.
For both those exhibits are RFN 7407 through 7602.
And then there's a C4.
Yes.
What is Exhibit C4?
This is just the full length with no motion tracking. It just runs the length of the incident. Oh, I guess it does. So it's a mixture of, it has the taser wire motion tracking, and it also has the magnification part where we point out Mr. Leoya in possession of the taser.
Well, let's talk about you said it's a taser wire motion tracking. Bless you, what do you mean by that?
I put the video in my forensic software, AMP5, and I circled the images where the taser probes were present and they were being dragged across the lawn. And it's motion tracking is what it's considered when you do a single frame advance and you keep that circle over it and you go all the way to where it's no longer useful, and then you back it up and you put a different circle around the other one and you do the same thing. And then when you play the video, those filters are applied over the video to show you where those taser probes are going.
Okay, and this program that you use, it's called AMP5, it's the same one that Sergeant Batchelor uses?
Yes, AMP is just the word AMP, and 5 is FIVE. It's an acronym for Forensic Image and Video Enhancement.
Well, we don't want to see the whole video again. Could you just go to the part where you just referenced with the wires and the motion tracking?
Yes.
And reference the RFN number and then tell us what you're seeing here.
Okay, we're at RFN 5719. The yellow circle, it's kind of hard to tell now, but it's encircling one of the probes. And the reason I knew that that's where it was is because I watched this enough times and watched it go across the grass that I had to back up to where I first could see it and circle it. And then I can inch forward from RFN 5719 and you can see it move across the grass. And then you see the blue circle come on, and that's another probe, same sort of motion tracking, and I follow that as they both are.
If you could stop for a second and back up 2 frames, maybe 3. You can actually see some sort of gray-white thing dropping down. Do you know what that is?
Gray-white thing.
Is it rain?
Oh, yes, those are raindrops.
So this is slow enough, you can actually see the rain coming across the
Yes,
lens.
sort of motion blur, but you could see the raindrops as they're descending. You could also see in this on Officer Schurr's right leg, and I'll zoom in a little. Those are the taser wires. I'm not sure who they're wrapped around, but those are the wires of the taser going across Officer Schurr's right lower leg. And I can inch forward. Now we can see that they're look to be to the around Mr. Leoya. And we continue forward 5741, and we can see the probes move 5754. I lost the blue one momentarily. And I picked it back up at 5775, and I'll just inch forward and you can see the probes move. Here we are at 5790. They seem to be sort of stable. Closer together at 5809. And that's sort of where they end up. 5827.
You analyzed all these videos.
And you looked at them many times, I assume.
I did.
Okay. And you were able to find significant points like this, where the taser wires, you could actually see them sort of bouncing across the lawn.
Yes.
All right. You have the ability to take still shots and create exhibits on the stand, correct?
Yes.
All right. I'm going to ask you to do that as we go along. You don't have to make the exhibit now, but if you could we could just say, we're gonna make an exhibit now, and then make them all later, and can you put that in a file, and then we'll ask the court if we can move it into evidence?
Yes, I would do sequential images.
Okay. And we're gonna start with the majority of the moments that you're going to capture, is it from a particular exhibit, A, B, or C, or?
I would say that the best exhibit is the one with the transcript.
Okay, and that's B. So when I call out an exhibit, I'd like you to note that RFN for the record, explain what's on there, and then we'll identify it, and then I'll move it in for admission at the completion of your testimony.
Okay.
All right. And now you saw significant points. Obviously, it's not that long of a video, relatively speaking, right?
Correct.
But the advantage of blowing things up is to show the jury things that is not readily apparent from just watching either the cell phone video or the body cam.
That's correct.
All right. I'd like you to go to RFN 265. It's basically the start of the video. And play that till about 3:14. Tell us what's going on here.
Okay. So 265. This is the part of the incident where Officer Schurr is making just about completing a U-turn to pull in behind Mr. Loya, and in the distance, where my arrow is pointing in the dash cam, almost in the middle of the dash cam image, we can see a car, and that car is Mr. Loya's car. And if I play it forward, you can see the car move and also Officer Schurr accelerate. And I'm sorry, where did you want me to go to?
3:14.
Okay,
That's not very long, is it?
no.
If you could mark as exhibit, I don't think we have a B1. Just to be safe, we're going to call this B3. And if you could back it up a little bit so you could see Mr. Leoya's car. And that would be RFN 269, and that's going to be exhibit B3.
Okay.
And then further on in the video, Mr. Leoya takes a second right turn. Can you go to that around RFN 499?
Back up here.
Go ahead and play a little bit.
So we'll start at RFN 492. On the right side of the dash cam, you see brake lights. And this is Mr. Loya's car down the street a little bit, and I'll play it. And at 696, Mr. Loya completes the right-hand turn.
Okay, and we can mark that as B4, RFN 696. And then if you could go forward to Officer Schurr, calling the stop out and Mr. Leoya exiting the car.
So this is right about RFN 1020, and what you'll see here in the dash cam or the body-worn camera video, you're going to see Officer Schurr's hand coming up across toward his face with a police microphone in his hand, his right hand, and Mr. Loya exiting his car.
Nelson, North of Grace, Recovered King Hall, 9367, Hamilton. Hey, stay in the car!
And we're at RFN 1280. Could you tell the jury what they see in this part of the synchronized video?
This is Officer Schurr getting out of his car right after Mr. Loya exited his car.
Okay, and that's going to be marked as B5.
And if you could play forward until we get to where Mr. Chiyoshime opens the glove box.
Stay in the car! Stay in the car! Get in the car! Dude, I'm stopping you. You have a license? You have a license? I'm stopping you. Do you have a license? Do you have a driver's license? Do you speak English?
Yes.
Can I see your license?
What do you want?
The plate doesn't belong in this car. Do you have a license or no? Do you have a driver's license?
Yes.
Where is it at? Get it for me.
What do you want?
The plate does not belong in this car.
So I'm going to pause here at 2737,
Okay.
and I'm going to zoom in on the body worn camera. And at the, near the B pillar of the car, there's a hand that is the right passenger. And as I inch it forward, you're going to see he right there opens the glove box, and the glove box is open at RFN 2807.
And could you toggle back and forth so we can see the glove box open and close?
Yes. Closed. Open.
And the order's open, close, right? Not close, open.
Oh, I just reversed it, sorry.
And so could you find an RFM where you can see Mr. Chiyoshime's hand on the glove box?
Yes. RFN 2759.
That's gonna be B6. And if you could go forward to the point where Mr. Lelia breaks away and shoves Officer Schurr.
Yes. Okay, RFN 3317.
Okay, and what do you see on that?
You see the clenched fist of Mr. Leoya, his left fist. You can see his right hand, and you see Officer Schurr holding the left and right wrists of Mr. Leoya with his left and right hands.
Okay, if you could make that B7, what was it, RFN 3317?
Yes.
If you could go forward to the point of the breakaway.
Okay. I'll play it and then come back.
Okay.
More or less right here to 3349 where he's completely free.
Okay, and is there any point where you see Officer Schurr be shoved backwards?
Yes. So I'll go back to 3317. And then I'm going to single frame advance the images. So if we advance to 3318, we see the right hand of Mr. Leoya come closer to Officer Schurr's body-worn camera. Then his right hand breaks free from Officer Schurr's right hand, and I'm inching forward. At 3329, Officer Schurr grabs the right shoulder area of the sweater Mr. Leoya has on. And you can see in 333, Officer Schurr's hands are now sort of crossed in front of him, and you see Mr. Leoya's arms and hands are up in the area of the forearms of Officer Schurr. And as we inch forward to 3340, we can see the knuckles from the right hand of Mr. Leoya over Officer Schurr's left forearm. We can see Officer Schurr's left hand making contact with his right forearm. And then as we continue forward to 3344, we see that Mr. Leoya is completely free. But if we back up at the point of 3340, this is right around, I'm going to go back to 3338 and single frame advance and just pay attention to the dash cam. Officer Schurr, both feet are off the ground. And I go back and you can see Officer Schurr stop right there. So you toggle this action. And you see, you saw what happened in the body worn camera, but now you have it from a different angle. And I toggled that section 3345 to 3345.
You said you toggled 3345, but I think you said 3345 again. When you say toggle, you mean you're moving from frame to frame?
It's 3338 to 3345.
Okay, and do you have the ability to take multiple images and put them in one exhibit?
Yes.
Okay, and so can you mark 3338 to 3345 as B8?
Okay.
Okay, and at this point, you also have a timer, and it's in the bottom right of the exhibit B, and it keeps time to the second, and then it's 8, 12, 55, and you have .403. Now, we're not used to even the 55. Can you explain to what degree of accuracy the clock is?
So the 403 is milliseconds. Because there are 30 frames in a second, when you watch a video and you say, I'm stopping the video at 3 minutes and 55 seconds into the video, the question becomes, well, which one of those 30 images did you stop on? So that's the reason for the numbering, but also for the millisecond. If you wanted to understand timing, you would understand everything right down to the millisecond.
Okay, and you were asked to figure out some timing, and you were asked how much time it elapsed from the time Mr. Leoya exited his car to this point right here in RFN 3338.
Yes, that was approximately 1 minute and 10 seconds.
All right, and now we're going to skip forward to past the chase to the point where Mr. Leoya first gets to his feet.
Okay. We're going to RFN 3582, and I'm going to zoom in on the dash cam. And you can see, if I toggle forward and back, you can see that the legs and feet of Officer Schurr up in the air as he's on the back of Mr. Leoya. And they're both appear to be facing northbound.
That direction's north?
Going toward, from the back of the car, Mr. Leoya's car, to the front is north.
Okay. You actually figured that out?
He said somebody was running northbound.
Okay. Oh, I'm okay. All right. And so if you could toggle forward or play forward to 3778.
Stop!
I can't see the RFN when I'm zoomed in, sorry.
Okay.
So there was about right here.
Okay.
3778, and I'll zoom back in on the dash cam video. And you can see Mr. Leoya's up to his feet.
Okay, what RFN are you on?
3778.
previously had showed us in the dash cam video where Officer Schur's feet were in the air and they were headed north.
Yes.
Do you recall what RFN that was?
The first one of this,
Yeah, I forgot to ask you.
that would be 3582. Let me go back and make sure.
At this point, I'm gonna have to object. I don't know what the relevance is. They can play around with the video as much as they want in the jury room, so I mean, I was giving them some leeway, but I don't know what we're doing here.
Your Honor, I published in the jury things that the forensic analyst has either blown up, they won't have the ability to blow these up. Certainly the jury's.
What's your response to his objection about the relevance of?
I'm explaining, the relevance is, we're showing, publishing to the jury, blown up and highlighted areas that the expert is specified about. And he's explaining how he made those exhibits, and I'm making exhibits for the jury's consideration, so they can view the evidence through Mr. McFarland's work.
It's cumulative.
Sure, I mean, it's up to your discretion. That's my objection. I gave him some leeway, but this is seems to be going on.
Right, it's pretty cumulative, I believe, and, I mean, the jury will have your exhibit, so I don't know that highlighting certain portions is relevant to.
I don't know that the jury is gonna have the ability to blow anything up, Your Honor, or
Or if they want to.
well, I mean, they may not want to, that's up to them, but I've seen the TV, it's a box TV back there, and there's still ability. Certainly the jury, at the end of the questioning, can ask Mr. McFarland if they want to blow something up right now and make an exhibit.
So, I mean, what I'll do is I'll sustain the objection. This doesn't seem like a good use of the court's time to go through each frame and blow certain ones up and making them into separate exhibits. Obviously, the jury will have access to the exhibit. They can play it as fast or as slow as they would like. If you're unable to see it in the jury room for any reason, we can certainly come back out and play for them whatever they would like on the record and blow it up.
Your Honor, may I just make a record of the ones that we're going to blow up and move them into evidence?
How
And
many
then,
are there? Because it sounds like there's.
well, there are much less than the thousands that the prosecution has entered into evidence, but
Well, I don't recall them doing any thousands of blown up images.
they went through and published some of the thousands that they, I think they said it was about 1,000
Thousand what?
images. That's their exhibit. He broke down still frames, and then he's been calling them out through the testimony. And so we'd like the opportunity to do the same.
I don't recall this happening in prosecution's case in chief, but I do find that, again, this is cumulative, and so I'm gonna sustain the objection. I'm not sure the benefit of this exercise to the jury. I don't know that it's a good use of our time.
Your Honor, my client has a right to present a defense. We believe that that includes analyzing the video in front of the jury. We're far away. If these things need to be blown up, they're not going to have the ability to blow it up. I think they're entitled to see what Mr. McFarland's work has been done. There's no objection to his qualifications. There's no objections to the exhibit. But I would like to make additional exhibits that we believe are important to the defense of my client. If the court's not willing to let me publish them now, I would like to be able to enter them into evidence at a later time. I can recall Mr. Farland without publishing them to the jury. And that would save some time if that's the court's concern.
That is my concern, because this seems like it's very time consuming.
I have no objection to that. If they want to create something off-site and we can take a look at it then, that's fine. It just seems like this
Would
is.
you like to blow up certain parts of, because it sounds like you're creating an exhibit as we're sitting here with.
We are,
the,
yeah.
and I don't believe that that is something your client would have a right to do, create exhibits on the fly like this. So, it sounds like there's no problem with your witness creating additional exhibits that go along with this one to blow up the areas that you would like for him to, without us having him to go frame by frame and doing that on the record.
Okay, Ryan, what I'd like to do is, well, To save time, we'll have our coordinated, and then we can always recall Mr. McFarland and the jury if they want to pass a note that we'd like to see this part blown up or something. Certainly that's something that they can do now. It's going to be a lot easier with the software that they're not going to have unless the court is going to allow us.
Again, I'm not saying you can't put those exhibits in. I'm saying you're creating the exhibits and saying, stop at this, go this many frames, oh wait, go back, I think I forgot which one we were at. So he's creating the exhibit on the fly right now. I don't have any problem if there's no objection, especially to admitting those exhibits as they're created. I just don't think it's a good use of time to create them on the record right now. So I'm not sure. So I'm sustaining the objection to the extent that it.
It's a waste of time.
It was a bit cumulative.
Well, I don't know that it's cumulative, Your Honor, since we're we're not taking the same picture over and over again. And so what we'll do, Your Honor, is we're at B10. We had a number about 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
So you have more areas that you would like blown up.
Yeah,
for
so-
this witness, so he can do that, create that, and then you can certainly recall him, and then he can go through those particular ones, and then, I think that would be more efficient for
Okay.
the court.
Fair enough, Your Honor, we can do that.
Did you have other questions for him, or was that?
No, that's all he's doing is looking at the videos.
Okay.
Okay, I'm not gonna have you play this one, but the exhibit HH, it's already in evidence. Can you tell the jury what that is?
This is the truncated dispatch audio. We received this audio file of the communications between dispatch and Officer Schurr and other units in the field. It wasn't received in real time. It was each individual transmission put into one continuous stream. And for that particular exhibit, I took the audio from the synchronized video file and put that in an audio program called Audacity, and then I put silence in between the transmissions to match the timing of the transmissions in the synchronized video, so that when you listen to the dispatch audio, it plays back in real time.
Okay, and we'll publish that at a later time, Your Honor. And I just wanted him to explain what it was.
So you don't want to publish that now, you want to wait until you recall.
How long is it?
I think it's 4 minutes long.
It's up to you if you want to publish it now, that's fine, since it's already been admitted.
Okay, if the court's okay with that, we'll just publish it now. If you could just play HH.
down. 1915.
Nelson, North of Great, over to Paul, 9367, Dan Nelson.
Nelson and Graves.
So we're hearing nothing right now. What does that mean?
That's the time when Officer Schurr announced the car stop, and the car stop was acknowledged by dispatch. And there's silence because nobody else is providing any transmissions.
Okay, so this is only Officer Schurr and dispatch. What's dispatch?
Dispatch is the police dispatcher at the police department in the communications division. They're the ones who receive the transmission from the officers.
Got one running. Go back.
One running northbound, additional units Nelson and Griggs.
20 round. Service more cars.
1915, what's your location? What's your location?
How many cars you got going?
Everyone. 6 in total.
Is this car still on Nelson and Gray?
It is.
1915. I was just involved in a shooting. Nelson Gray.
1915, 10-4, Nelson and Griggs. Starting medical.
1915. I'm Nelson. North of Grace, I'm 10-4. Suspect's down.
1170, so we pull 23.
Nelson, north of Griggs, suspect down.
1920, I've seen. 1510, what was your subject? The access to any weapons and which way you think?
1950, that's my taser.
We're addressing one more.
1625, 10-4, addressing one more.
Why don't you start a couple ambulances, start the switch.
They're on the way, mid one. They're staging till we figure it out.
That's the end of Exhibit HH, Your Honor. And so I think the plan is for Mr. McFarland to step down but not be excused.
Right. So, sir, you may step down at this time, and Mr. Becker, I'll wait and allow you to do cross-examination once they're finished creating those exhibits, and then I believe moving for the admission and possibly publishing it for the jury, and then I'll let you do your cross unless you want to cross on what's been asked.
I have no cross right now, so unless, depends on what you present with this exhibits, but at this point in time, I would have no cross.
Okay. All right, so then you may step down, Mr. McFarland, and have your next witness.
You know, we need a break. We're not ready to call someone right now, but we probably have done by half hour.
Oh, okay.
Sorry.
Okay, so, I guess we can break for lunch now?
If that's okay, Your Honor. I know it's a bit early. Maybe people are hungry.
Okay. So then that means we start back up earlier, because we still have the same hour-long break. There's also, you have a question for the witness? So my clerk will grab it, we'll see if we need to answer it now, or if we can wait until he's recalled, because he will be recalled. I think this is a fair question, but we'll wait for lunch. Asterisks on some of the subtitles.
Good question. The comments that are, get the keys, Amy, get the keys, there were 3 comments, they had the asterisk next to them. That was there because the audio, when I synchronized the 3 audios together, the body-worn camera kind of distorted some of the sound. When you listen to those comments, they're more clear on the cell phone video all by itself. So the asterisk was there just to point out that you can hear them, but if you want to hear them better, look at the cell phone video and listen to that audio.
Great, thank you. We will take a break for lunch, and we'll come back at 1:45. It's almost 1:45. I don't know if that'll be enough. I don't know if it'll be lunch number 3 or not. But anyway, we'll make sure everyone eats. Meanwhile, if you please leave your notes again upside down in your chairs. Please remember to not discuss the case with each other or with anyone else. Also, please remember the restrictions with respect to news reports on the media, in the media and on social media. And then we'll see you back in about an hour or so.
Welcome back. I'm Lauren Baker.
And I'm Emily Scarlett.
And I'm Tanner Holbrook. Thank you so much for sticking with our coverage this afternoon.
Today is day 3 in the trial of Christopher Schurr, who's charged with second-degree murder in the killing of Patrick Lyoya. Today has been a major day, with not only the prosecution resting its case, but also Schurr's defense team filing a motion for a mistrial and directed verdict. Now, before we go into our coverage during the court's lunch break, we're going to take a listen to the full argument made by Christopher Schurr's defense team. Take a listen.
Your Honor, good morning. So at this time, the defense would be moving for a mistrial based on the evidence that has been presented so far. This is based.
Mistrial?
Yes. And this is based on the evidence that was presented in the prosecution's case in chief. And we believe that the evidence presented will prejudice the defendant to the extent that the fundamental goals of accuracy and fairness are threatened by allowing Mr. Stoughton and Mr. Bloomfield to opine on standards that are not applicable under Michigan law. As they both admitted, they don't know what Michigan law is, and that are not within the knowledge and in the situation of the arresting officer, based on tactical considerations that are not ultimately at issue in this case, including everything that led up to the ultimate issue here, which is whether Officer Schurr had an honest and reasonable belief to be in fear of death or great serious bodily injury at the moment that he made the decision to use deadly force. We also, based on their testimony, it's clear that they have not relied on proper training. They were relying on outdated policies. They were testifying about a taser model, an old taser model. They were not qualified as taser experts, and they gave several opinions about the taser. And at this point, we believe that we're too far along with the jury to simply strike their testimony, because they have heard testimony from two of the people's experts now that do not accurately, and are not nowhere near based on what the law is in Michigan, and what should be considered in whether or not Officer Schurr was justified in using deadly force. And so at this time, we would move for a mistrial on that issue. And if the court is not inclined to grant the mistrial, then we would be asking that their testimony is struck from the record. Although we don't think that would be enough, because they've heard too much now based on the tactical considerations. And under Supreme Court precedent, San Francisco v. Sheehan, the 2015 case, even under the Fourth Amendment, that it says even if the officers misjudge the situation, the court cannot establish a Fourth Amendment violation merely on bad tactics that result in a deadly confrontation that could have been avoided. Courts must not judge officers with the 20/20 vision of hindsight when they're quoting Graham versus Connor for that issue. So we'd be moving for a mistrial on those grounds. And alternatively, we would also be moving for a directed verdict based on the motions that we just filed with the court. Given the complexity of the case, we would ask the court to review the written motion that we filed before making a ruling on that and before we move forward in our case in chief.
Mr. Becker?
We haven't got a copy of the motions, so that may be nice if we got one too, but I think there's no reason to grant a mistrial because they talked about objective reasonableness. The court, we've talked about this over and over again in chambers, that objectively reasonable officer, and we made sure to stick with that standard to the testimony of the experts, so there's no basis. And the experts can talk about Michigan law. The law's up for the judge to instruct on, so to say they weren't talking about the law, that's not their role to talk about the law in terms of the law. That's the jury's role in terms of determining whether somebody's engaged in self-defense, and that's a question for the jury, so they stayed away from that. There's absolutely no grounds for mistrial.
Anything else, Ms. Edmonton?
The only thing I would add is while they were testifying, they were talking about the laws and policies from other states. They were talking about what applies from the International Association of Chiefs of Police. They talked about all of these other agencies from New Mexico and South Carolina that it's not grounded or not required under Michigan law. And we outlined that in our trial brief with an attached 4 declarations explaining that that is not something that Michigan law requires or that GRPD trains their officers.
Anything else?
No,
Mr. Becker?
No, you're right.
Okay, so, I'm prepared to rule on the motions for both the mistrial and directed verdict, which incidentally, as soon as we left the courtroom, I did receive the motion, I did review the motion, and I'm prepared to move forward on both of those at this point. I still give you a break if you need one after, but as far as a mistrial is concerned, I do not believe that the expert's testimony rises to the level of requiring a mistrial. I believe that the fact that they were testifying, they clearly were testifying on generally accepted police practices. They never held themselves out to be experts in Michigan law, and as Mr. Becker stated, it's the judge's role to instruct on what, excuse me, on what the law is, and it was the expert's job to provide opinions based on how they apply the facts in this case as they have been presented thus far to reliable principles and methods. And I believe that they did that. So, and I believe that the fact that they did not testify based on what Michigan law is, that more so would perhaps go to weight to the extent that it does not agree with what I instruct the jurors on. Also, it's ironic that you cited a Supreme Court case because obviously the Supreme Court is the court of the land, and the experts were testifying based on generally accepted police practices nationwide. And so, given that, I don't believe that their opinions or the fact that the juror heard those opinions would rise to the level of prejudicing the defense or the defendant to the extent that a mistrial should be, that I should declare a mistrial in the case. And as far as the directed verdict motion, obviously, as everyone, well, all the attorneys know, that a directed verdict of acquittal is only appropriate if after I consider all of the evidence presented by the prosecution in a light most favorable to the prosecution, I would have to determine that no rational trier of fact could possibly find that the elements of the crime charge were proven beyond a reasonable doubt. In this case, there are essentially three elements. The first is that the defendant caused the death of Mr. Leoya, that Mr. Leoya died as a result of a gunshot wound that was fired from the defendant. I believe that is obviously clear, it's on video. No one is disputing that the defendant caused the death of Mr. Leoya, at least not any of the witnesses that I've heard so far. So it seems clear that that element has been met. Also, that the second element is that the officer had to have one of three states of mind, that he intended to kill, intended to do great bodily harm, or knowingly created a very high risk of death or great bodily harm, knowing that that would be the likely result. As an officer at the time, he was clearly aware that if he put a gun to the back of someone's head and fired a round into their head, that would likely, that at least created a very high risk of death, if not evidences an intent to kill Mr. Leoya. So I believe that element, again, would be difficult to dispute given the background of the defendant as testified to thus far, as well as the video. That brings us to the only element in the court's view that is really in dispute here, and that is whether or not this killing was justified. It's clear that Mr. Leoya appears to have possession of the defendant's taser at the time that this shooting occurs. But it is also clear to the court that a rational trier of fact could find that the alleged victim, in this case Mr. Leoya, was not in a position to use the taser at the time that the shot that killed him was fired. I believe that a rational trier of fact could find that based on the video alone, but if you also incorporate testimony of not just the experts, but also other witnesses, including the witness that talked about the taser, Mr. Childs, I believe a rational trier of fact could find that the killing was not justified. And so, because that is the position of the court, I am denying a directed verdict of acquittal for those reasons, because I do not believe it to be appropriate under the circumstances.
And so you just heard that whole process of the defense putting in a motion to not only have a mistrial, but also a directed verdict, and the judge denying that. I want to know your guys' opinion. What was your response to that?
Well, I think this was something that we knew could happen after our conversation with expert Andrew Rodenhouse. He is an attorney here in Grand Rapids. He's been kind of walking us through this trial this entire time. He did make the case this morning early when we were on at 8:30 that this is something that we could see. I don't think it's something that we were expecting necessarily to just outright happen. Not only a mistrial motion there, but also that the directed verdict. You know, I think that that was something that we anticipated, but weren't expecting.
Yeah, even Andrew Rodenhouse, you know, Lauren was like, whoa, this is a bombshell that this could happen today. And Andrew's like, well, wait a minute, don't get too ahead of yourselves. I don't think he expected that this would happen the way it did.
Yeah, definitely. It's also interesting to see the case that they were putting up. You know, like he had said, that the directive verdict was something that could happen, but a mistrial and the reasoning for the mistrial, I thought that was interesting because I wasn't even thinking that.
Well, she's citing, you know, these are two experts, the two at the very end of the prosecution's case there. She was citing that basically their testimony should not be admitted. One of the reasons specifically being that they're not experts on Michigan law. They're also not experts on GRPD practices. So it was very interesting to hear them lay that out. But when the judge, Christina Mims, went to go in and make her ruling on that, and then the defense saying, you know, I'm going to cite a Supreme Court case here to kind of push this along. The judge is like, well, it's interesting you're citing the law of the land here because this is exactly what you've told them that you don't want them to comment on is the law of the land.
Right, because those experts were referencing what the judge referred to as standard practices, which is what the defense was taking issue with. They're saying that doesn't necessarily apply here in Grand Rapids. But as Tanner was saying, the judge is saying, well, then why are you then referring back to the Supreme Court, which is the law of the land, and maybe would coincide with these standard policing practices that these experts are referring to.
I also think what was interesting is how fast this whole process went.
Absolutely.
You saw the defense come in very quickly after the jurors were escorted out. We have that confirmed that the jurors were not there.
That's an important clarification because we were very, like you said, it was happening very, very quickly, and so we were not able to see the moments when the jury, obviously we haven't seen any moments with the jury, but we were not able to discern whether the jury was in the courtroom or not. So that is an important clarification.
And I think also what's interesting is that when Andrew first spoke about this, he said that if they were to do the directive verdict, that the judge would need time to look at those motions, but she already had those motions. I think the only person who didn't have the motions or a copy of it was the prosecution.
And I think she even mentioned that, the judge, that, you know, typically this would take more time, but I'm ready to rule on these motions at this moment. And also interesting, you know, Andrew Rodenhouse, he mentioned to us the possibility of this directed verdict. I think we were all sort of surprised with the defense coming with this 1-2 punch, not only requesting the directed verdict, but the mistrial as well at the same time. And again, going back to this expert testimony that the defense objected to before these witnesses took the stand. So again, just this repeated effort of saying, we don't think it's fair for the jury to be hearing this information. And that was part of their argument for the mistrial and a directed verdict, saying the jury's heard too much. We can't go back on what they've heard so far. The judge disagreed.
I think that if you're going to take anything away from that scuffle that happened with those two motions is that the defense is absolutely opposed to the testimony that those two expert witnesses have given. And of course, not only have they made that clear with the pretrial motions made in court itself, but also with now these two motions to rule a mistrial and as well as a directed verdict. So very interesting stuff. We could have seen the court case end here, and we didn't. Of course, the defense has called their first witness.
And one thing that Andrew had spoken about on Monday is how this case will come to life on its own. We'll see it start to take patterns that maybe you weren't expecting. And those two motions together, which I also think is interesting because they're kind of saying different things. On one hand, they're saying there's not enough evidence to prosecute him, but then on the other side, they're saying, well, this evidence doesn't actually apply. So, you know, so I thought it was interesting that they decided to do both.
And then going into the judge's response, her reasoning for denying these motions, at least for that directed verdict, we talked earlier about her saying there were 3 issues that needed to be met in order for her to approve that motion. She was saying the first being that the defendant caused the death. She's saying that's pretty sure. We know that Christopher Schurr shot Patrick Lyoya in the back of the head. No issue with that. The second, that there was intent to kill or cause great bodily harm or create this high risk of death again, the judge saying, no question there whether or not that happened. With Christopher Schurr being a police officer, he would likely know that putting a gun to the back of someone's head could cause death. Anyone really would know that, whether you're a police officer or not. It was the third element that she was saying that there was possibly some question there. And that was, again, we mentioned this, the judge saying, yes, it has been established that Patrick Lyoya, had hold or had his hand on the taser at the time of the shooting. The question is, would Patrick Lyoya actually have been able to use the taser?
Yeah.
And so that was that third element she was saying maybe was in question, but again, all of those reasonings was why the judge said she denied that directed verdict.
Again, with that third element that you were speaking of, the taser being called back into question as it has been on both sides, the defense and prosecution have talked a lot about that taser within those first 10 witnesses. And we even kind of got into the taser a little bit too in the video, in the first pick for the witness from the defense side. We started to get into a little bit of that as well. But again, it's central argument that taser is in this entire case.
And what you just brought up a good point is that the defense has now started with their witnesses. Once that they decided on those motions, they did rest for a little bit, and then the defense came right back with their first witness. His name is Nicholas Bloomfield. He took the stand and he began testifying, but excuse me, actually this is another person that we're talking about.
Robert
McFarland.
Yep.
So I'm looking at the wrong notes. You can see how many people we're having to go through. But again, he was able to start testifying today. I think we have that sound ready to go in just a few minutes. So we're going to take a listen to that right now.
You have the ability to take still shots and create exhibits on the stand, correct?
Yes.
All right. I'm going to ask you to do that as we go along. You don't have to make the exhibit now, but if you could, we could just say we're going to make an exhibit now and then make them all later, and can you put that in a file, and then we'll ask the court if we can move it into evidence?
Yes, I would do sequential images.
Okay. And we're going to start with the majority of the moments that you're going to capture. Is it from a particular exhibit, A, B, or C, or?
I would say that the best exhibit is the one with the transcript.
Okay. And that's B. So when I call out an exhibit, I'd like you to note that RFN for the record, explain what's on there, and then we'll identify it, and then I'll move it in for permission at the completion of your testimony.
Okay.
All right. And now you saw significant points. Obviously, it's not that long of a video, relatively speaking, right?
Correct.
But the advantage of blowing things up is to show the jury things that is not readily apparent from just watching either the cell phone video or the body cam.
That's correct.
I'd like you to go to RFN 265. It's basically the start of the video.
Okay.
And play that till about 3:14. Tell us what's going on here.
Okay. So 265. This is the part of the incident where Officer Schurr is making just about completing a U-turn to pull in behind Mr. Lyoya, and in the distance, where my arrow is pointing in the dash cam, almost in the middle of the dash cam image, we can see a car, and that car is Mr. Lyoya's car. And if I play it forward, you can see the car move and also Officer Schurr accelerate. And I'm sorry, where did you want me to go to?
3:14.
Okay.
That's not very long, is it?
No.
And if you could mark as exhibit, I don't think we have a B one. Just to be safe, we're going to call this B3. And if you could back it up a little bit so you could see Mr. Lyoya's car. And that would be RFN 269, that's going to be exhibit B3.
Okay.
And then further on in the video, Mr. Lyoya takes a
second right turn, can you go to that, around RFN 499?
So I'm gonna back up here.
Go ahead and play a little bit.
So we'll start at RFN 492. On the right side of the dash cam, you see brake lights. And this is Mr. Leoya's car down the street a little bit, and I'll play it. And at 696, Mr. Leoya completes the right-hand turn.
Okay, and we can mark that as B4, RFN 696. And then if you could go forward to Officer Schurr, calling the stop out and Mr. Leoya exiting the car.
So this is right about RFN 1020, and what you'll see here in the dash cam or the body worn camera video, you're going to see Officer Schurr's hand coming up across toward his face with a police microphone in his hand, his right hand, and Mr. Leoya exiting his car.
Nelson, North of Graves, recovered King Hall, 9367, Hamilton. Hey, stay in the car!
And we're at RFN 1280. Could you tell the jury what they see in this part of the synchronized video?
This is Officer Schurr getting out of his car right after Mr. Leoya exited his car.
Okay, and that's going to be marked as B5. And if you could play forward until we get to where Mr. Chiyoshime opens the glove box.
Stay in the car! Stay in the car! Get in the car! Dude, I'm stopping you. You have a license? You have a license. I'm stopping you. Do you have a license? Do you have a driver's license? Do you speak English? Yes. Can I see your license? What do you want? The plate doesn't belong in this car. Do you have a license or no? Do you have a driver's license? Yes. Where is it at? Get it for me. The plate does not belong in this car.
So I'm going to pause here at 2737, and I'm going to zoom in on the body worn camera. And at the near the B pillar of the car, there's a hand that is the right passenger. And as I inch it forward, you're going to see he right there opens the glove box, and the glove box is open at RFN 2807.
Can you toggle back and forth so we can see the glove box open and close?
Yes. Closed. Open.
And the order's open, close, right? Not close, open.
Oh, I just reversed it, sorry.
And so could you find an RFM where you can see Mr. Chiyoshimi's hand on the glove box?
Yes.
Yeah, at this point, I'm gonna have to object. I don't know what the relevance is. They can play around with the video as much as they want in the jury room, so I mean, I was giving them some leeway, but I don't know what we're doing here.
Now, I'm posed to the jury, things that the forensic analyst has either blown up. They won't have the ability to blow these up. Certainly the jury's.
What's your response to his objection about the relevance of?
I'm explaining the relevance is, we're showing, posed to the jury, blown up and highlighted areas that the expert may specify. And he's explaining how he made those exhibits, and I'm making exhibits for the jury's consideration so they can view the evidence through Mr. McBrown's work.
Sure, I mean, it's up to your discretion. objection, that's my objection, or I gave him some leeway, but this is going to be going on.
Right, it's pretty cumulative, I believe, and, I mean, the jury will have your exhibit, so I don't know that highlighting certain portions is relevant to.
I don't know that the jury is going to have the ability to blow anything up, Your Honor, or
Or if they want to.
well, I mean, they may not want to, that's up to them, but I've seen the TV, it's a box TV back there, there's no ability. Certainly the jury, at the end of the questioning, can ask Mr. McFarland if they want to blow something up right now and make an exhibit.
So, I mean, what I'll do is I'll sustain the objection. This doesn't seem like a good use of the court's time to go through each frame and blow certain ones up and making them into separate exhibits. Obviously, the jury will have access to the exhibit. They can play it as fast or as slow as they would like. If they're unable to see it in the jury room for any reason, we can certainly come back out and play for them whatever they would like on the record and blow it up.
Your Honor, may I just make a record of the ones that we're going to blow up and move them into evidence?
How many are there? Because it sounds like there's.
Well, there's much less than the thousands that the prosecution has entered into evidence, but
Well, I don't recall them doing any thousands of blown up images.
they went through and published some of the thousands that they, or I think it said it was about 1,000
Thousand what?
images. That's their exhibit. He broke down still frames, and then he's been calling them out through the testimony. And so we'd like the opportunity to do the same.
I don't recall this happening in prosecution's case in chief, but I do find that, again, this is cumulative, and so I'm gonna sustain the objection. I'm not sure the benefit of this exercise to the jury. I don't know that it's a good use of our time.
Your Honor, my client has a right to present a defense. We believe that.
And you just heard the first witness for the defense, the first of possibly many. We could hear up to 40 people that have been submitted for the defense. We're going to go now to 13 on your sides. Callie Lichter, Callie, a lot has happened today. What are some of your key takeaways so far?
Well, I think that, two of the biggest takeaways for me personally was hearing the rest of the testimony from Nick Bloomfield, who we knew was also going to be a controversial witness for the defense, and then also those two motions that were filed by the defense, the motion for mistrial and then for the directed verdict. Now, again, those things aren't necessarily common, they're not uncommon, it's just another tool that's used, by usually the defense, because they're trying everything that they can do to help their client, in this case, Christopher Schurr. But those two definitely stood out, and even though the cross-examination and the testimony that we heard from Bloomfield this morning wasn't the longest, it didn't go on for 4 hours like we saw yesterday with Seth Stoughton, it was, still very impactful, and I think we really started this morning off with a punch, Lauren.
Most definitely, Callie. And I wanted to get your perspective on those two different situations. It seemed like there was a lot of emotion in the two, not arguments, but back and forth between the prosecution, judge, and defense.
Just to be clear before I start, talking, because I can talk about this forever. Are you talking about the two motions that we heard earlier today?
Yes. Mm-hmm.
Okay. So, with these two motions, they, like you said, there was a lot of high emotions in that courtroom. I think that's kind of how we're trending in this trial. Again, like I've been saying this whole entire time, there are the two clear views that we have in there, and it's just that little difference, the intention, and then also, was it justifiable? And so, of course, we've seen from the past couple of days before the trial that the defense did not want Stoughton and Bloomfield to take the stand, and time again, they've been denied by the judge. The judge kept on saying they can be expert witnesses, they can be on the stand, and this was kind of, their last attempt to try to, strike their testimony. That was the basis for the mistrial part. The defense believes that both Stoughton and Bloomfield, their testimony would, perjure their client, or perjured their client, that their testimony was prejudicial, and by the jury hearing both of their testimonies, it would highly sway their way against their client. And so they said they wanted their testimonies struck from the record. So to be removed from the record, to act like, that's never happened, so that the jury members wouldn't take that into consideration. But they were also claiming that at this point in the trial, they were too far along to strike those two witnesses, to strike their testimonies. So that's why they were calling for a mistrial. They were saying, they believed we couldn't continue the trial unless we couldn't continue the trial if these two witnesses were still on the record. And then, immediately after, they kind of went into that directed verdict motion, which was something new that I heard today. Again, I'm not an attorney, I'm not a lawyer, but the directed motion, after talking to some experts on this, the directed verdict, should I say, is when they are claiming that after we've heard all the evidence from the prosecution, we heard Becker rest his case, that the jury, wouldn't be able to come to a verdict, that they didn't hear enough from the prosecution in order for the prosecution to make their case, make their claim. So at the end, when Judge Mims says, all right, I can make my decision on both of these, both on the mistrial motion and on the directed verdict motion, she said, I believe that these two testimonies were fair. She brought up, the defense also brought up, these two witnesses were talking about generally accepted police practices due to kind of like a national standard. They're not talking specifically about Michigan law. The defense said that they should, be referencing Michigan law. They're not experts in Michigan law, so they shouldn't be taking the stand. But while the defense was making their case for mistrial, they cited the Supreme Court of the United States, which is a national law of the land. And Judge Mims says, you're saying that they can't bring their expertise to the stand with this nationally recognized, kind of police practices, but you cited the Supreme Court in your decision. So she did end up, striking down, saying, I will not, agree to this motion for mistrial. And when it came to the directed verdict, she went through, the different things that the prosecution has to prove for their case, including, that intention and, was this unjustifiable? And when judges are asked to make directed verdicts, they have to kind of err more on the side of the prosecution because that's all they've heard so far. And so she kind of went through her justification for each point, and she came to the conclusion that based on what she's heard, at least, again, she's not speaking to the jury. For the jury is the ones who make the final decision in this case. The judge said based on what she's heard, she believes that the prosecution accurately represented their case, Lauren.
I wanted to ask you about the defense's first witness that we saw today. At some point, it seemed like there was a discussion about the evidence that they were bringing into the case, or rather the clips they were bringing into the case, and the prosecution either wanting to be shortened, or can you kind of break down what happened in that situation?
So it's from, what I'm observing, what I'm hearing, what's going on in the courtroom, that the defense was trying to almost create evidence to put into the file as we were going through the trial. So we're kind of going through, clip by clip, and, it's no surprise. It was taking a fairly long time. We're going through a couple seconds at a time, replaying those, zooming in on those, slowing down those, taking clips. So that's kind of what we were seeing on that end. The prosecution had an objection which was sustained about, it was almost an objection to just keep on moving things along. But Borgula did say, my client has the right to share the evidence. The defense has the right to share the evidence that, the defendant, in this case again, Schurr, needs. And so he was arguing that this is completely necessary because they're allowed to share what evidence they believe helps their case. So at the end, kind of before we went into that lunch break, that was kind of the discussion there about, calling in Robert McFarland, who's the expert who we heard from, and later, he can kind of get his bearings. We can kind of do this on the sidelines until he can get called back in. So there's been a lot of discussion about that. So that's kind of what was going on from what I was able to see, Lauren.
And Callie, I know you're live at the courthouse and they will be resuming soon. So we're going to let you get back inside the courthouse. We again appreciate all of your reporting during this trial. And we have a team of experts who have been watching this trial, and we'd like to bring them in now. First, we'll introduce Tanya Cross-Phelan. She's the Associate Dean of Academics at Cooley Law School here in Michigan and has been teaching at the college for 20 years. She's a grad of Ferris State and has worked as a criminal defense practitioner and assistant public defender. Also joining us is Andrew Rodenhouse of Rodenhouse Law Group. Andrew is a trial attorney and graduate of Hope College. He received his Juris Doctorate degree from Cooley Law School and oversaw the appeals in the case of People versus Ackley, which changed Michigan law as we know it. And finally, we have Sarissa Montague. She's a criminal defense attorney with much experience in providing defense for those who are unable to afford their own. She is highly regarded as not only an exceptional litigator, but also an empathetic counselor. All three join me now. Thank you so much for joining me again, everyone. A lot has happened. I want to jump straight to Andrew, because Andrew, we talked to you before this these two motions were filed. What is your reaction just right off the bat?
Exactly what I anticipated. I know that some people were like, wow, how did he predict that? It's like, well, every person who's ever tried a case could have predicted that. And so it's a very common thing to ask for a directed verdict. What's more uncommon though is, and we can talk about the motion for a mistrial, and again, it's kind of a different iteration on what they've been claiming all along about these experts. The one expert that I was watching yesterday, and it continued this morning, they were talking about, you know, what officers need to do, and the motion that they brought was based upon a Supreme Court case where it says that, you know, officers aren't held to any different standard than lay people. But what the Nick Bloomfield said is that officers need to articulate the reason why they did this. Well, how does that mesh with your right to remain silent? What if Mr. Schurr decides he wants to remain silent, and now all of a sudden we've had an expert say that he has to take the stand? I think what he's referring to is what's known as a Garrity statement, which if you rewind all the way back to Monday, I had mentioned that officers typically are required to make a statement, but that those statements are internal, that they're not public, and that those statements are confidential and only get used if the officer takes a stand and testifies differently than what statement he made initially to his superiors. So that was just my kind of takeaway on it.
And Tanya, I want to bring you now in. What is your reaction to seeing these two motions filed? Are you surprised? Did you see it coming like Andrew? What are your thoughts?
Yes, good afternoon. Like Andrew, I fully expected the defense to move for a directed verdict. That is very common in criminal cases. And the judge's analysis went along the lines that I think we all anticipated it would, whether or not taking the light in the evidence most favorable to the prosecution, could a reasonable jury find that the elements had been satisfied. So when she was talking about those 3 points, death, causation, intent to kill, and lack of justification, she's really referring to the elements of the crime that the prosecutor has the burden to prove beyond a reasonable doubt. So that's how those two concepts connect together. So I wasn't surprised by that. What is more uncommon is to see a motion for a mistrial at the same time. However, the basis for that motion for mistrial is consistent with the legal arguments the defense has been making for quite some time, both pre-trial, during testimony, and at the conclusion of the prosecutor's case. So their argument against the experts the prosecution put forth has been consistent from the get-go. And I want to point out, I think it's really important because a lot has been made of this so far, is when we're talking about those two experts referring to national standards of police, what's reasonably accepted nationally, that's a very different concept. And the reason they're fighting so hard against that is because when we look at the elements of self-defense, it's not about a national standard. It's about this particular officer and what he was thinking at the time subjectively, and was it reasonable for him to think he needed to use deadly force. So when making the motion, when Ms. Hamilton was making the motion for mistrial and was referring to Supreme Court case law, for the judge to take a swipe at her, saying, I think it's ironic that you're now referring to national standards, was really mixing apples and oranges. And I'm glad that that was outside the presence of the jury, because that could have been seen kind of as a negative slapdown of the attorney. When we're making legal arguments as lawyers, we do refer to the Supreme Court because it is the law of the land, and Michigan law regarding the law has to meet those standards set forth by the Supreme Court. So I just wanted to make that point, that those were apples and oranges.
And I also want to bring in Sarissa. Sarissa, after watching and seeing those two motions filed, what was your initial reaction to that?
I agree with both Andrew and Tanya. It is very common, if not expected, for a motion for directed verdict to be filed. We have to do it in every case. And I think Tanya's analysis of the motion for a mistrial was interesting and kind of spot on. You know, as lawyers, what people need to remember is that we're fighting the case for what we want to win at every step of the way. We're filing stuff because we want to be successful. And the other thing that we're doing, though, is creating a record. And that record is going to be used, God forbid, there is a conviction. And I say, God forbid, if you're on the defense side, you know, if there's a conviction, that record is then going to be reviewed by higher courts, the Court of Appeals, the Supreme Court, whatever it might be. So it's very important for us to make sure that we cover everything that we need to be doing as effective lawyers to make sure that we're protecting our client both in the courtroom and then in the future courtroom, should that be. So you know, that's a reason to do a directed verdict. It's a reason, again, we want to win, we're filing it because we're hope that we're successful, but if not, it's also something that helps down the road, should there be a down the road.
And Sarissa, I want to ask you about the appeal process and building that case, even in this current trial. Is it something where once the motion is filed, that anything that happens after that motion is used or solely focused on for the appeal? Is it the whole entire process? I guess, can you explain to us how you're able to build that case once that file is motioned for the appeal?
Sure. So it's not specific to that motion, okay? Whenever there's a case, and if a defendant loses at a case and they lose at trial, they have an automatic right to appeal their loss. And so it goes up to the Court of Appeals. And what the Court of Appeals does is reviews the entire record of a case. That consists of what happened pre-trial and what happens during trial, right? So there's not another trial at that point in front of the Court of Appeals. The Court of Appeals never gets to hear live testimony. So what the only thing that they can do is review the record. And again, that spans for the entirety of the case. And so that motion is part of that record. And maybe there was a problem that should have been addressed. And it's possible that, you know, the trial judge makes a ruling in a certain way, and it's possible that an appellate court might see the same issue a different way and come out to a different conclusion. And so you have to make sure that a record is very, very strong so that the Court of Appeals, again, you never want a case to get to the Court of Appeals, but if it does, you make sure that that record is as strong as possible so the Court of Appeals has what to look for.
And Tanya, I want to go back to you because you were able to confirm to us very quickly that the jury was not in the room when those two motions were filed. But I wanted to ask, does this put anything in perspective for the jurors? Does this make them sway either way? Or even have they even heard the filing of the motions? I guess, how does this impact what the jury is now thinking?
A great question. These types of motions are specifically held outside of the presence of the jury because we don't want the arguments that we're making legally to sway what they're hearing and what their decision-making process will be. Because in a trial, the jurors determine the factual outcome. The lawyers and the judges deal with the legal issues and analysis outside of the presence of the jury, again, for the specific reason that we don't want it to impact their factual determination of the case.
Got it. And I wanted to ask you, Andrew, about the comparison of a mistrial versus a direct verdict, I think there's some questions of, are they the same thing? Do they, filing at the same time, does that kind of like zero them out? Or I guess, is there really any comparison to each other if they're filed at the same time?
Well, that's there's a big distinction between the two. And so if you get a directed verdict, what that means, it's a directed verdict of acquittal, and you can't be retried again because jeopardy attaches. Versus if it's a mistrial, it would depend on who caused the mistrial. If it's just a general mistrial, then we would start the process over. We would correct whatever was wrong, and we would do it again. Pick a different jury, do a lot of different things. If it's caused by the prosecution, then it can result in what would essentially be a mistrial with prejudice attached. And that would act as if it was a directed verdict because jeopardy would have attached, and then you couldn't be retried for it under the double jeopardy rules. And so there's a distinction. It's possible you could end up with the same outcome. The most likely outcome, had the court granted the mistrial, would just simply have been a new trial. And that's why courts are loath to do it. I mean, it makes sense why Judge Mims would say no. She's already ruled on this a couple of times. But you know, it's important for appellate review, because the last thing you want, the worst thing that you can be as a trial lawyer is to be found by a court to be what's known as quote unquote ineffective. And if you're ineffective, man, that follows you around, and people know about it in the legal community. And so you do everything you can. Like Sarissa said, you're fighting, and you're going to file, move, whatever you need to do to prevail. And the worst thing that can happen is the Court of Appeals says, oh, if he had only raised that one objection or only done that one thing, then we could have ruled in your favor, but you didn't. And so, oh, you were ineffective. And that's not something anybody wants. And
so in your opinion, is it okay to file more than one motion versus like a mistrial and a direct verdict? Okay.
Yeah, in fact, in criminal law in Michigan, there's no such thing as a frivolous motion. You can challenge every aspect of the prosecution's case. Where in civil court, you know, you file a motion that the court's like, there's no way you had a chance of winning. Why are you filing this? You're just making everyone do work. The opposite is true in criminal court. You file as many motions as you want, just simply because it's the prosecution's burden and the stakes are so high. So there's no such thing as a frivolous motion. And I'm not saying that these two motions were frivolous. I think that they're well-grounded motions. And so, but there's a reason you do it.
And Tanya, I want to ask you, we saw the defense brought these motions on after the prosecution rested their case. On the flip side, is the prosecution also allowed to ask for a mistrial or a direct verdict once the defense rests their case? And what is that process like?
Well, certainly a prosecutor can ask for a mistrial. It's very rare, at least in my experience, it's very rare for a prosecutor to ask for a mistrial, but they can. And it would be very similar to what we saw play out in this particular case, but they would be alleging some kind of wrongdoing on the side of the defense, or the defense introducing evidence that somehow prejudiced the jury and how they would listen to and deliberate about the facts that had been presented.
And Sarissa, is it risky to file these motions at this time? You know, when I hear the possibility that if I put together a direct verdict motion and it's approved and it doesn't go my way, to me, that scares me. But obviously, I'm not a lawyer, so break down maybe the risk factors of these motions.
Yeah, there's absolutely no risk to the defendant by filing those motions. I guess the only risk would be, you know, irritating the judge. But every judge, every trial judge expects that at the close of the prosecutor's proof, the defense is going to file a motion for directed verdict. It is just going to happen. It is going to happen pretty much in every single case. And if it doesn't, then the lawyer, unless there's extenuating circumstances, you know, the lawyer's kind of at risk of being found ineffective, like Andrew just said. So there's no risk at that at all. And as for the motions, there's no risk in filing motions. And in fact, if something else came up that the defense thought was problematic, they could file another motion for a mistrial. Or they could have filed 4 motions for mistrials if they had different reasons to, upon which that they were based, right? So there's no risk at all. You hope that maybe one will be successful. I don't know that you expect that to happen, but you certainly hope each and every time. But no, there's no harm done to a defendant by filing motions that are legitimate. There's just no harm done with that.
And Andrew, I want to ask you about the timing of all this. To some of us in the newsroom, it felt like it was very quick. It was like the jurors left the room and the defense got up right away, made their claims. I think we even heard the prosecution maybe say they didn't have a copy of the motion, and then the judge say that they already had the motion and were ready to talk about it. We were thinking that if they did decide to do this direct verdict, that it would take some time. Is that normal to see that happen that fast?
In fact, the normal is that you don't even file anything. The normal is you just orally make a motion at the close of the prosecution's proofs. Everyone knows it's coming. I mean, there's like Sarissa said, I mean, you do it in every case. So everyone expects it. And most times people don't actually file a formal written motion. You make an oral motion on the record. And the court reporter, takes the motion, and the judge listens to it, and the prosecution responds, and it's usually fairly quick. And sometimes you're just doing it just to preserve something for appellate reasons, and you don't expect to prevail. So it usually doesn't take, in most trials, it takes less than 5 minutes to make the motion, and maybe 10 minutes to have the judge hear the opposing side and make a ruling. So it doesn't take very long. It doesn't cost the court a lot of time, and they understand that every attorney has to do it.
And we spent a lot of time on these motions. I want to move to the next testimony that we saw, which is the first witness for the defense. During that time, we saw almost not a scuffle, but a discussion rather about some evidence being admitted in, like as they were going through the clips from this witness. Tanya, can you break down essentially what happened, what the complaint was, and then why they decided to ultimately not do what they did?
Well, yeah, so this is really interesting, and I'm really curious to hear what Sarissa and Andy have to say about this. But what the defense was trying to do with this particular video expert was to slow it down so that the jury could slow it down and magnify in certain points what exactly was transpiring, how the two were positioned relative to one another, what was happening with the taser, all of that. Because although we saw a lot of the video played during the prosecutor's case, it wasn't slowed down to that degree. And the defense really needs, I think, for their argument, for the jury to be able to see pinpoints in time and pinpoints in behavior. And the other thing that the defense expert, Mr. McFarland, did with the videos that we did not see in the prosecutor's case is that we now had a transcript running alongside of it, and they were put simultaneously, right? They were put together in a way that they were running at the same time. Now, why the prosecution objected, I think, is twofold, really. I think they were objecting to it being cumulative, which is an objection that can be made. It's a legitimate objection where the party is saying, look, judge, this is cumulative. We're just going over the same thing again and again and again. And then that ties into the second part of the objection, which is this is wasting the court's time. The defense responded by, hey, wait a second. We're allowed to put on a defense, and our expert is doing this in a particular way that is going to show what we're trying to argue on defense. So that was a really common objection on both sides. What bothers me about what happened, and again, I really want to hear what Sarissa and Andy have to say about this, is this argument that they can't make it while they're doing it. It is very common. I don't know how many trials I was involved in where the prosecution is having witnesses mark exhibits, draw on diagrams, and everything like that in real time. And to a certain degree, that's what the defense was doing here. What the judge ultimately ruled was, hey, I agree, we shouldn't be making making these exhibits as we go. Have your expert go ahead and show what you want it to show, bring them back in, and we'll introduce the exhibits that way.
And so I have to ask you real quick. I do want to hear from Sarissa and Andrew, but what is your reaction to that? I mean, if that was you and that's the decision you made, are you now frustrated because you're feeling like you're not able to make your case?
Well, for me, no. That would make me more determined to then, when we take the recess, that I'm going to go and have my witness actually do what the judge said he could do, and we're going to bring it back in and we're going to make the best of it. So I think most trial lawyers on either side of a case, we're prepared for those contingencies. Okay, what happens if the judge doesn't let it in? How am I going to get around it? How am I going to try to come at it at a different angle?
And Sarissa, I want to hear also your response to all of that happening here today.
Excuse me, I actually thought it was really interesting that the defense was trying to get the evidence in the way that it was doing it. And Tanya, I understand what you're saying. It's not so different from marking an exhibit. I mean, that happens all of the time. People draw on maps, or they mark a place on where a car was, something like that. That happens all of the time. And what's interesting is that this is kind of a modern day way of doing that, but it is slow. And so I thought it was a strategic decision. I thought it was a strategic decision, and I could be completely wrong on this, but this is what my take on it was, that the defense was making a strategic decision for some reason to try to get the evidence to the jury in the way that it was trying, through the expert sitting on the stand, creating the exhibits as they went forward in open court. And the strategic decision is, why did they decide to do it that way versus having these exhibits prepared in advance, just like the judge now has told them to do, and they're going to go and they're going to do it? Why didn't they do that initially, right? What was the decision making in trying to proceed in the manner in which they did? So that's what I found as striking. Again, maybe I'm wrong, but maybe that it would, but maybe there was a different reason for it. But that's how I took it. And they're going to go back and they're going to make the exhibits, and it's going to be perfectly fine. They're going to come in and they're going to show the stuff to the jury. The judge didn't say you can't do it. The judge just said you can't do it in the manner in which you are trying to do it. It's taking too much time, right? And so they were prepared for that. The defense had, I'm 1,000% confident that the defense was prepared that the judge might rule that they couldn't proceed in the manner in which they wanted to, and so therefore they had a contingency plan in place. But I don't know that we'll ever know the answer to why did it start this way. But I thought it was really interesting.
Well, Sarissa, I have to ask, when people do that, whether it's marking or clipping clips, screenshots in real time in front of the jury, does that make the jury kind of think about what's happening more? I mean, if you show someone a picture, they'll have a thought right away. But if they're stopping, doing this process in front of them, does that make the jury give the jury idea of saying, oh, I didn't see that before. Oh, maybe I should think about this. Like, how does that impact the jury?
So the jury, the amazing, terrible, wonderful, horrible thing about trial work is that you never know what's in the mind of jurors at any given point, right? So some jurors might have the same question that I did. Why did they try to proceed in that manner rather than a different manner? Some jurors might say, why are you wasting my time? Some jurors might say, oh, I like the way that he was doing it. I'm sorry that we can't proceed. We have no idea what the jury or each individual juror is thinking. And to the extent that they were, worried that, oh my God, this is taking forever, great for those jurors, to move this along quickly. But then if you have the ones who are like, oh, I really liked the way that this was going, this made a lot of sense, then that kind of stinks because, they don't get to go forward in the manner. But we have no idea individually how they're responding to it.
Andrew, I have to finally come to you to ask you also about this situation. What was your reaction to it?
My first thought was when Mr. Becker made the objection. My first thought, I was reminded of the movie Animal House, where they said, "Hey, they can't do that to our pledges. Only we can do that to our pledges." To to Tanya's point, the prosecutors do this all the time. And the fact that suddenly he's concerned that this is taking too much time, I don't know why the defense was proceeding in that fashion. I have to believe it's strategic. But it's routine for somebody to create an exhibit in trial just using the testimony. We do it all the time using whiteboards or markers, and we'll just like, okay, your testimony is this, give me the timeline. I've created timelines and just you mark it as an exhibit so you can submit it to the jury. And so it's not abnormal. The fact that he objected as it's quote unquote cumulative, it's like we're all going to see these videos 1,000 times by the time it's done. And the fact that the defense has an expert that can break it down into a way that's easier for everybody to understand and to get to the nuances, it sounded to me like, hey, we don't want the best evidence. We want people to not see this, and because it's bad for us. And it sounded like I don't know. I mean, if the job is to get to the truth, then why wouldn't we want to break it down and see it in a way that we can understand? Like when Chris Schurr's on the street with Patrick, it's like things are happening fast, and thank God we've got this technology now where we can go back and look at stuff and see what happened. Like, where were the prongs to the taser? I mean, because the experts made certain arguments. Well, let's see if we can apply the facts to what they're saying. And so I've have found that expert to be very helpful in just understanding. And I like how he puts all the videos together and explains the reference points. And so when I heard the objection, I just kind of chuckled to myself. It's like, yeah, okay, you don't like it, so you got to find a way to object. So they'll fix it, and we'll get to see it again. So,
and I have one. Sorry, I have one last question for you all, and that's just your reaction to the whole entire case presented. You know, they have rested their case. You know, I know that we won't really know who did the best or be able to compare everything until essentially the verdict. But now that we've seen the prosecution's whole entire case, what is your now reaction to what they have presented and going forward with now the defense? I'll start with you, Andrew.
Well, first of all, you know, the big question is whether or not the prosecution proved to the jury beyond a reasonable doubt that it was not justified. And the problem in self-defense cases is it's a double negative. And so it's like when a juror's thinking about it, it's like, well, was he justified or not? And from Chris Schurr's perspective, man, it's an argument to be made that they never proved beyond a reasonable doubt. If I can now put on evidence to show in my favor that in fact we can prove that it was justified, well, that helps the jury reach that conclusion, because you're not required to claim that you can prove that you are justified. The prosecution is required to prove beyond a reasonable doubt that you were not justified. And so I think now what they're going to do is they're going to really attack that in the defense. And so I'm looking forward to seeing how they do that going forward.
And Tanya, I also want to hear from you about your reaction to the prosecution resting their case, what they presented, and now what you look forward to with the defense.
Yeah, similar to Andy, I think in this particular case, there's no argument that Christopher Schurr caused Mr. Leoya's death. That's not the issue here. And what his state of mind was as far as was this an intent to kill or cause great bodily harm. But I'm looking forward to how the defense now presents, even though they don't have the burden of proof, with respect to presenting the case of self-defense. The self-defense jury instructions in Michigan are very favorable to a defendant raising the defense, right? And they say that we have to look at what the defendant's subjective state of mind was, and then we look to see if it was objectively reasonable. And so it's not surprising to me that the prosecution spent a lot of its case trying to establish that his response, Mr. Schurr's response, was not a reasonable or proportionate response, and trying to knock down this idea that he was reasonable in his calculation that he needed to act in self-defense. So I'm really looking forward to how the defense presents that other side of self-defense, what Mr. Schurr was thinking, why he thought he was at risk of imminent death or great bodily harm, and how the defense expert witnesses, I anticipate they're going to bring in experts, will help establish that.
And Sarissa, I also want to get your thoughts on what the prosecution has presented and what you're looking forward to as defense begins their case.
Well, I think the prosecution did what they intended to do, in that they tried to present enough evidence to a jury for the jury to find that Mr. Schurr didn't act in self-defense. You know, they tried to take it piece by piece, and only the jury, you know, will determine if that's the case. What's interesting and going to be interesting at this point for me is to kind of go back to what we talked about yesterday, which is, are they able to establish Mr. Schurr's fear of what was taking place without Mr. Schurr testifying? That's, again, another strategic, interesting point just from a defense lawyer's perspective when you're watching a case like this, and you just, you know, it's always at risk to put your defendant on the stand. We talked about that yesterday, but in a self-defense case, most times you really need to. So are they going to be able to get what they need without Mr. Schurr testifying, or will he have to be put on the stand? So that's really what I'm looking forward to seeing as this progresses.
And I know I said that was my last question, but as you know, we are on a 30-minute delay, and my producer just told me something very interesting that just happened in court. I'm hoping to get yours all, you know, initial opinions for what I'm about to say. Essentially, the defense wants to include evidence that would speak to Lyoya's intentions and character. The judge has said that that is not relevant to the case. This is the second time that the defense has tried to add in things about Lyoya's character. Is that normal? Is it strategic for when they're doing it now that they have their own case to present? I just want to know your initial reactions to just hearing that little blurb of that. I'll start with you, Sarissa.
So the defense is going to do everything possible to try to get in character evidence about Mr. Lyoya. I mean, that's what you want to do, but rules of evidence kind of preclude that from happening unless you have certain things that come up that allow you to do it. And so in the same way that we were talking about motions earlier, that you try everything that you possibly can to try to represent your client in the best way possible. And so now they're trying this, and again, they're trying it now. And if they get denied, it's possible that something might change in the future and they might try it again. There's no harm done in trying. What the judge decides, the judge decides. But if they have an open door, they're going to take it, because that is evidence that would be helpful for the defense if it was able to be presented to the jury.
Tanya, I want to hear your take on this latest opportunity, I guess, that the defense is trying to bring in more evidence of Lyoya's intentions and character.
Yeah, picking up where Sarissa left off, of course, the defense is going to try everything they can. That's their job, to zealously represent their client. And remember, when the defense is self-defense, the reputation of the victim's reputation for aggressiveness is admissible. But in Michigan, we've seen the courts rule that the defendant has to be aware of it, right? Because if the defendant's not aware of it, how does it affect the defendant's state of mind in thinking he or she has to act in self-defense? So just like it was ruled on earlier, if something comes up where it becomes evident that Mr. Schurr might have been aware of some of Mr. Lyoya's prior record, then it all becomes fair game again. And I would expect the defense to continue trying to get to that evidence.
And finally, Andrew, I would love to hear your take on this as well.
Well, let me ask you this question. When they did it, was the jury present or not?
It's unclear at this time. We're not sure, because obviously we're on the delay as well, but it is unclear.
Okay, well, because that changes my analysis a little bit. If the jury's not present, they're just bringing another request to do it. But if the jury's present and they try to do it, well, what they're communicating to the jury at that point in time is, hey, there's stuff here you're not allowed to look at. Wouldn't you be really curious to know what it is? And jurors will oftentimes grab onto that stuff. And so that's like one of those things a trial attorney will do strategically and broach the issue in front of the jury, just to plant the seed in the jury's mind that, hey, the court and the prosecutor is keeping stuff from you, that we've got the secret thing. that you'd love to know about, but you can't because they're stopping you. And so that's a little trick that trial attorneys will use. And so that's why I asked that question, if it's in front of the jury or not.
Well, we just got word in my ear that the jury was not in the courtroom when that was said. So I guess what's your reaction to that?
Well, then they're trying everything they can. And going back to Tanya's point about, hey, if the guy has a violent past and it's known to Officer Schurr, then that changes the analysis. And so, like, for example, let's just say that when he pulled up, he didn't know who he was. That's the whole thing. Like, but we don't know whose plate was on that vehicle. So all he said was it's a wrong plate. So I don't know if Patrick's name was attached to the plate or if another person's name was attached to the plate. But it's possible that his name was attached to the plate, and then if he knew that he suspected that that's the person that he's dealing with, and that person has, a violent criminal history, it would likely show up on lien. Here's the other possibility. Like, what if the plate comes back to somebody else that's not Patrick, and that the person that it comes back to does have a lengthy history of criminality and violent offenses. And now you think you're dealing with that person and not Patrick. I mean, so we don't know. No one has ever said who the plate came back to or what individual. And certainly we don't know what Officer Schurr knew because he hasn't testified and his Garrity statement hasn't been released. And so we don't know.
Well, I appreciate you all coming on again to talk with us. A lot to discuss, and we still have a whole nother case to listen to with the defense. Thank you again for all joining me today.
Thank you.
Thank you.
And we are able to now show you those proceedings happening right now. And it starts with this conversation about Patrick Loya's character. Take a listen.
Reasons that we feel may show intent on the part of Mr. Loya to use the weapon on Officer Schurr. So far, it's been the prosecution arguing what his intentions were, what was apparent to a witness, based on a cell cam video where it's pretty clear, maybe recording when the user wants it. It gets put down, oh, he hit you too, gets put back up at a certain time. So everybody's basing their opinions on what Mr. Loya's intentions may have been from the cell cam video. But we feel we should be able to argue what his intentions may have been based on the fact that if he were placed into arrest there, he's either wanted on several things or was certainly in violation of the law from several courts on probation.
Okay, I'm just gonna stop you because I don't want to place a bunch of things about Mr. Loya on the record. The court's already determined that they're not admissible or relevant. And so just addressing the renewed motion under 404 and 405. 405, I don't believe is applicable because that has to do with reputation or opinion in Part A of that rule. Part B of the rule says that when a person's character or character trait is an essential element of a charge or defense, then it could be proven by relevant, specific instances of the person's conduct. That's not what you're requesting, so that particular rule does not apply. As far as 404, I believe that perhaps maybe 404-2B could apply because in that rule it states that in a homicide case, when self-defense is an issue, the defendant may offer evidence of the alleged victim's trait for aggression. However, in the motion that you listed, the only point out of you listed 9 separate issues, the only one that could potentially have to do with aggression is the first one, and then that is the arrest warrant that you mentioned before, which is not evidence. There's nothing proven, it's a warrant. So, like I said, and compared it to your client, it's as if saying your client has a particular trait for aggression because he's had a warrant for the second-degree murder charge, and that wouldn't be appropriate either. And so I also believe that any attempted explanation, even those that have already been put forth by different witnesses, any attempted explanation of what was going on in Mr. Loya's mind, it would be pure speculation on the part of any person. It's impossible to know what was in his head. It's also not relevant what was in his head. What is clear, what is in evidence, is that he was clearly fighting with the officer. Why he was fighting, I don't know that that's relevant. He clearly is fighting, he's clearly drunk, that is evidence that has been placed on the record. He clearly didn't have a driver's license to present to the officer when he stopped him. He clearly didn't obey several commands. It doesn't matter why he didn't. It doesn't matter why, just like it doesn't matter why he was drunk. He was drunk. Those are the facts. You can clearly argue that he was intending and he was trying to do this. You can argue that just the same as the people can argue that he wasn't trying to. So because his character is not an essential element, this particular, again, trait for aggression, the only one that we're pretending is the arrest warrant that was pending, and there's no evidence that Mr. Leoy was even aware of that warrant, so.
Your Honor, but there were, just to note, there are several other warrants, for some of them for years.
Right, but none of them have to do with aggression.
There's prior convictions for domestic violence, so if the prosecution opened the door, he's a really good guy. At least usually when it's my client, if I call a witness and they say that, the prosecutor's following right up with
Right, because that's
prior
a defendant,
conviction.
and you're treating Mr. Leoy as if he's a defendant, and he isn't. Your client is a defendant.
So the door can't be opened on other parties involved.
Not from what I've heard so far, for sure.
So the prosecutor can argue that what they feel his intentions were. His intentions, opening statement, his intentions weren't to use the taser.
His intentions were definitely to fight the officer. His intentions were definitely not to comply with his commands. I'm not sure to say, did he intend to use the taser? I don't know how you get that from what you're trying to put forth.
That's what they said. They said his intentions weren't to use the taser.
Okay, so.
But, so, and I
I'm
want
just saying, it's fair argument that maybe they weren't, but maybe they were. No one knows, because that's what it was in his head at the time. So to say, well, he's got this warrant, so he must have meant to use it, that it doesn't jive.
Well, a car full of unlawful contraband that would
Well,
show
again,
multiple felonies, I'm just,
again.
those are legitimate reasons why you would not
Right,
follow
but
his
say
command.
none of that existed, but he's still, everything that we know is already there. Why does it matter if he had all these prior things versus the fact that he's clearly, at least 3 times the legal limit drinking and driving? For example, he's clearly fighting with the officer. So why he's fighting with the officer, if it was no reason, it wouldn't change anything.
Right.
It wouldn't change the fact that he's not complying.
Your Honor, you made a ruling prior to trial, state of mind, and then now we've had several occasions where the prosecution argues what his intentions were, what Mr. Lyle's intentions were.
I didn't hear them argue it several times. I think during opening, he may have made a comment, but.
And the witnesses that they've elicited testimony from about what Mr. Lyle's intentions were. So I don't mean to test the court's patience. I made a record as far as why we think the door's
And I don't believe that testimony was necessarily elicited. I do recall witnesses testifying to things, including on the video, that, as you mentioned, I don't know if you mentioned or Mr. Cordula mentioned it just a few moments ago, but stating how the cell phone video, the friend taking the cell phone video, saying he doesn't have the taser, or I don't see a taser. Oh yeah, yes I do. So I mean, the jurors will see what they see. They know, they have the evidence that has been presented by the people, and I just still am maintaining my previous ruling for all the reasons that I stated, that these 2 rules do not allow or make those particular allegations or the things listed, doesn't make them relevant or admissible. I'll say admissible, so they're not admissible. And then we can have the jurors come in, if there's nothing else. Is there anything else for defense before the jurors come in?
No, Your Honor.
Mr. Becker, anything?
Nothing, Your Honor.
Okay, so we'll have them come in. And then I'll have you follow this.
the parties have stipulated to Exhibit L4 and Defense Exhibit EE for this witness.
Is that L4?
L4 and EE.
And is that, Mr. Becker?
Mr. Your Honor.
And L4 and EE are not admitted.
Thank you, Your Honor.
Welcome back. You may be seated. And the defense requires first witness, or your next witness.
Your Honor, the defense would like to call Sergeant Timothy Johnston to the stand.
And sir, before you take your seat, if you please raise your right hand, my clerk will swear you in.
Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may be seated.
Thank you.
Whenever you're ready.
Good afternoon.
Good afternoon.
Could you please state and spell your full name for the record?
My name is Timothy Johnston, Timothy Johnston.
What is your current occupation?
I'm currently retired.
Have you had were you previously employed at GRPD?
Yes,
And that's the Grand Rapids Police Department?
that's correct.
And since you left the Grand Rapids Police Department, have you had a haircut since then?
No, I have not.
And while you were employed there, what was your position?
I started out as a patrol officer on night shift and worked for 28 years on the street as a patrol function, and the last several years as a supervisor on patrol.
And can you briefly describe what your duties and responsibilities were around the time of April 4th of 2022?
Yeah, that was a day I actually came in on overtime. They were short-staffed and were asking for volunteers to come in and work. And I was assigned to the East Service area as a supervisor.
Can you describe what the East Service area is?
It's one of the geographic areas that Grand Rapids is divided up into teams cover. So the East Service area is generally from Cottage Grove, which is just south of Hall Street, and it runs all the way south to 44th Street out by Kalamazoo. And the east-west boundaries are from Clyde Park all the way out past the East Beltline to East Paris.
And I think you had mentioned that at that time you were working overtime because they were short-staffed.
Yeah, the week prior, at the shift that I work, announcement was made that they needed volunteers to come in and work that day.
How many people were usually assigned to the East Service area?
That service area is usually assigned 7 to 8 officers and then 1 supervisor.
And how many officers were assigned on April 4th of 2022?
I believe at the time of this incident, I think there was either 3 or 4 officers and then myself.
And as part of your duties as a supervisor, can you explain a little more what your duties were?
So I would respond to major incidents. I wouldn't go to some of the, I guess, standard type of calls that come out, but anything involving like felonies and that sort of thing. And then to supervise those scenes as well as review officers' reports.
Okay, and that day were you in the field?
Yes.
Okay. And in your experience as a Grand Rapids police officer, were you ever involved in tense, rapidly evolving, like hand-to-hand use of force situations?
Yeah, I worked the entire 28 years on patrol, so I mean, if I averaged only 4 a year, it'd put me well over 100, I think.
So I want to go back to April 4th, Monday, April 4th of 2022. You mentioned that you were working that day. What time did your shift start?
My shift started at 6:30 a.m.
And before this incident occurred, which was, I guess, between 8 and 8:15, where were you?
I was at the parking lot of the Croc Center at Division in Alger.
Approximately how far away is that from where the incident occurred?
It's 8 city blocks for a mile. I guess it's probably about 3 miles, maybe 2-3 miles.
How long did it take you, I guess from the time that you heard Officer Schurr calling out the traffic stop, how long approximately would it take you to get there to?
Between 2 and 3 minutes, I believe.
And do you recall hearing Officer Schurr call in a traffic stop?
Yes.
And when you hear someone call out a traffic stop, what is the common practice at GRPD?
If you're available, you would slide by or start heading that way until we know that everything's safe and that there's not, I guess, every traffic stop's an unknown risk traffic stop.
And can you explain what you mean by unknown risk?
Sure. I was a field training officer for 24 years, and so we teach high-risk stops and unknown risk stops. An unknown risk stop, any stop is a potential threat. You don't know who's in the vehicle, even if it's for speeding or what may seem just to be a traffic violation. We still have tactics that we employ to keep ourselves safe until the conclusion of the stop.
And so that you typically will have at least one person respond, even if help isn't explicitly requested?
Yes.
And when you were on your way to respond, once you heard Officer Schurr call out the traffic stop, what did you do?
At the time, I was on a phone call from another officer. I'm also was the supervisor of our mounted unit team, and I was on a phone call with another officer that had a scheduling issue with that, and so I was at the point, I think, that Officer Schurr called out that he had somebody running. I ended that and responded code 1.
And can you explain to the jury what code 1 is?
That'll be activating all the emergency equipment on the vehicle, like sirens, exceeding the speed limit.
And you had mentioned you heard him say the second, or just say, "I've got one running." Is that correct?
Yes.
Okay. And did you hear Officer Schurr call out another command or request on the radio?
I did hear him ask to send more cars.
What did you interpret that to mean?
I could hear in the radio transmission sounds of like a struggle, heavy breathing, the I guess tone or inflection in his voice.
Can you describe what that tone was like?
Labored and I guess an excited, elevated tone, desperation.
And at that point, what did you do?
One response. I think that was, I don't know if I was halfway there yet or something like that. Just continued as fast as I could to get there.
And do you know approximately how long after you heard Officer Schurr call out the initial traffic stop that you arrived on scene?
I think it was, again, somewhere between 2 or 3 minutes.
And that would have been potentially from when he called out the request from that he had one running?
Yes.
Okay. And did you hear him give any other requests over the radio?
I just heard I was probably maybe 3 blocks from the scene or his location that he was at when I heard him get on the radio again, stating that he'd been in an officer-involved shooting.
And when you heard that, what was your initial response?
I was still had to make a couple more turns to pull up on scene, and I came around the corner and could see his cruiser and the suspect vehicle ahead of me. Another officer, Mott, and his partner, Officer Grace, arrived pretty much simultaneously with me at that point.
And what did you know when you arrived on scene?
Really, only what had been transmitted over the air, that there had been a foot pursuit, the sounds of some kind of struggle, and then Officer Schurr saying that he had been an officer-involved shooting. At that point, I didn't know who was the suspect, how many suspects, what their locations were, what kind of weapons were involved. There's more unknowns than knowns.
And what did that indicate to you?
For me, as a supervisor, even line officer arriving first on scene, our priority is to secure the scene and make sure there are no more threats to officers or the public in any way, and then render aid.
Okay. And when you arrived on scene, once you got out of your car, what did you observe?
Again, I think either Officer Grace or Officer Mott kind of ran up at the same time that I did. As I approached, I could see Officer Schurr off the side of the curb to my right as I was running up towards him. Looked like he was next to a tree or behind a tree. I still didn't know how many suspects there were. And Officer Schurr was either leaning on the tree or kind of hunched over, breathing hard and just pointing.
And what did that indicate to you?
That's where I should focus my attention.
And what did you observe about, or I guess have you worked with Officer Schurr before April 4th of 2022?
Only on a couple of occasions because we worked opposite rotations. So I did have one incident with Officer Schurr a couple months before that. We worked a sexual assault case together that we received awards for.
And when you saw Officer Schurr that day, what did you notice about him when you arrived?
Complete exhaustion. He was bent, like I said, he was sort of bent, hunched over. You hear him breathing. Even in his radio traffic as I was approaching, you can hear this breaths, gasping for air.
Okay. And what did that indicate to you?
That he'd reached his physical limit. It reminded me of at the end of an Olympic sprint race or something. You see the athletes afterwards with their hands on their knees, breathing hard.
And once you saw Officer Schurr, what did you do next?
He was on his feet at least, and I knew another officers that were closer to him would assist him. So I guess I turned my attention still to trying to secure the scene. I could see another occupant outside the vehicle, and I could see Mr. Loyola on the grass off to the right.
And at that time, did you know who either of the parties were? Either Mr.
No.
Loyola or the passenger of the
No.
vehicle? Okay. And were you wearing a body-worn camera at the time that you responded?
Yes, yeah.
And was your body camera on when you responded?
Yeah, it was automatically activates when you activate the emergency equipment in the vehicle. As soon as you turn on your lights or your siren, your body cam is activated, as well as the in-car dash camera.
Okay. And have you reviewed the body-worn camera footage related to this incident on
Yes.
April 4th?
Yes.
Okay. And Your Honor, I would ask to publish Defendant's Exhibit EE, which has already been stipulated to, which is the body cam footage of Sergeant Johnston. Could you turn the lights down too, please? Thank you.
On your head. Turn around, face the car. Walk back towards us. Keep your hands on your head. Keep to the right. Keep to the right. Go to the right. The right. Now come back this way. Keep walking back. Keep coming back to me, partner. Keep coming back to me.
Pause it. Sorry, thank you. And for the record, this is at the 22-second mark of Defendant's Exhibit EE. Sergeant Johnson, I noticed that you have your firearm drawn. Can you explain why?
Again, with an officer-involved shooting that's just occurred, again, I do not know what kind of weapons may be involved, who is in possession of them, who all may be in the vehicle. So it's just for protect myself if someone was to draw a weapon. The same reason we order them hands on their head. We don't want them reaching around the waistband or pockets where weapons may be. So we keep the hands in view the whole time.
Okay, and why were you ordering him to walk backwards towards you?
We would bring him back. In this position, it puts us at a tactical advantage, and then we can secure that person and pat them down for a weapon. Make sure they're unarmed before we proceed with securing the rest of the scene. I can't let that person just be wandering around or get behind me and potentially attack me. Because again, I don't know where these threats might come from. A lot of unknowns.
Bob, can you play these?
10 more steps. 10 more steps. Keep going. Okay, down to your knees right there. Keep your hands up. Keep your hands on your head. Down on your knees. Put your hands behind your back. Palms facing the air. Bend over your waist. Do not look back.
Can you pause it again, please? So we're at 49 seconds of Exhibit EE. I noticed you were what seemed like kind of yelling at the individual who was getting out of the car. Why is that?
If you notice at the beginning of the video, I started giving him commands to move right, but he moved left several times, and so I'm just projecting my voice so he can hear me, and I guess to emphatically give those commands to gain compliance or obedience from them. So as quickly as I can, because I'm still, my ultimate goal still is to clear that car and then render first aid. So I need to get obedience quickly, make the scene safe as quick as I can in order to administer first aid.
And why did you order the passenger of the vehicle to be detained at this point?
Again, I still don't know what his involvement was in this incident, and I don't know if he has a gun in his sweatshirt or in his waistband or anything.
Okay. Bob, can you play, please?
Here, I'm gonna move. I need wireless coverage on the vehicle here. Is there anybody else in that vehicle? No one else in the vehicle. Okay, next car up. Anybody else in the car, make yourself known now! Yep, we're gonna clear the car first.
At this point, I'm waiting for more officers. That's why there's a pause here. There's no backup yet. I'm just waiting for another officer because we go up in either a 2 or 3 man team to clear a vehicle, but nobody's available.
Okay. And why do you, I mean, when available, why do you typically want 2 or 3 people to clear a vehicle?
So you can cover multiple sides of the car. There's also, I guess, sometimes concerns even with surroundings too. So whenever there's a high-risk incident, there's people, some are focused on the car, one side of the car, the other side, and other people covering, you know, and again, I don't know how many people have fled from this car. I don't know if there's other potential suspects hiding between these houses or anything.
Okay. And that was stopped at 1 minute and 26 seconds. Bob, can you play, please?
Javon, Nick, you guys with him, you go clear the car from driver's side. We're gonna keep coming on here. Yeah. You're good. Who's gonna read? You need. All right, you two go up and clear that car. I'll come with you.
16, that bring in the impact to the northwest. 10-4, you're not
Bob,
seeing
can
the
you pause it
heading.
here, please? And this is 1 minute and 51 seconds. I notice everyone has their firearms drawn at this point. Why?
Again, this is standard police training that this is an unknown threat in this vehicle. For me, at the beginning of my career, Officer Scott Flahive from Grand Haven was killed going up on a car like this because somebody was hiding in the back seat and shot through the door at him. And we always will stop even behind that, called the C pillar, that block between the rear window and the back seat, and you sort of use that as a shield for yourself to even look in that back seat, make sure there's not somebody crouched down in there before you move forward and look in and move forward up to the driver's side or the driver door.
Okay, you can play.
Heading to the north off of Oroville. 1918, looks like you're coming in. 1918, I'm on Oroville.
Can you see anything in there?
Nope. Between 17, 26, and 17, 15.
Okay, that's right in front.
You have those direct information from that list.
They are from that side. I don't know.
And when you approached the car from behind, Bob, can you back up just a little bit? Sorry, I don't know the time mark, but if you could go back to as they were approaching the car from behind. A little further. Yeah. Or a little further back, sorry. All right, from here, I guess, go forward a little bit. Yeah, play it from here. Okay, if you stop it from here. I guess as you were approaching the car, could you tell how many people were inside or if anyone was inside?
No, I think it was a combination of, it was like rain and sleet, so it was cold on the outside of the car, and I don't know if it was from breathing occupants inside or it was like the window, back window particularly, was very obscured, like fogged up. And then with the reflection with the wet glass and rain, it was very difficult to see in there. At one point, I think, if you go for it, I think I even put the light on the end of my gun, like right up to the window, to try to get at least the back seat floorboards and that to light up, because I couldn't really tell through the back window.
Okay. And once you were done clearing, or I guess what happened next after you cleared the car?
At that point, we sort of rallied back, I think, near the cruiser and go around and then form a team to move up to where Mr. Loyola is laying in the grass there. And again, I still don't know, we have a fear of this person could be playing possum, so to speak, or, if there's still a potential threat, even as we approach to render aid, if there's any kind of weapon present.
And when did you first become aware that there was Mr. Loyola had possession of a taser?
At the point that I approach him, I think if you show the video further, we approach, and at first I see like a black angular object slightly, he's face down and sort of under where his left hip would be. I initially thought that was like the back corner of like a Glock handgun or something, but as I got closer I could tell that it was Officer Schurr's body camera that apparently fallen off, and it was under, like halfway under Mr. Loyola. And then I ended up grabbing Mr. Loyola by his right arm to roll him towards me. And as I did that, then I could see the yellow taser under the right side where I pulled his arm out from.
Your Honor, permission to approach? And I am... Yeah. And I am showing him what's been previously marked as Defendant's Exhibit L4, which the parties have stipulated to. Sergeant Johnson, do you recognize this?
It appears to be a still picture of Officer Schurr's taser in the mud next to what I believe is Mr. Loyoya's hand.
And you had just described that when you found the taser, it was under Mr. Loyoya's body.
Yes.
Was this photo taken, I guess to your knowledge, was this photo taken after you had already rolled him over?
Yeah, when we originally came up to him, it was over top of it, so we didn't even see it until we rolled him over onto his back.
Okay. All right. One moment. All right, thank you. I have no further questions.
Just briefly, Your Honor. Good afternoon.
Good afternoon, sir.
I was asking if you're on vice, because usually vice officers kind of look like that, and you're just retired.
Just retired, yes, sir.
Just want to go back to some of your statements that you made. The first thing you said is, you taught this when you were with Grand Rapids Police Department. You did some of the training for officers on traffic stops, correct?
Yes, yeah.
And one of the things you said was every traffic stop is an unknown risk.
That's correct.
You don't know what's in that car.
Yes, sir.
You don't know who's in that car. You have to
Yes.
answer out loud. I can see
Yes,
you.
sir.
And quite frankly, there's a lot of times where there are guns in cars in Grand Rapids. When you were working, that was an issue.
Yes.
It was not uncommon to find a gun on a person in a car
No, not uncommon.
and between the seats in a car,
It's very common,
under the seat of a car.
even more common.
Even more common. So, guns, and going back to some of your training, I've got some training records here. When you talk about training, did you train the recruits or are you training officers?
They go through what was labeled an in-house training through our training unit, and then once they're put out on the street, they enter the field training program, and they have officers that they're with a 4-week through different phases, and I was one of those field training officers.
But in terms of even the training, I think a lot of the training, when you train those people, they talk about, even when you start, is the danger of weapons in a car. Is that a fair statement?
Yes.
That you have scenarios where you may have one person with a gun in the car or two people with a gun in the car, correct?
Yes, sir.
And when you're doing an unknown traffic stop, that's part of the unknown traffic stop is you basically approach every car that it could have a weapon in it. Is that a fair statement?
Yes.
All right. And one of the things you said, and it kind of backs up did you have an opportunity to review your report?
Yes.
Okay, and I've highlighted some of the things in your report, and you kind of testified to this. My goal is to make the scene safe as quickly as possible so we can safely move forward or render aid. So you definitely want to render aid to Patrick, correct?
Yes, sir.
But without being attacked or shot by the subject standing outside the car. So you were worried about that?
Yeah, again, I don't know.
You have no idea?
All unknowns, yes.
And even at that point in time, though, you at least had, 4 officers, because you said you responded 2 pulled up at the same time?
A 2-man unit, that was Officer Grace and Officer Mott. And then,
The defendant.
And then Officer Schurr was.
And then yourself.
Yes.
So there's 4 officers, but you were still concerned, even with 4 officers at the scene, that you didn't know who was in that car?
Correct.
You didn't know who, Ame is his name, if the passenger was armed?
Yeah, we still have 2 suspects.
Sure.
Mr. Loyoya, that's on the ground, so, and then Officer Schurr is obviously out of commission because he's so exhausted. I wouldn't even consider him a usable asset at that point.
But there's at least 3 of you.
Yes.
So you clearly outnumber the passenger.
Yes.
But there still could be somebody in the car because you don't know.
Correct, sir.
And that's one of the things you said. And one of the problems was, even in your report, the rain and reflections on the car windows obscured my ability to see clearly inside the suspect vehicle.
Yes.
So that was an issue because it's a complete unknown in there. There could have been somebody else hiding.
Yes, sir.
And that's why you kind of go through all that we saw on your body cam.
Yes.
All right. Thank you. I have nothing further.
And Sergeant Johnson, I just have one question for you. You were asked about the passenger, but you weren't worried about the threat with him anymore because he immediately complied with your commands, right?
Once he's been secured, detained, and patted down, yeah, he's secured off to the side. But somebody's got to be his, keep custody of him, so that takes another officer out of, my available assets there, and I have to wait for more to respond to fill those positions.
And at that time, there were multiple, how many officers were on scene?
I don't even know, because a lot of the activity was behind me. I could hear some sirens getting closer. At some point, I think Officer LaHeis and then Officer Sanders arrived. And those are the two that went up with me to clear the car.
And when you chase individuals, is it also common for them to be armed with weapons?
Yes, I've tackled several people that had guns on them.
Thank you. I have no further questions.
Just one follow-up, I just want to make sure you're clear. She said, or in her question, that one question was you weren't concerned about the person standing outside the car. But your statement, you said, in your report, the subject in the front yard without being attacked or shot by the subject standing outside the car. So when you initially showed up, there's a person standing outside the car, right?
I don't understand what the discrepancy is.
That was her question. I just want to make sure.
Well, I think the point was that at what point was he no longer a threat? And that's why I explained, not until he's secured. He's a threat until he's secured and patted down.
So that's what I'm saying. When you pull up and he's standing outside the car,
He's a potential threat, yeah.
No further questions, Your Honor.
I don't see any hands raised on the jury. May this witness be excused? Ms. Hamilton?
Yes, Your Honor.
Any objection?
No objection, Your Honor.
Thank you very much, Your Honor.
Thank you, Your Honor.
Your Honor, the defense calls Sam Mott.
And sir, before you take your seat, if you could please raise your right hand, my clerk will swear you in.
Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may be seated.
Thank you, Your Honor. Good afternoon, Officer Mott.
Good afternoon.
Where do you work?
Grand Rapids Police Department.
How long have you worked there?
Approximately 4 years.
Okay, and what's your title and describe your job duties?
I'm a patrol officer on our day shift.
Okay. And were you on duty on April 4th, 2022?
Yes, sir.
Okay. Did you receive a call to respond to a scene involving a shooting by a police officer, Christopher Schurr?
Yes, sir.
Okay. When you received that call, were you in your car?
Yes, sir.
All right. Was anybody with you at that time?
Yes, sir. I was doubled up with a partner.
What does that mean?
It was 2 officers in 1 car.
Do you recall who was with you?
Yes, sir.
Who was that?
Officer Jordan Grace.
Okay. Did you respond to the scene?
Yes, sir.
I'd like you to tell us what you saw as you arrived in your car.
As I pulled up to the scene, Sergeant Tim Johnston was pulling up as well. We saw Chris standing a couple houses down in the block to our north. He was standing in the middle of the street, and we couldn't see anything else other than another vehicle with an individual standing on the passenger side of that vehicle.
Okay. And you want to refer to Chris, you're talking about Officer Schurr?
Yes, sir.
Had you ever met Officer Schurr before?
Yes, sir.
Okay. Are you guys friends? How do you describe your relationship with him?
We played basketball a couple of times when we weren't at work.
Okay, so kind of just someone you might hang out with playing basketball, but no deeper relationship than that?
Correct.
All right. Now, you say you played basketball with him. Have you ever seen him exert himself playing basketball?
Yes, sir.
Could you describe his level of physical fitness?
He had excellent cardio. He was one of the few guys that would continue to run the entire time we were playing.
Was he in better shape than you or worse shape?
Yes, sir.
Okay, all right. Okay, so as you approached the scene, did you get out of your cruiser?
Yes, sir.
And did you have an opportunity to engage with Officer Schurr?
I did.
Can you please describe what you saw as far as Officer Schurr's physical condition when you engaged with him?
As I approached Officer Schurr, he was standing on the rear passenger side of a vehicle that was parked along the curb. Officer Schurr appeared to be out of breath, and he was having trouble making any comments towards us, and he looked absolutely exhausted. He was kind of looking down towards the ground. At that point, I told Officer Schurr to go take a breather.
Okay. Did you follow up with him at a later time?
No, sir.
Okay. You also mentioned that there was another individual at the scene that you were concerned about and other officers were engaging with. It was the passenger of that car?
Yes, sir.
All right. Did you have a chance to interact with that passenger?
Yes, sir.
Okay. Please tell us what you observed when you talked to the passenger of the car.
I took possession of the passenger, placed him in cuffs. As I was walking him back to the car, he appeared very intoxicated. He smelled of alcohol and continuously asked me if his friend was okay.
Okay. And you placed him in the back of a patrol car?
Yes, sir.
Did you obtain his phone for evidence?
Yes, sir.
And you preserved it for such?
Yes, sir. I placed it in airplane mode.
Nothing further.
No questions?
I don't see any hands raised on the jury. May this witness be excused, Mr. Colville?
You may, Your Honor.
Any objection?
No objection, Your Honor.
Thank you very much. You're excused.
Thank you, Your Honor.
Defense may call your next witness.
The defense would call Nicholas Colati.
Good afternoon.
Good afternoon.
And sir, before you take your seat, please raise your right hand. My clerk will swear you in.
Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. You may be seated.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Sir, could you please state your name and spell it for the record?
Nicholas Colati, spelled Calati.
How are you employed, sir?
Grand Rapids Police Department.
And how long have you been employed with GRPD?
27 years.
Okay. And, sir, were you on duty back on April 4 of 2022?
Yes, sir.
And assume you know the incident we're referring to on April 4, 2022.
I am.
And if you could just tell me, what were your duties that day prior to this incident?
That day I was working as the patrol supervisor for the south end of the city.
Okay. And what do you recall as far as how you became involved in this situation here with Officer Schurr?
That early morning, Officer Schurr called out a traffic stop. Shortly thereafter, he called out for pursuit, and that drew our attention and started going his way.
Okay. Do you recall where you were when you first heard the initial call out?
Yeah, I was right around Franklin or MLK and Ionia, or 131 right there.
Okay. And if you could just explain as far as what you do after those calls are coming out.
When those calls come out, we activate our lights and sirens because it's emergency response. And then as I'm going as a supervisor, I help coordinate a response from the other officers or any other needs that we have, be it medical or anything like that.
Okay. And did you ultimately go to the scene here?
I did.
And what do you recall observing when you arrived?
When I arrived, I was not the first one there. There was a couple other officers that had arrived first. As I was approaching, we had coordinated what we needed protected. We didn't see who we still had to make contact with. surroundings, like anything that could be dangerous for our officers, had to keep an eye on that and coordinate a rescue effort.
And was it your understanding when you arrived that it was a situation where a subject had disarmed a police officer of their weapon?
Correct.
And is that a fairly rare situation for
It
GRPD?
is.
So was it treated very seriously, as far as very
It was.
carefully?
Yes.
Okay. Now, did you have the opportunity to view Christopher Schurr here?
Yes, I made contact with him as soon as I got on scene.
Had you known him before this?
Yes.
And if you can, explain what was his condition when you made contact with him?
When I made contact with him, you could tell he was like worn out, tired. His face was pale, still breathing kind of heavily. I would say kind of like a slouched posture instead of having all the strength type of thing. Like if you were to sit up straight, as opposed to having a bunch of energy and after you have expelled all your energy.
Okay. How long did you end up staying on scene, roughly? Do you recall? Quite a while?
Yeah, for the duration of the day, pretty much.
Okay. That's all I have. Thank you, sir.
No questions?
Hand raised on the jury, so have my clerk probably grab that question. It's not really a question for the witness. So, if you want to approach him. May this witness be excused, Mr. Hodge?
Yes, please, Your Honor.
Any objection?
No objection, Your Honor.
Thank you very much, officer. And attention to call your next witness.
Your Honor, we'll be calling Captain David Cyber to the stand. And, sorry, Your Honor, before we do that, can you take a 5-minute break for the restroom? I'm sorry.
So 5 minutes is not long enough. We're going to take a restroom break for there's 14 people. There's not 14 restrooms.
Sorry, maybe 15-minute break, is that okay?
It's a little early for a break, but I guess we can do one now. We haven't been in here an hour yet.
I know, I'm sorry.
So we'll just do a brief, we'll do a 5-minute break, but we'll just take another longer break later, since it's only been an hour, so hopefully that's enough. And we will take another restroom break. So we'll come back in 5. Meanwhile.
Thanks for joining us. Today is day 3 in the trial of former Grand Rapids police officer Christopher Schurr. He's charged with second-degree murder in the killing of Patrick Loyola. Now, you've just heard testimony from former and current Grand Rapids police officers who responded to the incident between Schurr and Loyola that day. The witnesses spoke about seeing Schurr at the scene and walked the courtroom through the processes they took to secure the scene. Normally, we would take this time to bring our live crews in and also experts, but because this break is is so short. We will stay with the court's live stream. Our coverage will continue throughout the day, so stick with us.
I do.
Thank you, maybe seated.
Thank you.
Sorry, a lot to go through with Captain Cyber. Good afternoon.
Good afternoon.
Can you please state and spell your name for the record?
Yes, David Siver, D-A-V-I-D-S-I-V-E-R.
And what is your current occupation?
I'm a police captain with Grand Rapids Police Department.
Okay. And how long have you been a captain at the Grand Rapids Police Department?
I've been a captain for approximately 3 years, or I'm sorry, a little over 3 years. I've been a police officer now for almost 26 years.
Okay. And can you talk briefly about some of the different positions you've held at Grand Rapids Police Department?
Yes, when I hired on started out as a patrolman, was assigned to second shift patrol, also midnight patrol shift, and then in 2004 I was selected for the special response team, our department's full-time tactical team. Spent 11 years in that team and then was promoted to sergeant in 2015. Worked nights and day shift patrol as a sergeant for a couple years, then went back to the SWAT team in 2017 as a sergeant. Promoted to lieutenant in 2019, was the midnight, one of the midnight shifts shift commander. And then in February of 2022, was selected to take over the training unit until a couple years back. We had a little reorganization that became a captain's position, where now I oversee the training and engagement division, which houses the training unit and the community engagement unit, kind of our hiring, recruiting arm and our training arm.
And how long have you been involved with the training unit generally?
As the commander for 3 years, a little over 3 years now, but I've been involved in training since roughly 2002, when I was selected as the defensive tactics or subject control instructor. And then 2004, emergency vehicle operations instructor through the state police. 2006 or 2007, I became a firearms instructor, Krav Maga instructor.
What is that? Sorry.
I'm sorry. Krav Maga is another form of defensive tactics, a system, if you will. And then 2013, I became a field training officer as well.
Okay.
And I'm sorry, and then also a taser instructor since 2005 or 6 as well. And a master taser instructor a couple years back that just lapsed.
Okay. Have you received any, in addition to this, have you received any specialized training in law enforcement, defensive tactics, or other use of force?
Yes. The certification courses are usually a week or two long. And then I also have attended the Force Science certification course. That's a week-long course. The executive management program through Northwestern's Policing Institute also.
Okay. And, but prior to working with the Grand Rapids Police Department, did you work for any other agencies?
Yes, I started my career in the city of Saginaw back last century, 1999. I got laid off, that's how I ended up here.
Okay. And when you came to Grand Rapids, what are some of, I guess, why did you come to Grand Rapids?
One, for the opportunity, right? It's a much larger agency than City of Saginaw, a lot more growth and opportunity, job satisfaction, those kind of things, so.
Okay. And have you taught or trained officers in the use of force and defensive tactics?
I have, since roughly 2002 in those various areas. We have regular mandatory training where it's in-service training, if you will. So those blocks of instruction rotate through the year, and I've assisted in those since 2002, 4, 5, 6, in that range. Also, during my tenure on the SWAT team, we trained pretty much every week, and I assisted in instruction or teaching in those areas. I also assisted teaching at Grand Valley State Police Academy in the areas of subject control, use of force, other topics since 2004 to roughly 2015. And then I also taught a couple sessions at Kalamazoo Valley Community College, 2005, 2006, in those areas as well.
Okay, and you mentioned subject control. Were there any other topics that you have taught?
Yes, obviously firearms, kind of I refer to it more of a critical skills area, so that component of communication, driving, use of firearms, subject control, kind of just a broad spectrum of the job, if you will.
And in addition to the certifications you spoke of, the force science and the Northwestern policing, have you completed any other advanced courses or certifications in regards to the use of force?
Just the Master Taser program.
And who is the, can you explain what the Master Taser program is?
I'm sorry, yes. I think you've heard from the Axon rep. Axon is a parent company that manufactures our body cameras, our tasers, a bunch of different devices and equipment. So the Master program is an intensive week-long program where they take you through the history of the taser weapon systems, from the invention of them, every model that's still currently manufactured. While some agencies, currently we have the Taser 10, some agencies still have the Taser 7s, some have the X26s. So they take you through the history, the nomenclature, and you're required to understand how to operate, diagnose, train, and all of those areas, along with some skill building exercises. And then you have a bunch of written and practical exams at the end. And the concept is you're a master instructor, you can then anywhere in the country go teach a taser class for an agency and certify instructors for that respective agency.
Okay. And are you familiar with Grand Rapids Police Department's policies on the use of force and practices and procedures?
I am, yes.
How did you become familiar with those?
Through being part of the training cadre. Historically, our agency has always had instructor development sessions or instructor days. So we discussed trends and policies and that, and then as I promoted up and became more of a command level, that's historically how the chief's office and work groups get policy changes through by several different entities reviewing them within the agency.
And have you reviewed the specific sections of the policies that were in effect at the time of the incident involving Officer Schurr, which
Yes.
is April 4th of 2022?
Yes.
Okay. And Your Honor, this is marked as Defendant's Exhibit G, I believe. Oh, sorry. Defendant's Exhibit E is the Grand Rapids Police Department policies.
So E is all the policies that. No objection, Your Honor.
To the admission of.
Apparently it's E 1 through 10 is what I'm understanding.
And you're moving for admission of those at this time?
Yes, Your Honor. And these are the Grand Rapids Police Department policies, and it's E1 through E10. It includes the use of force, firearms.
All right, so I'll admit 1 through 10 into the evidence at this time.
Thank you, Your Honor. And I guess while we're doing this, we also have Defendant's Exhibit F, which is the mandatory training. And it's Defendant's Exhibit F 1 through 18.
No objection.
To F1 through 13?
18.
18. And You said no objection to their initial?
Correct.
All right, then they are admitted at this time, F1 through 18.
Thank you, Your Honor. And Captain Cyber, how many times have you testified in court regarding GRPD matters?
Over the course of my career, I would estimate probably in the about 100 range, maybe.
And in those cases, who are you usually testifying for?
Many times for the city attorney's office here in GR, and then the county prosecutor's office as well.
And at this point, have you had the opportunity to review the video footage from Officer Schurr's body camera and dash camera and the passenger's cell phone video from the incident on April 4th?
Yes.
How many times would you say you'd viewed those videos?
Prior to this week, through the trial, probably 12 to 15 times.
And do you feel familiar enough with the content of these videos to answer questions related to the training and policy topics involved in this incident?
Yes.
And have you reviewed the facts of this case?
I have.
And did you form any opinions regarding the use of force by Officer Schurr?
I have.
So he can't give opinion testimony because he's not an expert.
I was going to move to qualify him as an expert at this
You
time.
have to do that before he introduces his opinion.
Yeah, I was not going to ask him for the opinion. I just had asked if he had formed one. But at this point, we would move to have Captain Cyber recognized as an expert in the Grand Rapids Police Department training policies and procedures.
Any objection?
Just simply for Grand Rapids Police Department training and policies, that's fine, Your Honor.
So he will be considered an expert in Grand Rapids Police Department training policies and procedures. Is that what you said?
Yes.
So he shall be considered an expert in that field.
Thank you, Your Honor. And Captain Cyber, can you tell us a little bit about your role at GRPD regarding policy review and analysis?
Yes. So like I explained a minute ago, as I promoted, especially since I took the lieutenant role in charge of the training unit and now my current captain position, yearly, roughly, we do policy reviews to keep up with national changes or court decisions that would affect our policies and procedures. We continually try to update our training materials, I guess, outlines every session, things like that.
And are you familiar with the GRPD's policies on the use of force?
Yes.
And Your Honor, I do have, I would ask for permission to publish a demonstrative that has Exhibit E, which is the GRPD policies on that.
What do you want to publish? I'm sorry.
Defendant's Exhibit E, but I put sections of them just for purposes of trying to go through them.
The ones that are just admitted?
Yes.
Okay. Yes, you may publish that.
Okay. All right. Okay, so can you tell us a little bit, I kind of want to walk you through and have you help explain to the jury what Grand Rapids Police Department policy is on the use of force. So I'm going to kind of have you talk to us about that a little more. So I am showing you what is part of E, Exhibit E1. Can you explain a little bit, can you explain what GRPD relies on for their use of force policy and what that is?
Yes. The Supreme Court case, Graham versus Connor, is the basis, the framework for our policy. As you can see, the language in there, reasonable amount of force, reasonable threat of death or serious bodily injury, number 3. The fleeing felon, that's Tennessee versus Gardner case, but yeah, that's the framework for our use of force policy.
And how do you usually, I guess when you're talking about the Graham versus Connor, can you explain to the jury what you mean by that?
Yes, so the term objectable reasonableness, which you can see that's highlighted there, some of the factors or things to take into account. The phrase totality of the circumstances, meaning the factors of that incident, that time, then, there. So you can see A through G, the immediate threat to safety of others, officers, and C, resisting arrest or attempting to evade arrest by flight, D, the term again, a reasonable officer on the scene. So these are all factors kind of combined together as you work your way through the reasonableness of the force.
I'm sorry, this is a separate page.
Oh, sorry, Your Honor, this is policy 9-1.2, which is defendant's exhibit. It's still part of E1, it's just the second.
It's like number 6 on this page.
Yes.
And then the other one was a different part.
Yeah, for the record, the first slide we discussed was the use of force, 9-1.1, which is exhibit E1, section 1, 2, and 3.
Thank you.
All right, and now we are talking about exhibit E1, 9-1.2, section 6. So you had talked a little bit about the objectively reasonable officer standard. How does this standard guide officers in how to make decisions in high-stress situations?
Well, mainly that kind of boils down to a similar trained officer in a similar circumstance or similar situation. Would they perform in the same way or in a similar way? That's kind of the easiest way to boil that down. And the big factor is hindsight 2020 can't be used in evaluating that use of force, right? The comfort of your desk or your office or your couch as you're watching that video, that's not the goal, that's not the objective there. You can't have the hindsight 2020. You got to be able to articulate or look into it in that time and place.
And when you say that, does that mean you have to, can you explain more what that means? Like, who are you supposed to be, what perspective are you supposed to be evaluating it from?
From the officer on the scene or a similarly trained officer, right? Put yourself in that officer's position. I can kind of use a sports analogy, right? When we're yelling at the TV on a football game or a basketball with the Pistons last night, put yourself in that position. That three-point shot's not so easy, right? So those circumstances of that right there, not you removed and you're in the safety of wherever. You've got to put yourself in that position. So exhaustion, you're tired, you don't know, all these factors, the totality of the circumstances, it's an extensive list of things. You've got to be able to recreate that and put yourself in that situation or a similar trained officer as you're judging or evaluating that use of force.
And is that part of what you do in your current position is evaluate
It
uses
is.
of
I'm
force?
responsible for use force analysis and reviews, and we average between 500 to 600 use forces a year in the last, for pretty much my entire career. So, yeah, I'm tasked with that. I'm part of the use force review board.
And you mentioned the totality of the circumstances, and you started mentioning some of them. And I would direct your attention to Exhibit E1, Section 9-1.4 to 9-1.5, and this is Section D. And you started talking about some of these topics. Can you talk a little bit more and explain what you are, or officers are trained to consider under the totality of the circumstances?
Yes. So that phrase, totality of circumstances, it's the tangible facts or the tangible things in that instance. So an easy one is size, right? Is the officer much smaller than the subject they're trying to arrest or fighting with? Exhaustion is on there. That has a huge bearing on use of force incidents. Weather, distance from the subject, the type of crime. And then the last one, and this isn't a complete list, obviously there's other factors that can play, but reaction time is a huge one because it's pretty well understood that action is usually faster than reaction. So again, sports analogy. A pitcher gets a pitch signal. He knows exactly where he's going to do it. He's going to be able to do it with relative control. The batter's got to react to that. If it was easy, a batter to have 1,000% batting average. So, same thing as an officer. They've got to pick up clues or cues ahead of time to try to give them some kind of a fair playing field.
And when you're talking about reaction time, is that something that's also trained to the officers?
It is.
And what are they trained about that?
Just to understand the concept that action is faster than reaction. So officers, for the vast majority of their daily activities, are behind the power curve, if you will. They have to react to other actions. Very rarely do officers take initial actions ahead of time. And I also point up number 5 there. A vast majority of our use of forces, subjects or suspects are under alcohol or drug influence. That's a vast majority of our incidents.
And is that just like something that you train officers to look for?
Yeah, to recognize that some uses of force are not effective. For example, pepper spray, people that are intoxicated historically don't have, they aren't affected the way that a person that wasn't intoxicated might be by pepper spray. Or they're very resistant to pain because of the delayed response due to the intoxication or the drug induction.
And you mentioned like not viewing this from hindsight. How do you avoid doing a hindsight analysis when evaluating the use of force?
Personally, I will watch the video or videos start to finish, and then review the incident reports to try to gather some more information, and then I'll try to break down the video frame by frame, or I don't have forensic video equipment, but break it down through the software that I have available by piece by piece.
And as, I guess when you're considering things from hindsight, are these some of the factors that you have to consider from the perspective of the officer involved?
They play a major role, yes.
And are officers trained with regard to the reaction time? Are they trained that they might have to make split-second decisions in tense, uncertain, and rapidly evolving situations?
Yes, that's reinforced through training.
And how do you train officers to anticipate that?
The best way we try is through reality-based scenarios where we put them at a disadvantage and force split-second decisions to try to reinforce decision-making skills and try to give them some framework to understand, reasonable decisions or reactions off that.
Okay. And now you mentioned some of the reality-based scenarios. Can you tell us a little bit more about what those are?
Yes. So as men and women hire into the Grand Rapids Police Department, they do an 8-week in-house orientation, we refer to it as, where we start with very basic skills and then progressively make them more difficult, the scenarios. For example, we'll at some point in that 8 weeks, we do a drill, kind of an exhaustion drill, if you will, where they're in a kind of sensory deprived, it's pretty simple design, but it's more or less a shower curtain that kind of comes over top of them. That's enclosed, and then they react immediately to something, and it's usually a violent assault. And the goal there is to get them exhausted, to have that understanding what that feels like, a 30 second to 1 minute scenario, because we found that if we go past that 1 minute, the injury rate gets pretty high. So that's one example. We also voluntarily expose the new recruits to taser, a taser effect, a taser, either a drive stun or NMI, as you've heard, the probe, and then pepper spray. We also make them drive on a racetrack. So we try to expose them to everything we possibly can that they'll see out in the street or out in a real operational sense. And then once they get done with that 8 weeks, they do 16 weeks of field training with somebody sitting next to them that evaluates everything they do, every call they go on, every stop they make, and it gets progressively harder. And the expectation is they have to do the whole 100% of the work by the end of that field training program. Then when they're done with that, we have between 8 to 10 mandatory training cycles a year that vary in topic to try to maintain skill sets and build skill sets.
And why do you have the new recruits go through all of these scenario-based trainings?
Just to give them a perspective of what, one, that time compressed decision making, that stress of having to make decisions in a split second. And then, like I said, to try to expose them to as much as we possibly can before they're subjected to it in a real life scenario. So the effects of pepper spray, what it feels like to be tased, what it feels like to be exhausted. You know, we even have foot pursuit scenarios that we do with them, so they understand what that feels like or what that looks like. We really focus on communication skills, and there's a whole list of things from A to Z.
Okay. And you mentioned that you ask people to be voluntarily tased and pepper sprayed. Why do you do that?
The biggest factor is to, so they understand the effects of it. One, for taser, for example, what that does to another human being, that if you're tasing them, to understand that, to avoid excessive taser deployments or taser rides, if you will. Also for their own benefit to know if they were incapacitated or the pain associated with the drive stun. Also, pepper spray affects people differently. Some people have very little effect. Some people are completely kind of incapacitated by the effects of it. So just so they have that before they get out on the street in a real life operational sense. They've never been exposed to it.
Okay. And I'd like to pull up what I think has previously been published as the people's, actually I'll just do ours. So I will, would like to move to admit defendant's exhibit. And Your Honor, I would have permission to publish Defendant's Exhibit J and K, which are the videos of Officer Schurr being tased.
Okay. Those are good to consider.
And Bob, can you pull up Exhibit K, please? Or sorry, J. Sorry, can you pull up Exhibit K? Okay. Sue, do you mind dimming the lights, please?
I'm sorry?
Could you dim the lights, please? Okay, this is Defendant's Exhibit K. Can you play this for us, Bob? And is this the voluntary tasing that you had talked about?
Yes, it's consistent with what we do. And if you notice, the retired captain now that actually tased Officer Schurr, he's well within that 4-foot range, and we do this to demonstrate various effects of the taser, where we'll get a quote-unquote proper spread of the probes to somebody, and then the next person we might do a close probe deployment to show that it's super painful, but there's varying effects to it, or we might drive stun somebody, or we might do a third point of contact to create that lockup or that NMI. So that is consistent with what we do, yes.
And based on the close range that Officer Schurr was tased, how close do you think this would be?
It looks like he's probably within about 2 feet of where he sends the probes.
And based on that, how far would you anticipate that the probe spread would be?
That's a previous model. That's an X2 model that when Officer Schurr was hired, we were still carrying. So the previous model, the T7, but in that range, it's probably about I would guess about a 6 to 7 inch spread from there.
Okay, and as part of the voluntary tasing, why, I mean, I guess you've explained why, but do you notice that with different people, their reactions are different depending
Yes.
on their size
Mhm.
and body mass, distance?
Yes, and you can see we have to take precautions to, because if, say, Officer Schurr standing up, those two officers would be spotting him under his arms because of that concern of a fall hazard. So we vary the positions just to demonstrate effectiveness, or as you could see in that video, Officer Schurr is able to crawl a little bit, but he's obviously in intense pain. And without his arms being held, I don't know if he would have been able to move his arms or not. We get varying responses, like you said, by body size, ability. People react differently to being tased. That's for sure.
And have you ever been tased?
I have.
And what was that experience like for you?
Miserable, I will say miserable. I've been tased, part of it was the instructor program, I think 3 times. I have not been tased by the Taser 10, thankfully, but yeah, it's, and I've had different reactions each time. That's the unique part about being tased, is one time you may lock up and not say anything, you may scream, blood-curdling screams, you may flail your arms. With that quote-unquote lock-up, the NMI. I've also been drive-stunned 4 times, and that's yeah, very intense pain, and I relate it to like being hit with a blowtorch. That's what it feels like your skin's melting.
Well, I think you're a brave person for doing it that many times.
That's also why I'm not the master taser instructor anymore.
And yeah. So we could do a demonstration, but we can't. So, so when you're teaching officers what it feels like to get tased, are there any other things that you train them to think about when they're about to use a taser, or when they're about to use the taser?
Yes, and that's why we do a ton of reality-based scenarios. We have specific taser-based scenario drills we do. Because things are dynamic, right? They're fluid. They're not like that mat room or the taser video where everything's static and I'm going to stand here, you're going to pull your taser, and I'm not going to move. So we try to demonstrate that through various different exercises to show, even though it might be a close probe spread, you could fire your other cartridge and get a lockup, or you could create that third point of contact by drive stun or touching that taser to the individual. So there's varying methods we try to reinforce that there's a whole spectrum of issues with the taser at times, so to try to work through that.
And I would like permission to publish Defendant's Exhibit K. J, I'm sorry.
So it's J.
Yes, sorry. Defendant's Exhibit J. And you mentioned the close probe deployment. Is this what you were discussing?
Exactly, yes. So Officer Schurr there is in very close proximity to it's just a leather wrestling dummy we use, so you can use live cartridges. And that's a limitation of training with the tasers because of some of the dangers with them. We can recreate some of it, but I can't have role players getting hit with live tasers. That's a problem. So we use dummies and things like that don't move. But he deploys that taser from probably 6 inches away and then finds that third point of contact. The other option we've trained in is you fire the first set of probes, you get a close probe spread, then you move, and you could fire your second set of probes to make the connection, the electrical connection.
And is there any, even though in some instances if you're closer than 4 feet or the optimal distance, is there any prohibition on doing that?
No, that's really why we do these drills, just to give them some repetitions and a conditioned response, if you will, that in a dynamic fluid situation, that optimum distance isn't always possible.
And you also mentioned that.
I'm sorry to interrupt, but with that last exhibit, was that the same taser model, or was that the prior model?
That's the prior one, Your Honor.
Thank you. Just wanted to make that clear for the record.
And that was the X2 model? I
X2,
think?
yeah. The functionality is the same, it's just different cartridges and design of the device a little bit.
And does your training on the close probe deployment or the distance you need to be from the person, has that changed at all now that you've switched to the TASER 7? Or I guess at the time you were using the TASER 7?
The TASER 7? No, that did not change anything.
And you also mentioned that sometimes you have people voluntarily try pepper spray? Or
Yes, we,
expose themselves?
I won't say mandate, however, strongly encourage people, unless they're prior law enforcement from somewhere else in lateral end. But again, for the same concept of to experience what that feels like, your eye ducts kind of shutting down and watering and just the physiological responses you have to that. And if somebody's never been pepper sprayed, they don't know what their response is going to be. Like I said, some people completely shut down and can't really fight through it. Other people, it doesn't affect them at all. So that's kind of the first step, because in the course of your duties, pepper spray has some residual effects on us too when we use it in the field.
And are you aware if Officer Schurr has been pepper sprayed?
He was, yes.
And Your Honor, I would have permission to publish the People's Exhibit 12, which I think is the graduation video. It's the People's Exhibit 12.
You want me to play it? You want to switch to my computer?
Yeah, if you don't mind.
Play the whole thing?
Yeah, you can play it, and then I might tell you to stop it. Okay, thank you.
Oh, sorry. Get the sound going.
Can you pause it here?
Can I
And,
charge what Mr. McFarland's charging here now?
yeah. And for the record, this is defense, or the People's Exhibit 12 at the 53-second mark. And you, Captain Seibert, you notice, can you explain, do you know why
Yes.
Officer Schurr looks like his eyes are
Yes, so
squinting?
typically, when we expose our newer officers to pepper spray, we're out at our outdoor range. Then it prevents our instructors from getting the feedback as well. So we'll spray one side of their face, have them close one eye, and spray one side they elect to uncover. And then we give them a little bit of physical training type, some jumping jacks, push-ups to get their breathing up, because some guys will hold their breath, or some folks will hold their breath, try to game it. And then we make them perform some simple strikes, kicks, punches, those kind of things on the training dummies, just to demonstrate to fight through the effects. And like I said, some of our folks really can't. Some people, like you see Officer Schurr is doing his best to get through that, and he's got some involuntary closure of his other eye. So he's experiencing full value, it appears.
And when you, I guess, expose them, depending on their reaction, are officers required to use OC spray if they have a bad reaction to it?
In the field, you mean, or?
Yeah.
No, they're not required.
And you also mentioned that you had been drive stunned in the past. Have you also been pepper sprayed?
Yes.
Would you say that the drive stun is the equivalent of pepper spray?
I would not.
Why not?
The drive stun's, you've heard the concepts of pain compliance with some of these techniques, the kicks and punches and some of these techniques. The goal is to inflict some kind of a pain to gain compliance. And I relate the drive stun is the most intense pain compliance option, device, tool that I've ever felt. So pepper spray is nowhere near. It's uncomfortable and it takes longer to decontaminate and it has some longer effects, but the drive stun is much worse.
And have you ever trained officers to spray pepper spray, or how do you train them to use the pepper spray when they're using it on someone else?
When we set up scenarios specifically where we want to try to elicit a pepper spray response, typically it's at a, where somebody's not obeying verbal commands, they're seated, you have some distance, because like I said, you'll get some residual splashback, if you will, you'll get some pepper spray back at you. So if I'm in close proximity to somebody, I pepper spray them, I'm gonna get the full effect as whatever that person's getting, and anybody else around. So it's really designed in its best application to be a distance type tool.
Do you ever train officers to spray it towards themselves?
No.
Why not?
Because they'll most likely suffer the effects of it.
And what would be the harm? I guess what is the risk?
I mean, you could see in that training video, the graduation video from Officer's class, he took one side of the spray, he's got one eye closed, and he's still suffering effects in both eyes. So without being able to shield one of my eyes, there's a chance I can get at both my eyes and then have double the effect of it. The other issue is the design of the device. Can I show mine, I guess, for the jury? Not spray it, but just to show you the canisters that we carry and have carried for years has a thumb device in it, so it would be very awkward and odd to try to get my thumb in and point it back at me, right? So we instruct to use your thumb to spray it, not your finger. So that would be the other preclusion of pointing it back at me.
Okay. And where is the pepper spray located on your duty belt?
In front of whatever dominant side you have, whatever hand you write with. I'm a right-handed person, so I have it on my right hand in front of my gun.
Okay. And is that where, do you know if that's where, or do all officers carry their pepper spray there?
The vast majority do.
Okay.
Whatever their strong or dominant side is.
Okay. And are there any issues with trying to use the pepper spray if you're at the optimal distance? Is it effective on everyone?
No. I think I mentioned earlier, historically, people that are intoxicated or under the influence of narcotics, a lot of mental health type crisis, people that are affected by that, it has very little effect or no effect. There's also some outside the kind of norm folks that just don't have any effect to it, whether they're stone sober or not.
And in your experience, does it typically work to on certain people who may be intoxicated?
With limited success in my operational use, I guess.
Okay. Mr. Becker, if you wouldn't mind playing the rest, I don't think. Sure. And then if you could switch it back to Mr. McFarland's computer. And when you were talking about the drive stun, you had mentioned you had been drive stunned multiple times.
Yes.
And have you ever trained officers, or would you equate the drive stun potentially to the eye as equivalent of a thumb?
No.
Why not?
I guess I would say a thumb, you'd have to know kind of how to inflict that damage to the eyeball, where that electricity coming off the end of the model of taser. Again, like I said, I relate it from my experience of being drive stunned 4 times like a blowtorch. So I don't personally want to have it anywhere near my eyeball. I would think that's going to cause a lot more damage, but I'm not a doctor. So.
And without getting too much, what do you train or how do you train officers to use the taser?
To use the taser? Like in the video, for example, that drill that officer does during his recruit class, close probe deployment, where you fire the taser, activate it, pull the trigger from any distance, and then you know that you've got a short probe spread, so you follow up with that third point of contact, or fire the other set of probes into the person at some point, because then that would give you the distance you need between the probes. We've never taught to remove your cartridges to affect a drive stun. That's just not in our training philosophy or program at all. So we've always been from a probe deployment type. The only thing we talk about is the older models, especially, they had what they referred to it as blast doors on the front of the taser device. So the probes are not super long, so sometimes those probes would get impaled in the blast doors, and then it wouldn't give you any impact to the person. So we've always taught to keep at least try to get a 6-inch distance before you pull that trigger to send the probes, and then follow up with somewhere else, either more probes or drive stun.
And are there any locations that you train officers to avoid when using the taser?
Yes, early on in the taser days, I think actually I had hair back then, they weren't, the dart to heart concept wasn't around, but then after several litigation cases, they changed that so that they've asked us to avoid that center mass kind of chest area. And it's always been preferred that back or legs, large muscle group areas. And we've always instructed that to avoid the neck, face, genital areas, chest area as of late, obviously, but just because of the danger of probes going to those sensitive areas.
And do you also train them not to target those areas with the drive stun?
Yes.
And regarding how you train, kind of going back now to some of the use of force training and some of the policies, what standards in Michigan govern how police officers use force?
Obviously, we talked about the U.S. Supreme Court case, Graham versus Connor, but then obviously we follow Michigan law, Sixth Circuit Court of Appeals, any of their case law or decisions that come out.
And when you say Sixth Circuit case law, are you referring to the Sixth Circuit Court of Appeals? That includes Michigan, Ohio?
Yes,
Tennessee.
Michigan, Ohio, Tennessee, Kentucky. Yes, so throughout the year, their cases come down. We have legal reviews or legal updates rather by the city attorney's office. And as cases come down, we try to glean information to if it has an operational impact on our day-to-day.
And in Grand Rapids, GRPD use of force policy and all of the policies implemented, is GRPD required to follow Michigan law? And
Yes.
what other, and you mentioned, I think, that Graham versus Connor is also incorporated throughout the policy, is that correct?
Yes.
Is GRPD required to follow South Carolina, Florida, or New Mexico law?
No.
Is that incorporated anywhere in the GRPD policies or training?
No, the only thing I would say to that is as instances around the country pop up or happen, we constantly are trying to glean information off that, trends, concerns, those kind of things. But no, not for policies or state law.
And why is that? Why do you?
Just to try to learn, and because as we sit here right now, men and women are out answering 911 calls, doing the daily duties of police work. So it's imperative that we stay up on it and try to identify training needs or concerns or things that we're seeing as trends happen across the country.
And yesterday we heard from some of the prosecution's experts, and I think there was some mention of consent decrees that were entered, I believe from New Mexico. Is the Grand Rapids Police Department trained on or required to follow any consent decrees from other states?
No.
And And is GRPD required to, or do they implement the International Chiefs of Police policy guidance into their policy?
No, I'm actually a member of the ICP, and I follow their publications, but no.
And some of the references to their policy, it was referenced as a policy guidance. Does that mean that GRPD is required to implement those policies?
No.
And you were here yesterday, and I believe, did you hear the testimony by Professor Stoughton and Mr. Bloomfield?
I did.
And did you hear them talking about this officer-created jeopardy theory?
Yes.
And
we have to object here. We have to object.
Okay, I withdraw my last question. Based on some of the generally accepted police practice that you heard Professor Stoughton and Mr. Bloomfield testify about yesterday, are those all consistent with what GRPD trains our officers to do?
Could you rephrase that? Sorry. That seems like a broad, in what police practices, I guess.
During the testimony from Professor Stoughton and Mr. Bloomfield, there were some tactical suggestions that they talked about regarding foot chases. Is that consistent with how Grand Rapids trains their police officers on solo foot pursuits if there is another occupant in the vehicle? Is there anything that prevents or
No.
prohibits that at GRPD?
No.
How are officers trained to handle solo foot pursuits?
Depending on the situation, biggest thing is to get radio traffic out that you're in a foot pursuit and evaluate the factors there and then execute.
And is there any GRPD policy that prohibits an officer from pursuing a suspect or person when there is another occupant in the car?
No.
And I think we touched on this a little bit, but following up on what some of the testimony was yesterday from Professor Stoughton and Mr. Bloomfield, is they talked a little bit about the taser close probe deployment. Is there anything at GRPD that prohibits officers from using close probe deployment?
No.
And sorry, one second. Could you explain to the jury how GRPD officers are trained to assess actions by arrestees?
Yes. One of the first things we try to reinforce with newer officers is visual cues, obviously. Watching hands, waistline area. It's a well-known fact that the vast majority of firearms or illegal weapons are kind of hidden between the waistline or the hip bones, if you will. So watching hands, if they're trying to access a weapon or a firearm as you're approaching them, that's some of the biggest concerns. Watching for some nonverbal cues, if they refuse to look at you, if they're kind of looking for an avenue of escape. Establish some kind of verbal dialogue with them, whether that's commands or directives, and gauge some compliance or lack thereof as you're approaching. There's multiple factors, but those are some of the kind of the first ones.
Okay, and if I could have Bob pull up the PowerPoint that has Defendant's Exhibit E, which includes the GRPD policies. Thank you. And I am directing your attention to policy, and this is Exhibit E1, 9-1.3 to 9-1.4, Section 2. Are these some of the available responses that you were discussing?
Yes.
Okay, and you talked a little bit about some of the responses available and some things that you train officers to look for. And what is the officer's, when can an officer use these types of responses?
Well, the first one, A, there, officer presence, verbal direction, that's pretty much immediate. When you arrive on scene, you effect a stop, you make a contact, you know, like I am here, full uniform, clearly marked as a police officer. And then establishing some kind of verbal direction, right? Stop, hey, come over here, you know, get back in the car, get out of the car. Those are simple verbal directions. So that's the first step, and that kind of gives you an idea as you're visually kind of identifying and gauging compliance off that verbal direction. And then just working down that list, I'd refer to it as physical controls, where you're actually grabbing or trying to establish some kind of physical control where you're grabbing onto them. That would be, under B there, soft, empty hand, and then it progresses down from there.
Okay. And this is a continuation of that, so this is Defendant's Exhibit E1 9-1.4. Can you talk through some of the available options?
Yes. So as you saw on the first page, this is just the second series of options as you escalate in your use of force, or the force you tried to affect wasn't successful, right? So the top one, physical controls, I just said that, but that really is any type of, you're trying to, grab onto them. So now you're into some kind of strike, a kick, a punch, and you can see the sentence up there that, reasonably believes that soft, empty hand controls will be insufficient to establish control and the use of deadly force not justified. And then the next step is intermediate control. So kind of commonly refer to that as our tools, right? Impact, your baton. If you're equipped with less lethal munitions, which the vast majority of patrol officers aren't. And then the electronic control devices, tasers. So again, it has that language in there where you could move to that level, intermediate control before, after you can establish that lower levels of force have been ineffective, or you reasonably believe. So going back to that, to totality of the circumstances or the factors, right? Size is a huge one, right? So if I'm an officer that's 5 foot, 100 pounds, and the subject I'm dealing with is 6'4" and 280, we don't expect them to go hands-on with them. They could escalate to a taser device maybe right away, as opposed to, a bigger officer may have to actually physically go hands-on with them, if that makes sense.
Yes, and sorry, I jumped out of order here a little bit. I'm now showing what's Exhibit E1, Section 9-1.2, and it says number 7, 8, 9, and 10. So can you explain a little bit about what the officer's response is, what they're responding to?
Yeah, so it just kind of clarifies what we expect of our people, right? To gain control of a subject, they're trying to either take into arrest or detain for an investigation, or just general public safety. So that just defines what a response is. And then again, we go back to the reaction time. It's barely understood that it takes some time. Your brain's going to initiate an activity, but it isn't an immediate, right? It takes some time to actually initiate that activity or that response you want to do. And it just goes in there. And then at the bottom, a duty to intervene. That's clearly in our policy that we have a duty to stop another officer from unreasonable force or excessive force.
And now, Exhibit E1, Section 9-1.3, D, can you talk a little bit about what the officer's use of force is generally based on?
Yes. So that language in there is just kind of a guideline. We ask our people, our men and women, to explain what that looks like. So inactive resistance, you can see in the parentheses there, clenching a fist, blank stare, looking for an avenue of escape. Those are what you could see and understand. The inactive resistance just gives it kind of a rough phrase there. And then you work down the passive resistance. That's kind of commonly referred to as like a protest or dead weight, right? Stand up, no, is dead weight. So they're not actively resisting, they're passively resisting. They won't react to verbal commands. And then it progresses down to active resisting, where you're actually physically trying to block an officer from grabbing onto you. You're pulling away. And then active aggression and assault, you're striking them, you're wrestling with them, or tussling. That seems to be a common phrase. Grabbing onto the officer, grabbing their equipment, and then a deadly force assault at the bottom.
And we already talked about the officer's available responses in 9-1.3 and 9-1.4. But just to clarify, so the level of control used by the officers, is that typically based on what the person's actions are.
Yes, with the caveat, I think they said it in a couple of them, that we don't have to progress through each one to jump to another one, or we don't have to wait to be punched to do, ABC kind of thing, or I don't have to wait to be shot to use deadly force, so it's all based upon, again, that objective, reasonable standard. What would a similarly trained officer in a similar situation, how would they react? So it just spells out in our policy those actions and the options the officers have.
And how do you train officers to account for or incorporate the decision-making options when they're in a situation, use of force?
Yeah, we really focus on that reasonableness. There's more than one way to do it. It doesn't have to be perfectly right. It has to be reasonable with that information they had in that time-constricted decision-making process, recognizing that decisions take time to actually initiate. So you see it commonly where maybe the subject's facing me, and then as I initiate that action, they're faced away from me, so it looks like I hit them in the back or punch them in the back, but as I initiated that activity, they're facing me. So that's kind of the reaction time. We understand that.
And what are some of the challenges that officers might face to make slow or analytical decisions during use of force incidents?
Like we've talked about here, the reaction time, right? They're usually reactive in nature. And you don't have full, complete information. You're going off of your training and experience, or reasonable decisions at that point, or what you can kind of, those factors, the totality of the circumstances. So if a subject's acting like they're armed, they're doing what we'd refer to as security taps, where they subconsciously tap their waistline where a weapon might be secreted. That's a reasonable response for me to key in on that and think that they're armed, right? Or they blade away, where they move their body position away from me, like as you're standing at me, if I put my right hip or right side to you, I've bladed away from you to conceal my weapon. So those are clues or cues that we try to train our folks in, and we expose them to in scenarios to pick up on that, to start that decision-making process. And then we recognize that we try to give them some kind of parameters, and they operate in those parameters, and we constantly coach and train and mentor.
And how does the training account for an officer's reliance on intuition or experience in these split-second moments?
They get quicker with recognizing threats or cues, or clearly a brand new officer, unless they've got vast life experience reading people, don't pick up on the clues that somebody with 10, 12, 15 years on the job was going to, until they've been exposed to that, right? Where you may give somebody 2 arms length distance away as I'm speaking with you, and then you're in 3-foot pursuits because they can pick up that you don't know they're going to run. So then all of a sudden you close that gap a little closer to be able to grab onto them. Things like that, where you allow somebody to move a little further, then you're involved in some foot pursuits, and you learn pretty quick that, oh wait, he's probably going to run, or she's going to run, so I close that gap a little quicker. So it just speeds up the decision making as they get more experience and more training and more repetitions.
And
looking for conditioned responses, if that makes sense.
Okay. And why is that important?
Like I said at the beginning, we try to train the men and women to have been exposed to the vast majority of things we possibly can before they see them in an operational sense. And obviously there's limits, we can't do everything, but a conditioned response to an input is much better than I have no idea what I'm doing, I'm going to go off the fly. If that makes sense.
And when you are training officers in these scenario-based situations, are they, and like we saw with the taser exposure, are they usually in very controlled situations where?
No, starting, if you think of the concept, crawl, walk, run, we like to use that, right? So week 1 through 4 of recruit in-house is going to be pretty static, right? We're going to teach them skill sets, drills to reinforce positive reaction, and then we turn the dial up, if you will, the pressure up, where now it's much more dynamic. So that dummy that maybe he's doing a close probe deployment on now is a moving role player in a suit, and he may move as that taser goes, or those kind of scenarios where we run or we get the foot pursuits and we fight back. And so we try to turn the stressors up as much as we can without injuring the new officers or the role players.
And as part of the training, I guess just finishing up some of the policy stuff. Once an officer, and I'm sorry, for the record, I'm showing what's Defendant's Exhibit E1, Section 9-1.4. Once an officer makes the decision to use deadly force, are they required to try other options?
No.
Why not?
If the situation, that officer has deemed that situation has resulted in they're going to elect to use deadly force, they need to stop that threat in an immediate sense. So lower levels of force have a very less likelihood of becoming successful, especially if you've escalated through multiple options of force and now you're at a deadly force encounter. Like we've talked about, the time-constricted decision-making, exhaustion, various factors are going to have an impact in that. So deadly force, there's not time to go back to other options.
And are there some instances where it would be reasonable for an officer to go directly to deadly force without having to try
Yes.
any of the lower options?
Yes.
Can you give an example of when that might be?
Yeah, for example, I try to stop somebody here right outside the courthouse on Ottawa, somebody walking on the street. As I go to make contact with them, hey, stop for a second, they spin and they produce a firearm. I don't have to try to use empty hand tactics or anything else. I can immediately pull my firearm and defend myself.
And once an officer decides to use deadly force, are they, I may have said this a little bit already, but are they required to use a different force option before they resort to their firearm?
No.
And once they decide to use their firearm, can you explain how you train officers to use their firearm once they've decided that deadly force is necessary?
Yes, so we do usually 3 to 4 times a year. Besides scenario-based stuff, we actually do firearms training with different weapon systems, different drills, whether it's standard marksmanship, point shooting, close quarter battle type drills where you're very close to targets. There's a whole multitude of training that goes into the use of firearms. And then in realistic based scenario training, we have the option of using training devices so we can, role players can recreate a deadly force encounter and the officer going through can deliver deadly force without injuring either party. So we have that a lot where we build specific scenarios to elicit those responses. Yeah.
I'm showing you what is marked as Defendant's Exhibit E2, and this is the Firearms Procedure 9-2.2. Can you explain when an officer may draw or display their firearm?
Yeah, it clearly says right there, fear for their safety of the officer, safety of others. So easy example of that is frequently we have break-ins around the city where a broken window in a business at 2 a.m., the officers are authorized to pull their firearms as they clear that structure or begin to clear that structure.
And once officers decide to use deadly force, now I'm showing Defendant's Exhibit, this is still E2 9-2.1. When can an officer discharge their firearm?
So it starts with a reasonable threat of death or serious bodily injury to yourself, another citizen, or another officer, and then to present the escape of a inherently violent fleeing felony crime, and the probable cause to believe that that subject poses a reasonable threat to others or officers.
And when you are training them on how to use the firearm, where do you train them to?
Yeah, so kind of a misconception, unfortunately, is shoot to wound. We train to stop the threat, and we teach to shoot center mass because that's the largest target area that people have. So upper chest, upper back, those areas. We don't train to shoot limbs or shoot the gun out of somebody's hand because the likelihood of success is not very high. So that, in its easiest explanation, is the preferred target areas for. But like I said, some of the drills, it's point shooting, if you will, where you're pointing, you're drawing your firearm under stress and you're firing rounds at a target. So you're not actively aiming your firearm, if that makes sense. You're not, looking through your sights, developing a sight picture, taking your time. It's under duress, under stress, and you're just trying to get a response out right away.
And I think you mentioned close quarter battle.
Yeah, so it's a term, sorry, monikers and acronyms, but all that means is that threat is probably within arm's reach of me. So my arms are almost 3 feet long, probably. So that arm distance away from me, it's a very close-up threat. I don't have time, right, to create distance or put something between us. I've got to immediately defend myself or another. So we've taught, gone through this for years now of draw your firearm, and obviously I can't extend it because I'm going to be presenting that to them. So I'm going to keep that firearm close to me and point shoot. And with the cycle of our handguns, the chance, so not that this is a firearms lesson, but we have a semi-automatic handgun. So as I pull that trigger, there's a top part, the slide, that will cycle and come back. If I'm too close to my clothing, and we're in Michigan, so we're in heavy clothing 8 months of the year, I feel like, I've got to keep that slide away from me. So we teach to put the bottom of that firearm, the magazine that the rounds or the bullets are in, against our rib cage and shoot from here. So it gives me a little standoff distance and also prevents a malfunction of my firearm, if that makes sense. So that's a standard kind of close quarter battle drill we do, or close quarter combat drill we do at the range. And that's a very static in the sense of I'm standing in front of a paper target and I'm doing that. Due to safety and concerns for injury to my role players and instructors and cops, I can't really recreate those drills very well in training. There's some products out there that you kind of use, but it doesn't give you the same feel. So it's really hard to replicate that in a dynamic training scenario, if that makes sense.
And you mentioned something, I think, that it would be ineffective or something in certain circumstances. Can you explain what you mean by that?
I'm sorry, one more time.
Did you say something about it being ineffective at certain, using it in a certain manner when you're doing that?
Just more of a concern of creating a malfunction myself. So if I bring that firearm in front of myself, the slide could impact me or hit my vest and not cycle properly. So as you pull your trigger, a bullet goes, that round ejects out and a new round feeds in. So if it doesn't cycle properly, you've got a one shot and that's it. So that's why we really focus on bringing that firearm up, kind of that rib cage area up here, to prevent any kind of malfunction.
I think we've gone through all of these. One of the things that we haven't talked about yet, and I'm showing what is marked as defendant's exhibit. This is part of E1, and this is 9-1.6. And this is also talking about the authorized use of force. But can you tell us a little bit about the verbal directives that are mentioned? What are, in number E4? Can you explain what that is?
Yeah, I'm sorry. So yeah, whenever reasonably possible, officers shall provide verbal directives before deadly force is used. And I like to tell our newer officers, that's, for example, you're in a traffic stop, you've got multiple people in the car, and you see somebody reaching for a firearm. That's a proper time to tell them, don't reach that firearm, I'm gonna shoot you, right? A directive could be stop, drop it. It's a direction, not necessarily a warning. And when feasible, under life-threatening stress, time-compressed decision-making, exhaustion, some of those, when feasible, doesn't really make sense. It's not practical.
And with this verbal directive, does it require you to say, like, stop or I'll shoot?
No.
I think that's all the policy stuff that I have for you for now. Sorry
Okay.
if we've bored everyone. But, all right, so we've talked a little bit about your training and the in-house training. You've talked a lot about kind of how you train officers to be prepared for the use of force encounters in the real world through the scenario-based and the field training. One of the things that it seems like is kind of ingrained throughout this is that a lot of the responses are up to the officer's discretion. Can you explain why that is?
That we don't want to limit telling our men and women there's one response to that input or that stimulus or that situation, because it's just not practical. Like I explained, size of the officer, their ability. Clearly, I'm not a young man anymore, right? So if it's a 25-year-old officer compared to almost 50, right, there's physical skill differences there or experience. So we try to give them parameters, if you will, and operate within inside those. So their decision doesn't have to be perfectly right. It just has to be reasonable for that situation and circumstance.
And if one officer would do something one way, but another officer might do it a different way, does that make it unreasonable?
No.
Why not?
Like I said, size, skill, and again, I'll use the term articulate. If I explain what I saw, what I felt, why I did what I did, then maybe it looks different than me watching it, right? Like you can't be in somebody's mind to know what they saw, what they thought, what they experienced. You know, videos give you a perspective, but not living through the moment.
And you mentioned that officers' reactions are not meant to be perfect.
Yes.
Can you explain that a little bit more?
Yeah, just are they reasonable? Keep coming back to that term. Are they reasonable for that situation? So yeah, it doesn't have to be perfect, and we constantly review and coach and mentor and train to try to perfect that craft, if you will. But again, we don't expect perfection. It's just got to be reasonable, because they don't have the luxury of having all the time in the world to make a decision and come up with a tactical plan and have every asset and resource available before they initiate that plan. They've got to make split-second decisions under a lot of times serious stress and with a lack of information.
And is there ever one right option?
No.
I think you've explained it. Why not?
Yeah, just going back to that last answer, there's variable factors to it. You know, the officer, their experience, their what they recognize as a threat, where one might not. Though there's just a multitude of factors, and that's why we don't bracket people down into one way, one track, because it's not practical.
Okay. All right, and Your Honor, could I have a brief moment? I realize I need to get my notes. Your Honor, would it be okay if we just took a brief break? I just need to get some of my notes from my computer. Or we can.
It's 3:15, Your Honor, maybe it's time for the afternoon break, if court declined.
Okay, I was gonna do one at 3:15. we're almost there, so. We will take a break for 15 minutes, come back at 3:30. So meanwhile, please remember to leave your notes upside down in your chairs, and that you're not deliberating, so you're not to discuss the case amongst yourselves or with anyone else, and also the restrictions are still in place to avoid news reports about this case in the media and on social media.
Welcome back in. Today is day 3 in the trial of former Grand Rapids police officer Christopher Schurr. As you know, he's charged with second-degree murder in the killing of Patrick Lyoya. You've just heard testimony from Captain David Siver with the Grand Rapids Police Department. He is one of the officers who trained the other officers how to use of force and why. We're going to bring in 13 on your sides Riley Mack, who's been in the courthouse all day long, updating our live blog. And Riley, I'm interested to know, what are your key takeaways from the defense's witnesses?
Yeah, absolutely, Lauren. I think the day started with the prosecution's last witness, which is Nicholas Bloomfield, who is a use of force expert in the case. His appearance yesterday, along with Seth Stoughton, was immediately contentious for the defense. The defense today moved for a mistrial ultimately over the two's appearance in this trial. That's maybe the biggest thing that's happened in this case so far. They say that those two experts, Bloomfield and Stoughton, used outdated policies and an older taser model to base their facts off of, which was unfair to Schurr, saying that the jury has already heard these testimonies from these two men, meaning that it was unfair. They got an unfair view of the case from these expert testimonies, but ultimately it goes to the judge. The judge just gets that final decision. Judge Christina Mims ultimately says they never claimed to be experts in Michigan law. They only spoke on use of force, which is what their expertise is in. And she ultimately denied their motions for a mistrial. Right after that, the jury re-enters, and it's business as usual in the courtroom. The defense brings in Robert McFarlane, who was classified as a forensic video expert. He did a second-by-second video going through the footage of the incident, kind of saying what was happening in each clip. And after about an hour of listening to second-by-second video commentation, the prosecution objects to this use of time, and the judge asks the defense, is there a specific spot that you want to highlight within this footage? The defense says, no, we want to show the entire video second by second. The judge, and I'm quoting here, says, you're creating an exhibit on the fly right now. And she says, I don't think this is a good use of time. She asks for the next witness, but the defense says they're not ready for their next witness, so they call for a lunch break around 11:30. And we come back into the courtroom with immediate turbulence. The defense wants to include evidence about Lyoya's intentions and character on that day, April 4th, 2022, which we've seen before in this trial with the argument over Lyoya's previous convictions with domestic violence. The judge ultimately decides once again, no, his intentions are not relevant to this case because Schurr did not know his intentions that day, and any type of decision we can make about his intentions are ultimately just speculation. Defense brings out three GRPD officers, which are the first, GRPD officers we've heard from in this case, who were there that day. They talked about Christopher Schurr's demeanor when they arrived at that scene. I'm quoting here, they said he looked pale, he looked exhausted, he looked out of breath, and he looked like he just ran an Olympic race. One officer said when he arrived at the scene, he was leaning against a tree pointing to Lyoya's body. The latest person on the stand is David Siver, which you spoke on. He's a captain with GRPD, and he's now become an expert on GRPD policy in the case. He can speak now in court on how officers are trained, when they're justified in using their tasers, their pepper spray, their weapons. They even showed a video of Schurr getting tased and pepper sprayed while in the police academy. And he speaks on, how when in GRPD policy it says that deadly force can be used, what situations would call for that. I think the biggest takeaway that I got from that is, GRPD code does not require an officer to threaten lethal force before using it. So, they were saying Schurr does not have to say, put that down or I'm going to shoot. That's not, he didn't have to say that to Loyola before he fired that shot. He said that an officer's reaction to these high-stress situations do not need to be perfect, they only need to be reasonable, and that the high-stress, split-second decisions should be taken into account when we're thinking about an officer's behavior. So those are my biggest takeaways from, this afternoon and this morning.
You've been watching all these witnesses so far. I'm curious on what your opinion is when it comes to seeing the differences in witnesses from the prosecution to the defense today.
Absolutely. I think yesterday, we heard from, I think it was just a handful of people, but on Monday we heard from 8 witnesses from the prosecution, a lot of which were, the people who actually saw the events taking place. We heard from the friend who was in the car when Loyola was shot. He was filming it. He was right there watching. We heard from 2 neighbors who were watching the situation unfold. So we really got that, that firsthand perspective. Now we're hearing from people who arrived after it happened and, what they saw in their coworker, Christopher Schurr. We're kind of seeing a new side to him a little bit of how his reaction was, which is something we have never heard before. So yeah, a lot is being revealed in the courtroom today, I think.
And I wanted to ask specifically about Captain Siver. It sounded like the defense was almost asking him questions that were similar to the statements that Stoughton said yesterday in regards to use of force or how people react in situations. What is your take on that?
Absolutely. They're kind of taking what Stoughton said yesterday and kind of rephrasing it in the terms of GRPD, because Stoughton, they asked him multiple times, are you an expert on Michigan law? Are you an expert on GRPD policy? And he said, no, I don't claim to be. I'm an expert on general police practices, what's accepted. Now they're getting into specifics with GRPD. What should a GRPD officer do compared to their handbook, their GRPD policy? So we're getting into the nitty-gritty now, the details of how Officer Schurr was trained and how he reacted in comparison with that training.
Well, Riley, I know that they'll be getting back in session pretty soon, so we want to get you back into the courthouse. We appreciate you coming on and talking with us.
Thank you.
And like you just heard, we most recently heard from Captain Siver. He's a captain with the Grand Rapids Police Department. He is an important expert in this case as he is responsible for evaluating and training officers through their use of force tactics. Siver has explained aspects of how GRPD officers are trained in his testimony. Take a listen.
Can you talk a little bit more and explain what you are or officers are trained to consider under the totality of the circumstances?
Yes. So that phrase, totality of circumstances, it's the tangible facts or the tangible things in that instance. So an easy one is size, right? Is the officer much smaller than the subject they're trying to arrest or fighting with? Exhaustion is on there. That has a huge bearing on use of force incidents, weather, distance from the subject, the type of crime. And then the last one, and this isn't a complete list, obviously there's other factors that can play, but reaction time is a huge one because it's pretty well understood that action is usually faster than reaction. So again, sports analogy. A pitcher gets a pitch signal. He knows exactly where he's going to do it. He's going to be able to do it with relative control. The batter's got to react to that. If it was easy, a batter'd have 1,000% batting average. So same thing as an officer. They've got to pick up clues or cues ahead of time to try to give them some kind of a fair playing field.
And when you're talking about reaction time, is that something that's also trained to the officers?
It is.
And what are they trained about that?
Just to understand the concept that action is faster than reaction. So officers, for the vast majority of their daily activities, are behind the power curve, if you will. They have to react to other actions. Very rarely do officers take initial actions ahead of time. And I also point up number 5 there. A vast majority of our use of forces subjects or suspects are under alcohol or drug influence. That's a
And is
vast majority of our incidents.
And is that just like something that you train officers to look for?
Yeah, to recognize that some uses of force are not effective. For example, pepper spray, people that are intoxicated historically don't have, they aren't affected the way that a person that wasn't intoxicated might be by pepper spray. Or they're very resistant to pain because of the delayed response to the intoxication or the drug induction.
And you mentioned like not viewing this from hindsight. How do you avoid doing a hindsight analysis when evaluating the use of force?
Personally, I will watch the video or videos start to finish, and then review the incident reports to try to gather some more information, and then I'll try to break down the video frame by frame, or I don't have forensic video equipment, but break it down through the software that I have available by piece by piece.
And as, I guess when...
And Cyber also went into the actual programs officers are put through and how they're trained in difficult circumstances so that they can respond to dangerous situations, but also be aware of how it feels to be on the receiving end of tools like tasers and pepper spray. Take a look.
As men and women hire into the Grand Rapids Police Department, they do an 8-week in-house orientation, we refer to it as, where we start with very basic skills and then progressively make them more difficult, the scenarios. For example, we'll, at some point in that 8 weeks, we do a drill, kind of an exhaustion drill, if you will, where they're in a kind of sensory deprived, it's pretty simple design, but it's more or less a shower curtain that kind of comes over top of them, that's enclosed, and then they react immediately to something, and it's usually a violent assault. And the goal there is to get them exhausted, to have that understanding what that feels like, a 30 second to 1 minute scenario, because we found that if we go past that 1 minute, the injury rate gets pretty high. So that's one example. We also voluntarily expose the new recruits to taser, a taser effect, a taser, either a drive stun or NMI, as you've heard, the probe, and then pepper spray. We also make them drive on a racetrack. So we try to expose them to everything we possibly can that they'll see out in the street or out in a real operational sense. And then once they get done that 8 weeks, they do 16 weeks of field training with somebody sitting next to them that evaluates everything they do, every call they go on, every stop they make, and it gets progressively harder. And the expectation is they have to do the whole 100% of the work by the end of that field training program. Then when they're done with that, we have between 8 to 10 mandatory training cycles a year that vary in topic to try to maintain skill sets and build skill sets.
And why do you have the new recruits go through all of these scenario-based trainings?
Just to give them a perspective of what, one, that time-compressed decision-making, that stress of having to make decisions in a split second. And then, like I said, to try to expose them to as much as we possibly can before they're subjected to it in a real-life scenario. So the effects of pepper spray, what it feels like to be tased, what it feels like to be exhausted. You know, we even have foot pursuit scenarios that we do with them, so they understand what that feels like or what that looks like. We really focus on communication skills, and it's a whole list of things from A to Z.
Okay. And you mentioned that you ask people to be voluntarily tased and pepper sprayed. Why do you do that?
The biggest factor is to, so they understand the effects of it. One, for taser, for example, what that does to another human being, that if you're tasing them, to understand that, to avoid excessive taser deployments or taser rides, if you will. Also for their own benefit to know if they were incapacitated or the pain associated with the drive stun. Also, pepper spray affects people differently. Some people have very little effect, some people are completely kind of incapacitated by the effects of it. So, just so they have that before they get out on the street in a real-life operational sense. They've never been exposed to it.
And as we talked about all along during this trial, we are on a 30-minute delay, and court proceedings for us will soon be beginning. But before we go back to those proceedings, we want to talk about what else Captain Seibert talked about and some of the questions that the defense asked him. They go on to ask him questions specifically about use of force and what law they follow. He says that they follow Michigan laws for use of force and not other states like South Carolina. Now, the reason why South Carolina is important is because yesterday we heard from the expert for the prosecution, Seth Stoughton, talk about things with use of force and police tactics, and he currently is a professor in South Carolina, so that possibly could be a reason why the defense asked that specific questions. They also talked about pursuit. You know, what are the policies the officers have to follow when it comes to pursuit? He would go on to say that everything kind of changes depending on what's happening in that situation. There's no one straightforward way for someone to follow pursuit. He also says that there's really nothing focused about a passenger being in the vehicle and what to do if you are starting to pursue someone on foot. Again, that's important to bring up because yesterday the prosecution's expert, Seth Stoughton, talked about a police tactic, a poor police tactic, which was running in a foot pursuit and leaving someone who was in the car behind. He was saying that you should stay behind with that person to either gather details or let that other person get away. And Seibert here, while he's not directly saying you should not follow the other person, he says there's no direct specific policy that people have to follow. Also, he talks about split-second decisions and the mentality that comes with that. He says that it's very obvious that someone who has not been in the game very long is not going to have the mentality of someone who's been in the police law enforcement industry for a long time, but as they continue to grow, they'll be able to have better decision-making actions when they're in that type of situation. They also just talked about the use of firearms. What are their protocols when it comes to firearms, and specifically when to use them? He talks about how, according to GRPD policy, that these officers are instructed to draw them when there is a fear of safety for them or others. Also, when there is a reasonable use for to escape a felony violent crime. He also talked about how they use firearms when shooting at someone. He kind of chuckled and talked about, there's some other thoughts of what thoughts of what people think you should be doing. And he says that they're trained to stop a threat and they're trained to shoot in the upper chest or back, but obviously that doesn't always happen. And I want to ask my producer, is this okay? So this is now the proceedings. They have started, so let's take a listen in.
Sorry. And also,
Thank you, Judge.
jurors come in.
All rise for the jury, please.
Welcome back. Your name is David. And go ahead with your next question, Mr. Evans.
right. Captain Cyber, I would like to kind of walk through some of the training that Officer Schurr received and how it has been applied in this situation. Bob, can you please pull up Defendant's Exhibit B, which is the sync video with the transcript?
You're saying B as in boy.
B as in boy. Okay, and before we play the video, I just kind of, could you explain to the jury kind of some of the things that you train officers to do when conducting a traffic stop?
Yes. One of the biggest things is get radio traffic out as soon as possible, because there's a lot, as you can see in the body camera of Officer Schurr. He's got a computer by him, a radio, he's got to operate the vehicle, turn the emergency equipment on. So try to get radio traffic out as soon as possible, because pulling a traffic stop is an unknown risk. You don't know, again, you're back at that reactive point of their actions. So first thing is radio traffic. Simple as, the description of the vehicle, license plate, location you're at. If you can tell how many occupants are in it. And then activate your emergency equipment, and then approach the vehicle once it comes to a stop.
Okay. And Bob, if you could play the video, start playing the video through RFN 1246.
Nelson, Northern Briggs, Edward King Hall, 9367,
Okay, so for the record, we're stopped at RFN 1236. And kind of backing up a little bit, through when, we've talked about this a little bit, but there's no sound in the beginning. What does that mean? Why is that?
Yes, our, obviously Axon, the symbols in the top right, same manufacturer's taser, our in-car video and our body camera. So there's an automatic built-in delay of 30 seconds. So there's automatic activations. So when Officer Schurr activates his emergency lights, that activates his body camera and his in-car video, it loops back 30 seconds. So there's multiple opening the back doors, manually, or activating the gun locks, the shotgun or rifle, speed. If another officer in the area activates their equipment or their body camera, it Bluetooths into yours. So there's a multitude of factors, and that can be varied by agency, but ours is a 30-second loop. So that's why there's no sound until you see him on the radio and you can actually hear him. So it's just the 30 seconds catching back up. So that's what you see there.
And leading up to this point, was there anything that you would train officers to look for up to this point?
Yes, obviously it's 8:15 in the morning or 8:11 in the morning, so there's not a lot of traffic. It's a weekday. And as you see, if you could tell, Officer Schurr is doing a U-turn to turn and follow that vehicle. And as he's making that U-turn, you see it make a turn. And then as he turns onto that street, it turns again. So that could be a clue of they're trying to evade you or get to a driveway to pull into and quickly get into a house. Again, just possible factors that we train our officers to look for as they're affecting that or making that traffic stop.
And here, if you see at this point, when Mr. Lioya opens the door and is stepping out of the vehicle, how do you train GRPD officers, or what do you train them to do if someone jumps out of the car before the officer has had a chance to get out of his car?
Yes. It's a concern because they again, the action versus reaction. The driver is already opened the door, is getting out of the car. The officer's still on the radio or putting his vehicle in park, got to open the door to get out. Countless cases a year of officers being ambushed inside their cars as they pull a traffic stop. Happens far too often. So that's obvious the gravest concern. We try to, we show some videos of that and show statistics so they have that in the back of their mind, they understand that, and not to say that that's possible in every case, but it's a concern. They have to address that. So the driver's out of the car already, so Officer Schurr's got to hustle to get his car in park, get his car door open, and address that driver immediately. So like I talked about a little bit ago, watching the hands is the biggest concern right away to see if he's trying to access the weapon, if he's blading away, like I talked about, or hiding a side of his body because he could potentially be armed. It happens. It's one of those things that steps up your concern when somebody immediately jumps out of a car.
And what do you train officers to think about if someone does jump out of the car?
One, to get out of your car. You're not in a good spot in there because it kind of locks you in. Like I said, ambushes happen, or people close that distance and are on top of you in your car before you can get out. So get out of your car, give some verbal direction right away to try to gauge. One, then you can feel for what that situation is. Maybe it is somebody that's late to school or giving their kids a ride somewhere and they're just trying to explain it. But you got to get out, have some verbal communication with them, evaluate that situation right away. So biggest thing, get out of your car, watching the hands and the waistline area, and then have some verbal direction with them or communication with them.
And why, what manner of verbal direction do you train officers to have in this
Trying to
situation?
be firm, right? It's not the time to, good morning, my name's Captain Cyber with the Grand Rapids Police Department. They're already out of the car, they're approaching you. It can be a grave concern, so establish some type of control. Be professional, but establish firm control, verbal direction right away.
And what do you train officers to think about someone who's jumped out of the car?
Like I said, not to say every instance like this is going to be some kind of a tragic ending or you're going to be viciously assaulted or killed, but it's a possibility. So you've got to mitigate that right away. So getting out of your car, addressing them. Like I said, sometimes it's just they're being evasive. Again, you're reacting to that driver. The driver knows if what they've done or and if they have a valid license, they don't have a license, they have something in the car, they don't want you to find out. So again, far more common for people to flee right here or try to distract you enough to get you off of your preliminary investigation there.
Okay. Bob, if you could play, could you dim the lights, please? Bob, could you please play the video through RFN 1846?
Hey, stay in the car! Stay in the car! Stay in the car! Get in the car! Dude, I'm stopping you. You have a license? You have a license? What? I'm stopping you. Do you have a license? What? Do you have a driver's license? Do you speak English? Yes.
Yeah. Okay, and for the record, this is RFN 1830. Okay. So I want to walk through some of this. What do you train officers to do when they approach the vehicle in this instance where someone's jumped out of the car?
Like I said, watching the hands is the gravest concern right there to make sure they're not going to try to access a weapon. And establishing some type of verbal direction commands to gauge cooperation. Officer Schurr clearly is instructing him to stay in the car, get back in the car. He's not cooperative. And then he wants to argue why he's being stopped. Officer Schurr is trying to communicate with him, confirms he speaks English. So he closes that distance to cut off an avenue of escape. That way, if the subject tries to flee, he's much better positioned to give chase on foot.
And can you talk about, why do you train officers to ask for a driver's license?
It's just the immediate part of the traffic stop. One, to identify the subject, and then two, to establish whether they have a valid license or a license on them, because then that could lead down the path of having a reason for a valid arrest right away. So you can effect an arrest and continue that investigation.
And if someone doesn't produce a license, what do you train officers to do?
Typically, driving while unlicensed without your license, it's a misdemeanor offense in the state of Michigan, so they're going to at least be temporarily detained, if not physically arrested. So if they refuse to produce a license or they don't have one, then try to cooperatively talk them into handcuffs. If not, then you have to physically restrain them.
Okay. Bob, could you play the video to RFN 1945, please?
Can I see your license?
And for the record, this is RFN 1949. Do you observe the driver at this point doing anything when Officer Schurr asks him for a license?
Yes, when Officer Schurr asks the driver for the license, the driver reaches to, it appears his right back pocket, taps it to like, I'm gonna get it out of my wallet, and then just taps and keeps moving without producing a license. So again, those are verbal cues. We try to train our people to recognize that that's evasive or evasion, if you will, that you've asked them for the license a few times, they're not providing it, and now they're, whether they're trying to initiate a plan or what, they're trying to keep you from your direct action.
Bob, could you play through RFN 3195, please?
The plate doesn't belong on this car. Do you have a license or no? Do you have a driver's license? Where is that? Get it for me. The plate does not belong on this car. No. Stop.
Okay, and for the record, this is RFN 3213. At this point, what do you observe about Mr. Leoya?
Well, the start of the video, or start of this clip, rather, excuse me, Officer Schurr, again, asked him for his license. He opens the door and asks the passenger to find it. Again, not an uncommon thing where, again, trying to be evasive, try to distract you. Officer Schurr gives him an opportunity to produce a license. He doesn't, and he's going to, he's under arrest for driving on license or without a license, at least at this point. So he, right before the end of this, the driver starts to move towards the north of the car, which is common to, hey, I don't have a license, I know I don't have a license, I'm going to try to maybe create some distance and run, flee. So Officer Schurr grabs him by his upper arm and shoulder there, it looks like.
Okay, and this is how you train officers?
Yeah, to grab and to, limit that avenue of escape, and more times than not, just that grab and pulling their hands behind their back is enough to effect an arrest.
Bob, could you please go forward to RFN 3195? Oh, sorry. Okay, sorry, can you go forward to 3344?
Stop. Stop.
Oh, sorry, could you back up a little bit? Okay, so leading up to, and for the record, this is RFN 3344. Throughout this, can you describe what you saw here?
Yes, so the start of the clip, Officer Schurr's got a hold of the driver, and as he tries to, I assume, try to bring his arms behind his back, the driver spins, and by spinning is able to push the officer off of him, or kind of launch him, if you will, almost off of him. And then Officer Schurr goes back in to grab onto him again, and the driver actually like strikes at his hands to knock him away, and then is creating this distance here.
Okay, Bob, could you just back up like a few frames? Keep going. So you were saying, when did you see, can you just explain kind of what you're talking about with the?
Yeah, can you zoom into the top screen?
Thank you.
So you can see it appears Officer Schurr's feet are, if you go back and forward a little bit, his feet actually come off the ground. They're off the ground there. So as the driver spins and Officer Schurr's got a hold of him, he's actually off the ground. So that movement by the driver is enough to actually physically pick him up and spin him. And then he breaks his grip by actually, on the bottom screen, you can see it appears as the driver brings his right arm down. As you can see, it knocks Officer Schurr's left hand off his grab, and then he ends up hitting his own arm and knocking it off by that strike or block of the driver into Officer Schurr.
And at this point, what level of resistance would the driver be using, Mr. Lee?
Active aggression, in my opinion, by the strikes. And it went from a driving offense to now a resistant obstruct or assault on a police officer.
And what type of offenses are those?
State R&O charge is a felony. Depending on the assault on a police officer, that could be two, but not here, I would think.
Okay, and is there anything about the positioning of Mr. Leoya that you observe in this that you would train officers to look for?
Yes, so I would refer to this as an inside position. So clearly at the beginning, Officer starts with his like a chest to back position where he's behind him. That's ideal. But when we're face to face, that's a problem because then we're much closer to be assaulted. Clearly the driver can block your hands or punch your hands away. It's difficult to control a human being face to face. So ideally we want to be faced away.
Okay. All right, Bob, could you please play this through 3402? Okay, for the record, this is RFN 3415. At this point, and I guess a few frames, backing up a few frames, did you observe anything about the vehicle that Officer Schurr was driving that day?
He's got his lights activated and it's fully marked. We drive Ford Explorers, more or less sedans, so they're fully marked. It's got a full light bar on it and it's activated. And he's in a full uniform, full police uniform.
Okay. And you see Officer Schurr reaching for his radio. Oh, I guess we can play it. Bob, if you want to play the video now through 3471. And for the record, this is RFN 3477. When Officer Schurr calls out on the radio, we got one running, what does that mean? Or what does that
it's just
indicate to other
simple
officers?
radio traffic to let dispatch and other units know that you're in a foot pursuit. So again, it's imperative to get that information out because now you're separated away from our car. Our car's got a locator in it, but we don't have locators on human beings. So as Officer Schurr gets away from his cruiser, it's inherently concerning because we don't know where he is. So for accountability and manpower issues. But so he gets the radio traffic out right away. And if you, in that freeze frame in the bottom, you notice I spoke about concerns of secreted weapons or people carrying weapons between hip bones. It's kind of widely accepted in our law enforcement industry that to access that firearm, I've got to create some kind of an arm angle to access that. So on foot pursuits, commonly we see that elbow bend, and not to say that everybody is armed that we chase, but it's something that we train our officers to watch for, to be cognizant of, because it can easily turn into them accessing a firearm. And we've had numerous cases in my career have it happen. So it could be something as they're trying to keep clothing up, but it is a trained cue for our officers.
And when Officer Schurr called out that he had one running, how do you train other officers to respond to that?
So when he calls out his traffic stop, available area units will start that way, normal driving conditions, obeying traffic laws, no emergency equipment. Again, it's 8, 10, 8:15 in the morning. It was a weekday, so traffic's probably pretty congested in the east service area on the southeast side of the city. So once he calls out a foot pursuit, at least the east units should be responding emergency mode, lights and siren, if they're available. If not, other service areas, so directly to the north of that would be our south service area, and then north, central, and west. So manpower was an issue that day. We were very short-staffed. So whatever units were available should have been heading emergency fashion, lights and siren, and driving with due care and caution, but obviously exceeding the speed limit.
And why do you train the officers to respond with lights and sirens?
Because of the risk, you're fighting with someone. We know that we want more cops there than not. So to try to get people there as soon as possible. One, the cruiser's unattended. You don't know, sometimes officers end up in backyards. They don't know exactly where they are. They end up in houses sometimes as people flee into a house. So there's a multitude of reasons, but we want to get that radio traffic out right away.
And at this point, once someone is under arrest, do you train GRPD officers that they can just let them go?
No, that is not common practice.
Why not?
Because there's an inherent risk to the community. Just in this example here, if this stops, the driver has already committed a couple arrestable violations. He's fleeing on foot. We've had numerous cases of people fleeing into other people's homes, breaking into homes, outbuildings. Like I said, it's a school time of the morning. So that's just a risk to the community. That subject knows they did something that they're going to go to jail for, and they've fought with the police, and they're running away. So, and if the officer, say he gets back in his car and starts driving to find him again, there's no saying that subject can't get back in his car and drive away, right? And now we've created that jeopardy. So we train people to chase and effect an arrest.
And what do you train them to do if there is another person in the vehicle?
Be aware of it, but it's more of a risk when we're fighting around cars or struggling with people and there's 4 people in the car. Some of those things, we've had multiple instances of that, but running by a car that's occupied is not, be aware of it, but it's not a hindrance to say, don't ever do that.
And in some instances, is there any training that you provide on someone who is in this situation where they're by themselves and they have to engage in a foot pursuit?
Yes, we do multiple scenarios with that in-house, where we force the officers to run, chase the role player, and then work through the scenario.
And is there anything that would prohibit Officer Schurr from continuing to follow
No,
Mr. Leroy at this
no,
point?
we and that's why we train on it. We talk about some of the risks, right? Where people potentially are armed, following the same path, nighttime, backyards. There's a multitude of reasons, but or issues, but that's what we train to be aware of it and mitigate those as best possible.
And pursuant to GRPD policy and training, is it your opinion that Officer Schurr was reasonable in pursuing Mr. Leoya at this point in a foot chase?
Yes.
Even though there was someone else still occupied in the car?
Yes.
Could you please play the video to RFN 3555? Okay, for the record, this is RFN 3555. So what do you train officers to do once someone is actively running away?
To try to catch them, obviously. And that's with varied success sometimes, but obviously Officer Schurr catches up to the driver pretty quickly. And then it's, sometimes people give up right away when you tell them to stop. They lay down, they put their hands up. Other times we have to tackle them to the ground or push them to the ground. And clearly in this incident, Officer Schurr pushes the driver to the ground or tackles him to the ground.
And based on what Officer Schurr, or it appears that he would know at this point, just that the plates didn't match the car and the driver was starting to run away, what would you train, or I guess how do you train DRPD's officers, or what do you train them to think about with regards to the car?
It's unknown. Again, it could be a multitude of factors there. An improper plate or a plate that doesn't match the vehicle isn't in itself that uncommon, but it could be maybe the car's not reported stolen yet, or maybe they just bought it, they didn't register it yet. There's a multitude of factors there, but it's a concern and it's a valid reason for a stop.
And what do you train officers to think about the person who's running at this point?
Well, just this has continued, this path of noncompliance, and it's escalated from verbal noncompliance to failure to produce an ID, failure to produce a license. Now there's been assaultive behavior. Now they're fleeing on foot. It just continues down a path of lack of cooperation.
And Bob, can you please play the video to RFN 3373? Oh, no, sorry. 4479.
Okay. Stop! Stop! Get your hands behind your back, okay? Hands behind your back, okay? Get your hands behind your back.
Okay, and for the record, this is RFN 4479. Could you zoom in a little on the upper left, which is the dash camera, please? Okay. And could you play this to RFN 4823? Okay, so I guess, sorry, I should have asked you these before this part, but leading up to this point, what did you observe Mr. Leoya do?
So Officer Schurr tackles him to the ground and has to get his radio secured, and is struggling to try to keep him on the ground. And in these clips that we just saw, the driver is able to get back to a tabletop position, if you will, where his hands and knees are on the ground. He's in a good base, meaning it's very challenging to break that back down. And then he's able to even get back up. They go back down, he gets back up. What is striking is the continued that Officer Schurr is unable to physically control him, and he puts out radio traffic of "send me more cars," which now means everybody that's available should be coming emergency mode. So that's the whole city is coming to him because it's an emergency. He's asking for an emergency response. So he's clearly unable to control the driver. He's tried lower levels of force with the tackle, some knee strikes. He's trying to physically push him back down, and he's unable to.
And you mentioned a tabletop position. Can you explain what that is and what that means for the officer?
Yes. So a subject on their hands and knees. Think of a toddler crawling. Right. That position is what we'd refer to as a tabletop position. It's a very strong position if you don't want to be moved. You have your limbs are kind of shortened. You have all your power in an inside position. I call it. You're tight, and it's challenging to defeat that. And being like riding on somebody's back right there, if I'm trying to put all my weight on them, it's easy to roll that, or reverse that situation where the top position now becomes the bottom position, and it's a dangerous situation.
And from the last segment of the video that we just saw zoomed in, what did you observe about Mr. Lioya when he was on the ground in the prone position?
Just that he was able to get back to a standing position with relative ease, regardless of what the officer was attempting to do.
And at that point, what was Mr. Lioya's, I'm sorry, this might not be clear. Bob, could you just back up a few frames to RFN 4579? And then frame forward to 4672. If you zoom in on the dash cam. 4579 to 4672. And from this position, what did you observe?
Yeah, so that's what I'm referring to, is that tabletop position. You see the driver's on his hands and knees, and Officer Schurr is, for a lack of a better term, almost like piggybacked, right? He's just riding them. And both feet are off the ground, his hands are off the ground. He's trying to call out on his radio, so he's distracted with his one arm. He doesn't have full control. So he's calling out with his radio, and he's in a bad position because, for example, all the driver would have to do is duck his head forward and lift a little bit, and that officer's going over top of him. So then he's on his back or face down, and then the driver could easily be on top of him.
And a few frames forward, did you see Mr. Lioya on all, when you say, we talked about prone position, can you explain what that is?
Yeah, so prone, just belly down, your face down on the ground, belly down. And that's an ideal handcuffing position for us. We want to be on top while they're prone or face down. As you can see, the officer attempts that multiple times here, and the driver is successful in just standing up on his own power, regardless of the force being put on him.
Okay. And did you observe Mr. Lioya go from the ground, stomach down, and push himself all the way up?
Yes, he did that various stages through here, but yes, he does that. And that in itself is going back to the totality of the circumstances, the factors in use of force decision-making or objective reasonableness, size, strength, ability. Those are the factors. And as this progresses, exhaustion. So it's physically, it's extremely difficult to control another human being that doesn't want to be controlled. It's exhausting. So you can see that this has been going on for several seconds now, this struggle, and the officer is unsuccessful in his application of force at this point.
And at this point, what would you train an officer to look for as far as his surroundings? What would be other indicators you would train an officer to look for?
The gentleman in the white, I forget the witness's name, sorry. Is that Mr. Butler?
Mr. Butler.
He's saying something to the driver or the passenger, I forget, but he's there, so that's a concern. He's an unknown subject, whether he's going to help you or help the driver or what that situation is. And then obviously the passenger in the vehicle now is out of the car, and they're both kind of in the peripheral view of Officer Schurr. So now he's got multiple subjects. He's not able to physically control the driver that he's dealing with. So yeah, he's got to be aware and be concerned with it.
And at this point, are Officer Schurr's actions consistent with GRPD policy and training?
Yes.
Okay. Bob, if you could please play through 5-4 9408.
Stop. Stop resisting. Ain't good enough, he's in nothing.
Based on this, did you, at this point in time, have you heard Officer Schurr call for backup again?
Send me more cars, yes.
And at that point, what would you expect the responding officers in the area to do?
Respond emergency mode, so lights and siren, and get there as soon as possible, as safely as possible.
And what have you observed about Mr. Leoya's behavior during this part of the video?
The verbal, okay, is not matching his physical actions. Right? He's verbally saying okay, but there's no compliance there. It's the polar opposite. So the officer, they get to their feet, and Officer Schurr tries almost like for lack of a better term, chicken wing his arms behind him. Maybe an attempt to handcuff him, secure him, but they progress across the lawn in a kind of a southerly direction there, and then another knee strike is applied, and then it appears he tries to do some type of a takedown from where he's got him wrapped up in his upper half, and that's unsuccessful as well.
And is there anything that you observe about Officer Schurr throughout this?
Yeah, if you back up a couple frames and play it again, you can hear his heavy breathing. So it appears he's already hitting levels of exhaustion.
And what do you train officers to do once they start feeling exhausted?
Well, and we talk about this a lot, and as they first come aboard, it's kind of accepted that, hey, in 30 seconds of strenuous output, you're roughly going to have about 50% of the energy levels you started that encounter with. So if you're struggling with somebody or fighting with somebody and you start out at 100%, you're going to be greatly reduced here within 30 to 45 seconds. So we teach them to use force reasonably, but with full force initially, because we don't want these to draw out for a longer than they have to.
Why not?
Because the exhaustion level has a bunch of effects to it. It can impair your decision making. Clearly, you potentially can't defend yourself. Your tools on your belt. There's a list of factors, but yeah, exhaustion is a problem.
Okay. Bob, could you please play the video through 5548? And leading up to this point, what did you observe Mr. Leoya doing?
Still actively resisting the officer, zero compliance. And again, like I said, he's giving verbal okay, like he's going to comply, but he's not showing any compliance at this point. The officer's been unsuccessful in all of his attempts to use force up to this point. In that bottom left screen, it appears that the officer's got a hold of his sweater, like in the upper shoulder area, and his right arm is going across his body. And as we know now from watching the video multiple times, he's accessing his taser, which is we teach our officers to carry it on their non-dominant side, in a cross-draw style application, like I have mine on my left side, to avoid any type of confusion during a deadly force incident or create that where they pull their taser on accident or vice versa. So we've always dictated they carry it in a cross-draw style. So as you can see, Officer Schurr's arm is coming across his body to retrieve that. And it's of note, it takes him a few seconds to get it out. From the graduation video where he's on the dummy, he struggled and he had two hands to access that. Our old holsters at this time had a snap brake, and the snap went towards your body. So if I was leaning that way, I'm fighting against myself. if that makes sense. So it takes him a little bit of time. He's one-handed, and he's trying to hold the driver with his back, upper shoulder arm area there, his sweater, and access his taser with his right hand.
And Bob, and is there anything that you observed Mr. Leoya saying at this point?
I didn't catch that in any of my reviews because I didn't have the dictation until recently, but the get the keys part, so that is concerning because what's the plan there? Is there a weapon in the car? Was there something? So.
And Bob, could you please play the video through RFN 5649? Okay, if you could back it up just to training 5648. Okay. For the record, this is RFN 5648. At this point, what have you observed?
Excuse me. As Officer Schurr has a hold of him and he's trying to access his taser, again, going back to that reaction time, he formulates a plan in his head to grab the taser, but it takes him some time to actually accomplish that. So in that meantime, the driver spins, so now they're face to face. So you can see in the bottom left frame, Officer Schurr's got a grip of his upper sweater still, because that sweater's loose fitting and he's able to spin on him. So now he's on an inside position, and it's hard to see over Your Honor's computer screen there, but he's reaching for Officer Schurr's taser. I can't tell if he does have a hold of it.
And what does the training teach about the dangers of Mr. Leoya having a grab on the taser?
It's quite uncommon, frankly. We have a few a year maybe where there's an attempt disarm, but they're usually holstered. We've had a few incidents over the years where they swat at it to try to deflect it, but we've never had where somebody grabs onto it while it's out of the holster like that and is driving it away from themselves. So that immediately raises huge concern of that's not an attempt to swat it away. They're grabbing hold of it and potentially going to disarm you.
And what does the training teach about the dangers of having a weapon taken away?
Just that the chances are it's going to be used against you. You get disarmed of your firearm. It's the statistics are out there that it's not doesn't end well for officers. So that's the presumption. Yeah.
And how do you train officers to perceive someone who has taken their weapon?
How do you perceive them? Sorry?
Yeah. How do you train officers to, or what do you train officers to think about someone who's reached for and grabbed their weapon?
That it's potentially is going to be a deadly force assault. Again, trying to attack an officer and disarm them has escalated into the highest levels of resistance.
And what does GRPD train officers to? How are officers trained to assess threats when they're disarmed?
To fight, to retain that weapon, obviously, at all costs, and then fight to get that weapon back.
And what do you train officers to think once they're fully disarmed?
Again, that it's a deadly force encounter. That's not again, like I said, we haven't had a successful weapon disarming in long time, decades. So it happens around the country, and officers are killed yearly because of it. So it's of the greatest threat.
And what does the training teach about the intent of someone who disarms a police officer?
That you have to presume it's for the worst reasons, right? I don't have to, if I get disarmed by firearm, I don't have to wait to have it used against me. That intention alone to grab an officer's weapon is the gravest threat.
Okay. Bob, could you play the video through RFN 5770, please?
Okay.
got to be one on, bro. He's moving, man.
Okay, and at this point, what do you observe Officer Schurr doing?
So just as the frame starts, and the driver grabs hold of the taser, officer appears to do, I refer to it as like a wheel weapon retention, where he wheels it to the ground in kind of a circular motion to try to break that grip. And if you look at the bottom left screen, the grips of each, the officer and the driver there, the driver's got a dominant grip. He's got an overhand grip and his arm's locked out, and the officer's got just the handle of that, where the purchase of that taser, the majority of it is on the front of it, not the handle. So he's got a dominant grip over the officer's grip, and the officer's tried a couple weapon retention techniques and has been unsuccessful. And one set of probes is already deployed, where the officer tries to, like I explained earlier, not an ideal distance management, but he could have easily fired one set of probes, fired another set of probes, and gotten the spread that would have accomplished the neuromuscular incapacitation or lockup if he hadn't grabbed on, the driver hadn't grabbed onto the taser.
Okay, and at this point, what is Mr. Leoya doing?
He's driving that taser away from himself, and it appears towards, and they're, well, the cell phone video shows they're both traveling towards the ground.
Bob, could you play the video, please? Through, I don't know yet, but I'll tell you when to stop.
Let go of the taser.
Oh, Bob, sorry, can you stop there and back up a little bit? And zoom in on the cell phone video?
6256.
Yeah, sorry, can you back up? I missed mine.
More?
Yeah, if you can go to 5825, or if you can just zoom in and I'll tell you when to stop. If you can go a few frames back.
I can't see the RFN term.
Okay, if you can just back up and I'll tell you when to stop. Okay, stop. This is RFN 5882. And at this point, what do you observe Mr. Leoya doing with the taser?
He's still got control, or attempting to take control of it. You can see Officer Schurr has still got it in that grip that he had before. And it's pointed at the ground. You can see the LED flashlight pointing towards the ground. So now, in that position that Officer Schurr's arm in, it's an odd position, right? He's got that elbow bend going, so the driver's on his back and has, again, locked out arm, a dominant grip.
Okay, and what hand do you observe it in, Mr. Leoya's?
It appears it's his left hand.
Okay. Bob, can you play it moving forward, please? And yes, if you could stop at RFN 6220. Okay, at this point, what do you observe? Where is the taser located at this point?
It's directly into the ground. And again, similar positions. The Officer Schurr's got an odd angle arm, kind of a bent 90-degree arm angle, and the driver's got, again, still a locked out position with what appears to be a dominant grip.
And what hand do you observe the taser in Mr. Leoya's?
It appears it's his right hand now.
Okay. Okay, Bob, can you play the video, please?
What's wrong with you?
No, like he good, like you can talk to him, bro.
1915.
Yeah. Like he good, bro. Like can you talk to him like good, like can you, yeah. Stop grabbing him like that. Nah, he good at it for real. Yo, you hit him too. Now he ain't probably gonna tell you. I see.
Guys, can you stop it here? And zoom out. This is RFN 7489. And at this point, what do you observe? I know the camera went out a little bit, but what do you observe?
The biggest thing that struck me was it sounds, you can hear the stress in Officer Schurr's voice, the exhaustion. He's barely getting out commands. They're lagging, if you will, or they're drawn out because of lack of oxygen. He's breathing so heavy. The positions have switched again to be, again, the driver's in that tabletop type position. And you can see as it backs up, he rolls to that position and the officer kind of rotates to the top position again. For a brief second there, he's rocking on his back. His feet are off the ground. He's in a very unstable position, and he moves to access his firearm after a command to let go of the taser.
And Bob, if you could zoom in on the cell phone video, please. Where do you observe the taser at this point?
It appears it's in the driver's right hand.
Okay. And Bob, could you just do a frame forward from here? And I'll tell you when to stop. Sorry, you can play it, I guess. Okay. Frame forward from here. Okay, stop it here. And if you could back up for the RFN. Okay, and what did you observe here?
The struggle, the position is fluid, right? The officer's access his firearm, it's out of the holster. He's trying to maintain some type of a position on top. The driver is now turning back to the inside position, appears, where his right hip is towards the ground and he appears to be spinning into the officer. He's got control of the taser. It's in his right hand, it appears. And the officer's got his left arm kind of draped over the driver's left shoulder to try to maintain some balance.
And at this,
And another command to let go of the taser was in that clip there too.
I think it was drop the taser on that one.
Was it?
Yeah, this is where at the, like right, the last drop the taser. So this was after he had given
it's
the
dropped, sorry.
final command of drop the taser. And at this point, I guess we can just play it forward from here.
Everyone. Six in total. You just packed up, those are great. Good.
Get back!
1915. For the shooting. Penalty grade. 1915, 10-4, Nelson Briggs. Starting medical. Somebody else hit. Go to the grade, that's the door. Subject down. Nelson, head to your lead. Don't do anything. Nelson, north, grade, suspect down. 1920 at scene.
you said was your subject, the access to weapons, and what do you mean? I think that they have my taser.
Okay, stop. Okay, and for the record, this is RFN 10,181. So leading up to this point, and I know we kind of talked about this a little bit before, but in your experience, how fast can someone on the bottom reposition themselves so they are facing you or gain some sort of advantage over you?
How fast can they reverse that position? Is what you're asking?
Mm-hmm.
In a blink of an eye. That can be in a second or two.
And in high-stress, close-quarter situations like this, is it realistic to expect that an officer could stop someone from initiating or completing a full spin if that happens quickly?
I'm sorry, could you ask that one more time?
In this type of situation where it's dynamic, it's moving very quickly, is there a situation, is it realistic to expect that an officer could stop someone from initiating or completing the spin, rolling towards them?
No, in the sense too of the video, if you saw the steamy breath out of Officer Schurr, that would indicate how deep of a guttural breathing he's trying to accomplish there. So at that level of exhaustion, no, I don't believe he could have prevented that situation from spinning in a second or two.
In your opinion, based on your training and experience, does the threat from the bottom position ever end until they're fully controlled?
No.
And based on everything we've reviewed, do you have an opinion on whether an objectively reasonable GRPD officer in Officer Schurr's situation would have been in fear of a serious bodily injury or death when Mr. Leoya started getting up off the ground with his taser in his hand?
I do.
And what is that opinion?
That it was reasonable, that a reasonable officer could perform the same way in that situation.
Thank you. No further questions this time.
Back here. I just want to start out with one of your statements. Your statement was the GRPD is trained to chase and effect an arrest. That's what you just told the jury, correct?
That's a common practice, yes.
Those were your words. Those are your exact words. I wrote it down. Trained to chase and effect an arrest.
Do we train? Yeah, we train our officers to do that, yes. That's an expectation, yes.
But when we were notified you're a witness, you talked to Detective Tubergen, didn't you?
Yeah, I did.
You said there's no foot pursuit policy.
There's not a foot pursuit policy, correct?
But you trained them to effect an arrest.
Yes.
Now, this has been pending for like 3 years. Did you prepare this?
I did.
You typed it?
The affidavit?
Yes.
No.
Who typed it?
The defense.
So the defense. So the defense typed it. So
Yes.
you've been how many times have you met with the defense over the course of the last 3 years?
Probably 5, 6 times.
And you've had access to some of their videos as well. So you've gone over this case with them 5 or 6 times?
I did not have access to the video until now. I haven't seen it until this week.
We
I mean, the video I had access to was Axon, the body camera, the cell phone camera, not the forensic video.
But this week you said the one with the writing on it, you said you had access to it, you watched it earlier this week.
I saw it, yeah, this week, yes, not before this week.
So this is one of the biggest events in Grand Rapids in probably your career, isn't it?
It is.
And you don't bother to do a report?
I did an incident report.
An expert report. You have access to our expert reports, haven't you?
Your expert reports?
Correct.
Yes.
So you read our expert reports. It's like a 56-page report.
It is.
You're brought up as an expert for the defense. You're their expert, you have at least their degree, GRPD policy, and you produce a 2-page affidavit.
Yes.
Even in that affidavit, you don't say anything about training to chase officers or to effect an arrest. You don't say that in this affidavit, do you?
No.
You say includes training on solo foot pursuits, such as drills and scenario-based training, GRPD does not prohibit officers from chasing a fleeing suspect.
Correct.
That's different than you train them to apprehend a fleeing suspect, isn't it?
The solo foot pursuit drills will end in an arrest.
Prohibiting and training positively are two different things, aren't they?
Yes.
Where is that policy? Where is the written policy where you train to effectuate an arrest? We spent an hour and a half here looking at all the policies. Where is the written policy where you effect an arrest? You train your officer to effectuate an arrest?
Off of foot pursuit?
Yes.
We don't have one.
You don't have one. But that's your testimony now, suddenly in front of this jury, that, yep, we trained to that.
Objection, Your Honor. This is argumentative, and if he wants me to go through the mandatory training, I will gladly do that, but.
I think he's not cross-examining him. So which part? I mean,
The fact that he's trying to portray that there's no training or policies. I did not walk him through, and if you'd like me to walk through this, I will gladly go through all this, but I'm trying to speed it up.
I'm gonna overrule the objection, and you obviously will be able to redirect, and you can certainly point out what you'd like, but I don't believe that last question was argumentative. So.
I mean, you had an hour and a half to present the policy, and we didn't see any policy. These are the policies that were provided. These are the training policies for Officer Schurr.
These are training outlines. These are policies, yes.
Okay. Where? Point it out. Where is it?
His recruit class one is in here? Is that in here?
There's recruit class. We've got everything.
Okay. His recruit class is 15-3. These are, this is 21,
These are the training documents we have.
He has a recruit class book of 15-3. We, not being argumentative, we train in foot pursuits, we do solo foot pursuit drills. We don't have a policy that mandates, but we don't have a policy that prohibits it.
So it doesn't mandate. You said you train to chase and effect an arrest. It doesn't mandate. It means that basically they can chase based on the circumstances, right?
Yes.
All right, that's a bit different than they just run. You don't train them to be greyhounds chasing after rabbits, then, right?
Correct.
It's based on the total facts and circumstances.
Yes.
So if somebody's driving down the road and guy's got a gun in the car, passenger's got a gun in the car, driver flees, you're not going to chase the driver. You're going to stay with the passenger, right?
Potentially.
Potentially?
Do we know if he's got a gun? Do you see the gun?
I just said the passenger's got a gun. Passenger's got a gun, driver flees. You're going to have your officer stay with the guy with the gun, aren't you?
Yes.
Okay, well, that's based on the totality of the circumstances. Then that's a little bit different than what you testified to, right?
That situation's completely different.
Sure. So it's based on the totality of the circumstances, just like we've been talking about. All those policies up there, the totality of the circumstances controls, not just you're trying to have an officer just chase anybody that runs down the road.
Yes.
So one of the things we do talk about, and were you in here for former Sergeant Johnston's testimony?
I was not.
You weren't. Well, one of the things he testified to, and he said one of the things that Grand Rapids is very specific on, is every traffic stop is an unknown risk.
That's correct.
Okay? You don't know what you're going into when you get into a traffic stop. Anything can happen, right?
Yes.
And one of the concerns Grand Rapids Police has is guns in the car.
Correct.
Guns are, guns on people in the car?
Mm-hmm.
Sandy, yes.
Yes, sorry.
Guns under the seat?
Yes.
Guns anywhere in the car?
Correct.
So when you pull somebody over, you gotta be worried about a gun if you don't know about it.
Potentially, yes.
So every person in the car potentially has a gun.
Correct.
Let the record reflect on showing opposing counsel we marked as People's Exhibit 36 for identification purposes. Captain, I'm going to show you what we marked as Exhibit 36 for identification purposes. Do you recognize that?
I do.
Could you tell the jury what that is?
This is a mandatory training, 19-2. 19 means 2019 was the year we performed this, and 02 would mean it's early in the year, the second training of the year. So it's a firearms training outline.
Okay. And so this is, we have a number of training documents where you go through mandatory training for your officers, correct?
Yes.
And this would be training that we've received for the defendant that he took in 2019.
Correct.
And his signature's on that.
Yeah, sign in, yep, sign in right here.
I would move for the admission of people to Exhibit 36, Your Honor.
No objection. Okay, and 36 is not admitted.
Looking, I believe it's gonna be 1, 2, 3, 4, page 5. The one thing I did find regarding foot pursuits is there a Seattle officer-involved shooting?
Yes.
There's a Seattle officer-involved shooting, and in your foot pursuit, what it talks about there is allow for a safe distance and have a plan while chasing an armed or potentially armed subject. Treat someone you pull over as potentially armed. Isn't that what it says?
It does, yes.
So that's the one thing we could find on foot pursuits is that somebody could be potentially armed. You don't go chasing after them because they could be armed. It's for officer safety, right?
It says allow a safe distance.
Okay.
Have a plan while chasing armed or potentially armed. So
Going
we're still chasing.
hands-on or tackling someone who is known to be armed is bad tactics.
I would agree.
That's what's in the training policy.
That's in the training outline, yes.
Training outline, but that's the outline. That's what you're telling your officers. That's what the defendant would have learned back in 2019.
Yeah, this specific training, correct.
One of the things he also talks about is maybe discontinue with the foot chase and set a perimeter.
Potentially, yes.
So officers are perfectly fine in discontinuing, not chasing after, not mandatorily running after them, correct?
Correct.
In terms, staying with this foot pursuit policy, you are familiar with the International Chiefs of Police, correct?
I am, yes.
The International Chiefs of Police, you're a member of it.
I am.
Your chief's a member of it.
He is.
Both deputy chiefs are a member of it.
They are.
And so they have a foot pursuit policy that they've come up with, correct?
They do, yes.
2019, July of 2019, they came up with a foot pursuit policy, a model, if you will.
Yes.
In that model, don't they say that chasing officer individually chasing a suspect is inherently dangerous?
That's what it says. It does.
You
I'm not.
read it?
I'm not exactly familiar with the verbiage of it, but I'll take your word for it, sir.
You know, I looked through it.
Is that an exhibit or just something that you?
Well, not exhibit at this point in time. If he's not familiar with it, let him read it.
Your Honor, I would object to that, that's hearsay.
What?
That
I don't even
document
know,
is-
wait, so it's not he's not moving for its admission, he's showing a document to the witness. So, I'm not sure, what is that document?
This is a model foot pursuit policy from the International Chiefs of Police. So you're familiar with it, but you've never read it?
We don't have one, so no, I don't. I didn't. I've read it before, but it's been years. It's been out for 5 years, 6 years. So.
Well, I guess you've read it. Why haven't you done anything with it? You're the trained. Why hasn't Grand Rapids adopted it?
The direction of the agency, we don't want a foot pursuit policy.
You don't want a foot pursuit policy.
Correct.
But you would agree that the International Chiefs of Police saying they're inherently dangerous, correct?
Yes, they do.
Would you disagree that they're inherently dangerous?
No.
Would you disagree with their recommendation that at least 2 officers be involved in a foot pursuit?
Ideally.
Ideally, but they say that's what you should do. Of course, you don't know because you haven't fully read it. Are you familiar with Police Magazine?
I am.
Okay, Police Magazine.
Your Honor, I would just object to relevance.
Learn treaties, Your Honor. We can impeach with learn treaties under the Michigan Rules of Evidence
The Police
707.
magazine is not a learned treatise.
He can, if he understands it, what it is, he says he uses it, it doesn't have to be
I didn't say I use it. I said I'm familiar with it.
You don't read it?
I don't read the magazine regularly. I'm familiar with it.
Your Honor, how is this relevant? We're here to talk about
Well,
mission.
if it's impeachment, is that a learned treatise? I don't know that it is.
Police magazine?
It's something that the police, we heard yesterday, police, you were here for the testimony of our experts. They rely on it, correct?
They said they did, yes.
You don't ever read police magazine?
I didn't say I don't read it. I said we don't rely on it for policy advisement or direction.
Don't rely on it for direction. So you just do your own thing then? You don't rely on the international chiefs of police?
I'm sorry, I need to rule of the objection, but I did want to check MRE 707.
707.
Which does allow for the use of learned treatises for impeachment, which includes statements contained in published periodicals or pamphlets. It doesn't have to be in the textbook, so I will overrule the objection under that rule for impeachment purposes only.
So police magazine, foot pursuits by their very nature are emotionally charged and dangerous events that occur frequently in police work. You'd agree with that, wouldn't you?
I would.
Law enforcement officers must balance their obligation to enforce the law and arrest perpetrators with their personal safety. You'd agree with that.
It's fair.
Unfortunately, that rarely happens. Would you agree with that?
Yes.
More often than not, officers become emotionally captivated by the event and have an instinctive reaction rather than a studied and planned response to resistance and chase without considering the inevitability of suspect capture. Would you agree with that?
It's possible, yes.
Possible. But that's one of the dangers of somebody's running away, they want to get away, and you rush off and tackle them by yourself. All of a sudden, you got your hands full and you're not aware of it. You're not aware of what could happen next.
Potentially.
And that's one of the things that you teach in Grand Rapids Police in terms of the reactionary gap.
Yes.
Right? So a reactionary gap is the further away somebody is, the better off you are in essence, because you have an opportunity to respond. Is that a fair, I'm not.
Sure, at times in a situation, yes.
Situation. But as soon as you chase somebody and tackle them, you close that reactionary gap.
Yes.
And that kind of goes back to the 2019 outline of the foot pursuit thing, that if somebody's potentially armed, all of a sudden you tackle somebody that's potentially armed, you could be in a world of hurt, right?
Correct.
Okay.
Because of the time, I'm not sure how much further you have, we do have redirect as well, so.
Yep.
What we'll do is we'll break for the day, because it's 4:45, and so again, please leave your notes upside down in your chairs, and remember that you're not to discuss the case at all with each other or with anyone else. Also, continue to avoid any news reports in the media and in social media. And what we'll do is return and resume testimony tomorrow morning at 8:30.
Not this time, right? I'm sorry, I thought you said anything further, I'm sorry. I thought I heard you.
Okay, so what we're gonna do is recess for the evening. Is there anything we need to address before we recess?
Nothing from you.
Okay.
After that offense.
I do want to state for the record that there was a question that a juror asked that was not asked. And it really wasn't a question. I did say on the record that it wasn't a question. The juror was simply pointing out that there was an exhibit still on the witness stand. Didn't know if it mattered. So it wasn't really a question, but I did want to place on the record because it was clear on the record that a juror did have a question and it was never addressed on the record. So there's that. And if there's nothing else, thank you very much for this now.
Thank you, Your Honor.
And the court will be in recess until tomorrow morning at 8:30.
just tuning in, we're wrapping up day 3 of the trial of Christopher Schurr. We saw a lot today, including not only a motion for a mistrial, but also a directed verdict, both of those denied. We also saw the prosecution rest their case and the defense begin their case with their first set of witnesses. Now, we're not over with our coverage. We're breaking down everything during our evening shows and on Evening Plus. Tune in for more.